जस्ट ए जेंटल रिमाइंडर लेडीज़ एंड जेंटलमैन, आप सभी से रिक्वेस्ट है आप प्लीज़ बैठ जाएं, सीट्स ले लें अपनी अपनी, जो बैठने के जो अरेंजमेंट्स हैं उसके हिसाब से, इनक्लोजर्स के हिसाब से, और अपने मोबाइल फ़ोन आप साइलेंट मोड पर ज़रूर कर लें. प्लीज़ इंश्योर दैट योर मोबाइल फ़ोन्स आर ऑन साइलेंट मोड. अगर स्विच ऑफ कर लें तो और भी अच्छा होगा, लेकिन अगर कोई मजबूरी है तो साइलेंट मोड पर ज़रूर कर लें. इंश्योर कर लें इसको, क्योंकि प्रोग्राम के दौरान किसी तरह का कोई डिस्टर्बेंस ना हो, इसके लिए ये बहुत ज़रूरी है. हॉल के बाहर जो लोग हैं उनसे भी मैं रिक्वेस्ट करूंगा कि वो भी आकर अपनी जगह ले लें एज अर्ली एज पॉसिबल. Please take your seats as early as possible, ladies and gentlemen. ऑनरेबल चीफ जस्टिस ऑफ इंडिया हम सब के बीच यहाँ पहुँचने वाले हैं ऑडिटोरियम में, इसलिए आप सभी से मैं रिक्वेस्ट करूँगा कि आप सभी अपनी अपनी जगह ले लें, मोबाइल फ़ोन अपना स्विच ऑफ कर लें या कम से कम साइलेंट मोड पर ज़रूर कर लें. प्लीज़ इंश्योर दैट योर मोबाइल फ़ोन्स आर ऑन साइलेंट मोड एट लिस्ट. आप सभी से रिक्वेस्ट है, जो भी बैठने के जो इनक्लोजर्स बने हुए हैं अलग अलग, उसके हिसाब से आप सभी अपनी अपनी जगह ले लें. गैलरी में प्लीज़ खड़े ना हो, आप प्लीज़ जगह ले लें. देवियों सज्जनों, भारत के माननीय मुख्य न्यायाधीश ऑनरेबल डॉक्टर जस्टिस डी.वाई. चंद्रचूड़ साहब, आप सभी से मैं ये रिक्वेस्ट करूंगा ज़रूर कि आप सभी अभी अपने स्थान पर ही खड़े रहें, क्योंकि इस इनॉग्रल सेशन का शुभारंभ जो है वो राष्ट्रगान से होगा। आप सभी से मैं रिक्वेस्ट करूंगा कि आप सभी नेशनल एंथम के लिए अपने अपने स्थान पर खड़े रहें।
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे, तव शुभ आशीष मांगे। गाहे तव जय गाथा, जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
बहुत बहुत आभार आप सभी का। प्लीज टेक योर सीट्स। नमस्कार, गुड मॉर्निंग लेडीज एंड जेंटलमैन। ऑन बिहाफ ऑफ द डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, गवर्नमेंट ऑफ इंडिया, we extend our heartiest welcome to all the dignitaries, luminaries and guests in this one-day conference on India's progressive path in the administration of criminal justice system. It is our proud privilege to welcome the Chief Justice of India, Honorable Dr. Justice D.Y. Chandrachud, who is gracing the occasion as chief guest in this inaugural session. आपकी करतल ध्वनि के साथ बहुत बहुत अभिनंदन वंदन ऑनरेबल चीफ जस्टिस ऑफ इंडिया का। कॉन्फ्रेंस के इस इनॉग्रल सेशन में मंच पर गरिमामयी उपस्थिति है केंद्रीय विधि एवं न्याय राज्य मंत्री स्वतंत्र प्रभार श्री अर्जुन राम मेघवाल जी की। उनका भी स्वागत अभिनंदन इस अवसर पर। साथ ही यहाँ मंच पर विराजमान है लंदन अटॉर्नी जनरल ऑफ इंडिया श्री आर वेंकटरामनी जी, बहुत बहुत अभिनंदन वंदन। लंदन सॉलिसिटर जनरल ऑफ इंडिया श्री तुषार मेहता जी, डिपार्टमेंट ऑफ जस्टिस के सेक्रेटरी श्री S.K. चिराहाटे जी, डिपार्टमेंट ऑफ लीगल अफेयर्स के सेक्रेटरी डॉक्टर राजीव मणि जी और एडिशनल सेक्रेटरी डॉक्टर अंजू राठी राणा जी, और ऑडिटोरियम में सभागार में उपस्थित सभी गणमान्य विभूतियों का, अतिथियों का हम बहुत बहुत स्वागत अभिनंदन करते हैं इस उद्घाटन सत्र में जो एक दिन के कॉन्फ्रेंस का है। मैं निवेदन करूंगा आज के ऑनरेबल चीफ गेस्ट, ऑनरेबल चीफ जस्टिस ऑफ इंडिया और अन्य सभी गणमान्य विभूतियों से कि वे ट्रेडिशनल लैंप लाइटिंग के लिए पधारें, दीप प्रज्वलन के लिए पधारें और दीप प्रज्वलन के साथ इस इनॉग्रल सेशन का शुभारंभ हो, जैसे कि हमारी परंपरा, हमारे संस्कार और हमारी संस्कृति है। देवियों सज्जनों, हम सब जानते हैं कि एक सभ्य समाज का, एक सिविलाइज्ड सोसाइटी का जो बेस है, आधार है, वो इसका विधि और न्याय सम्मत होना है। और इसके लिए ये भी आवश्यक है कि देश का जो कानून है, न्याय व्यवस्था है, देश के आम जन के, कॉमन मैन की जो लोगों के एस्पिरेशंस है, उनके एम्बिशंस है, उनकी आवश्यकताएं हैं, उनके अपेक्षाएं हैं, उस पर खरा उतरता हो। देश में आगामी 1 जुलाई से जो लागू होने जा रहे 3 नए क्रिमिनल लॉज देश में क्रिमिनल जस्टिस सिस्टम को एक नया स्वदेशी
of its criminal justice system. India's legal landscape has witnessed transformative changes. The winds of change blow strong as we stand on the cusp of a historic transition. The enactment of the three new criminal laws, the Bharatiya Nyaya Sanhita 2023, replacing the Indian Penal Code 1860, Bharatiya Nagarik Suraksha Sanhita 2023, replacing the Code of Criminal Procedure 1973, and Bharatiya Sakshya Adhiniyam 2023, replacing the Indian Evidence Act 1872, heralds a new dawn in our quest for justice. These legislative milestones are set to replace outdated colonial laws, symbolize our unwavering commitment to adapt and evolve with the ever-changing dynamics of our society. Enacted in December 2023, these new laws are poised to reshape the criminal justice system, set to take effect from July 1, 2024. These reforms reflect India's commitment to modernizing its legal framework, enhancing efficiency, and ensuring justice to all. It is a moment of reflection, of introspection, and of anticipation for the possibilities that lie ahead as we endeavor to build a criminal justice system that is not just reactive but proactive, not just punitive but rehabilitative, not just exclusive but inclusive. Today, as we gather to unravel the intricacies of these legislative reforms, let us remind ourselves of the core objectives that underpin our efforts. Our aim is not merely to enact laws, but to ensure their effective implementation. Our goal is not simply to punish the wrongdoing, but to prevent it. Our mission is not only to uphold the rule of law, but to safeguard the rights and dignity of every individual. In the pursuit of these, but a tangible reality, where the scales of justice are not tipped by bias or prejudice, but by fairness and equality. As we embark on this transformative journey, let us embrace the spirit of collaboration, innovation, and empathy. Let us pledge to work hand in hand, shoulder to shoulder, towards the realization of a shared vision, a vision of a more just, more compassionate, and a more progressive India. With that, I extend my heartfelt gratitude to each and every one of you for your presence here today. May our deliberations be fruitful, our discussions enlightening, and our resolve unwavering. Thank you, and have a wonderful day ahead. Thank you.
थैंक यू डॉक्टर अंजुरा ठिराना जी। देवी सज्जनों, आज़ादी के पहले से आप कह सकते हैं 100-150 वर्षों से भी अधिक समय से जो क्रिमिनल लॉज हैं उसमें बदलाव की मांग उतनी ही पुरानी है जितनी कि देश की आज़ादी है। और डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस ने सभी स्टेक होल्डर्स के साथ बहुत गहन चर्चाओं के बाद इससे मूर्त रूप दिया, जो राष्ट्रपति महोदय के हस्ताक्षर के बाद अब कानून और अधिनियम का रूप ले चुके हैं। मैं निवेदन करूंगा डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस के सेक्रेटरी डॉक्टर राजीव मणि जी से कि वे इस बहुत ही महत्वपूर्ण कॉन्फ्रेंस के इनॉग्रल सेशन में इन कानूनों को लेकर जो उनके अपने एक्सपीरियंस और अपने उद्गार हैं वो आपके साथ शेयर करें। डॉक्टर राजीव मणि।
Respected Chief Guest of today's conference, Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, Honorable Judges of the Supreme Court, former and sitting and former, Shri Arjun Ram Meghwalji, Honorable Minister of State, Independent Charge, Ministry of Law and Justice, Shri R. Venkat Ramani ji, Learned Attorney General for India, Honorable Judges of the High Courts, Shri Tushar Mehta ji, Learned Solicitor General of India, Shri Ajay Kumar Bhalla ji, Home Secretary, who could not come. Previous speaker, I would just like to recall that the background of the same flows from the speech which the Honorable Prime Minister had given from the ramparts of the Red Fort about 2 years back about the Panch Pran of the Amrit Kal. And one of them was to take pride in our roots and to remove any trace of colonial mindset. The conference today encompasses the thread which has been left by the Prime Minister, and we take it forward as far as the reformation in the criminal laws administration justice system is concerned in the country. We had a rich ancient legal system, which of course the Shruti and the Smritis were the primary sources of law. Over a period of time, when the Mughals came, the law was based on religious practices of the ruling powers and of course of the other communities. But with the advent of the Britishers in India and the colonization of the country, the new system of codified law had come into being. And what I would like to emphasize here is the fact that the codification of the laws done by the Britishers was in fact for their own benefit. Just to recall the philosophy which actually guided the British, though they are a very law-abiding society, they claim to be the propagators of the rule of law. But as it is pertinent to recall that Dadabhai Naoroji, in his book, Poverty and Un-British Rule in India, which was published in 1901, he emphasized the fact that the British policies were just formulated to see that the wealth of India could be extracted to finance British industries. And that led to, the great detriment of the Indians, and of course, the downfall of the Indian industry, the local industry, and other things. In fact, recently in 2018 also, there has been a research which has been published in the Columbia Law Review by one researcher, Usha Patnaik, and she has concluded that over a period of time of almost 200 years, from 1765 to 1938, the Britishers actually took away $45 trillion from the Indian economy and took it for their own use. This is in fact almost 17 times of the present GDP of Britain. So you can imagine the rule of law in the manner in which was established by the Britishers to serve their own needs. The Britishers codified the law in terms of rationalization in the Weberian sense to ensure order, certainty, and uniformity. However, the elements of colonial rule applied by Britain to its former colonies included control over land, divide and rule, apartheid laws, and just heaping discrimination on the native population. In fact, the original Code of Criminal Procedure of 1862 separated jurisdiction of the judges along the racial lines. The Indian Press Act, the Prevention of Seditious Meetings Act, the Rowlatt Act, and the Public Safety Bill were all, in fact, formulated to help the British tighten their grip over India and put the Indian freedom fighters in prison and to the distress of the native population. These laws, in fact, gave vast powers that helped British perpetuate the structural violence against the native population. Though the British codification was to justify what the British would say that it is a guarantee of rule of law and justice, yet in reality, these laws were used to discriminate between Indians and Europeans. We cannot forget that the existing criminal laws define the state-citizen relationship based on the colonial prejudices and practices. The British had introduced the criminal codes in the aftermath of the 1857 War of Independence to exercise their authority over Indians whom they condemned as an inferior race. These laws, primarily based on the legislative on the state action, is justified on the theory of retribution and is preoccupied with the need of imprisonment. In fact, the same theory also perpetuated in some other laws after independence, and an imprisonment was prescribed for various non-compliance of procedures and irregularities of minor nature. The Jan Vishwas Act 2023, which has been enacted last year, has in fact decriminalized 183 provisions of 42 central acts administered by 19 ministries and departments. The whole idea is to limit the people and limit the curbs on the people and the businesses and to reduce compliance in order to achieve the goal of Viksit Bharat. The Amrit Kal of independent India has provided this opportunity to us to do away with the bygone mindset. As a result of this, many minor offenses have been decriminalized. The present change, that is from a Danda Prakriya to Nyaya Vyavastha, is a testimony of the same exercise. The key forces which in fact are guiding the legislative department also in this process is the simplification of the procedure, the simplification of laws related to applications, etc., etc. Rationalization of the legal provisions by repealing, amending, and omitting of redundant laws. In fact, since the last 10 years, 1562 laws have been repealed by the parliament. Digitization of government process is another important step in this direction, which is to help the ease of processes, and decriminalization of minor technical and procedural defaults. So the whole ecosystem is actually to promote the Indian mindset and to get away from the colonial mindset, which was evolved and established to serve the colonial masters. India has a rich heritage. We can draw from our ancient heritage and legacy to administer the country in the right manner, in the manner in which our ancestors had devised for the next many, many years. I take this opportunity to thank all the participants who have taken their valuable time, to come to us out of their very busy schedule and bless us with their very presence. आप सभी का हृदय से बहुत बहुत आभार. धन्यवाद. जय हिंद.
बहुत बहुत आभार डॉक्टर राजीव मणि जी का. May I now request the Secretary, Department of Justice, Ministry of Law and Justice, Shri S.K. Chirahate Sahab, for his address, please. Shri S.K. Chirahate.
Honorable the Chief Justice of India, Dr. Justice D.Y. Chandrachud ji, Honorable Minister of State, Independent Charge, Law and Justice, Shri Arjun Ram Meghwal ji, Learned Attorney General of India, Shri R. Venkatramani ji, Honorable Judges present and former of Supreme Court and High Court, Learned Solicitor General of India, Shri Tushar Mehta ji, Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Director CBI, Director ED, Director Indian Law Institute, senior officials of CBI, ED, and Delhi Police, senior law officials, officials from the Department of Legal Affairs, Legislative Department, Department of Justice, and Ministry of Home Affairs, ladies and gentlemen. It is indeed a great privilege to participate in today's conference on India's progressive path in the administration of criminal justice system. As we all know, Ministry of Home Affairs, Government of India, after a very comprehensive review of the colonial era criminal laws, that is IPC, CRPC, Evidence Act, and after extensive consultation with all stakeholders and legal experts, has drafted the new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam, which were passed by the Parliament in December 2023 and subsequently notified. Also, the date of its commencement is now fixed as 1st July 2024. In fact, the enactment of these laws acknowledges the fact that the evolving nature of crime in the present times, particularly the cyber and advanced economic crimes, as well as other heinous body crimes, require the law to adapt to these modern challenges, and thus a long overdue overhauling of criminal laws was undertaken and successfully completed by MHA. This reflects the deep-seated commitment of the government to strengthen the law and order mechanism, simplification of legal processes and procedures, enhancing the efficiency and transparency of the criminal justice system, and ensuring access to justice for all citizens. In the context of this latest criminal laws, what would be the role of Department of Justice is what I would like to share with you today. The mandate of Department of Justice is to facilitate the administration of justice in order to make the justice delivery system more efficient, more accessible, more transparent, and with a citizen-centric focus. The Department of Justice is taking several initiatives. One such is the implementation of the e-courts project for the computerization and ICT enablement of district courts in close association and guidance of E-Committee of Supreme Court of India. Presently, the e-court phase 3 project with an ambitious outlay of rupees 7,210 crore is under implementation. You would be happy to know that the entire phase 3 e-court project has been conceptualized, designed, and its DPR formulated by none other than the Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud ji himself. Phase 3 e-courts project is envisaged as the next higher digital and IT empowerment of Indian court system. It aims to usher in a regime of end-to-end digital, online, and paperless courts through digitization of the entire court records, including legacy records, and through universalization of e-filing and e-payments by saturating all court complexes with one-stop shop free of cost for e-services for the common citizens in the form of e-Seva Kendras. It will put in place intelligent smart systems enabling database decision-making for judges and registries while scheduling and prioritizing cases. It will create a unified technology platform for the judiciary which will provide a seamless and paperless interface between the courts, the litigants, and other stakeholders. E-Court Phase 3 includes several components employing latest emerging technologies like machine learning, blockchain, artificial intelligence that will change the entire landscape of the Indian courts. In fact, a very important component of Phase 3 is the integration of ICGS, Interoperable Criminal Justice System, with the e-courts for enhancing the efficiency and transparency of the criminal justice system. It is well known that the ICJS project of Ministry of Home Affairs has brought on one platform the different pillars of crime investigation and criminal justice system, like police, prison, prosecution, and forensic laboratories. Once ICJS is integrated with e-courts, then there will be a seamless flow of digital data and documents between police and courts, like FIR, charge sheet, case diary, summons, warrants, as well as there will be real-time update of the criminal trials with evidence being taken in the digital form. This will reduce delays and ease the entire criminal justice system. The 3 new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam, incorporates several electronic features now in the crime investigation and trial, like issue of summons in electronic form by the courts, production of electronic communication as evidence, videography of search and seizure, lodging complaints through e-FIRs, definition of documents expanded to include electronic or digital records, evidence to include any information given electronically. All this would be facilitated now through integration of ICGS with e-courts. I am happy to inform you that Department of Justice and Ministry of Home Affairs, under the guidance of Honorable the Chief Justice of India, has already taken measures for the said integration. Actually, a pilot project has been initiated in Khandwa district of Madhya Pradesh for developing a protocol of electronic flow of summons, processes, as well as e-FIR, charge sheet, case diary. This has been successfully completed and is now being replicated in other districts of Madhya Pradesh, based on which a standard protocol would be framed for replicating in all states of the country. Further, a pilot project in Rajasthan has also been initiated to undertake all processes before the issue of charge sheet, like bail, police custody, submission of case diaries before the court in electronic format. The same would be e-signed using e-Hastakshar and DSC. This serves to speed up the entire process drastically, as well as avoid errors during manual data entry. In the context of the new criminal laws, Honorable the Chief Justice of India has formed a core committee headed by a Honorable Judge of Madhya Pradesh High Court, Justice Sanjeev Khalgaonkar-ji, to work on the alignment and streamlining of the ongoing ICGS and e-courts integration with the various provisions of the new criminal laws. The core committee also comprises of officials of Department of Justice, E-Committee of Supreme Court, MHA, NCRB, and BPRD. The core committee has already held 3 meetings, and it is expected that the entire exercise would be completed well in time. In conclusion, the interoperable criminal justice system and the introduction of new criminal laws represent significant milestones in our journey towards a more just, more easy, and a more equitable criminal justice system. By harnessing the power of technology and embracing progressive legal reforms, we are laying the foundation for a justice system that is efficient, transparent, and accessible to all. As we move forward, let us continue to work together to ensure that the promise of justice is fulfilled for every individual, regardless of their circumstances. Thank you. Jai Hind.
Thank you very much, Shri S.K. Chirahati Sahab, Honorable Secretary, Department of Justice, Ministry of Law and Justice, Government of India. Ladies and gentlemen, not only the country's but the world's leading counsel, learned Solicitor General of India, Shri Tushar Mehta ji, he is here with us on this occasion. I will request him to give his address on this occasion. Shri Tushar Mehta ji.
Good morning, everyone. Honorable Dr. Justice D.Y. Chandrachud Sahab, our iconic Chief Justice of India, Shri Meghwal ji, our vibrant Law Minister, our scholarly Attorney General, Shri Venkat Ramani ji, Shri Rajiv Mani ji, Anju ji, Dr. Rahate ji, my colleagues, Aishwarya Bhati ji, and Venkat Raman, Chetan Sharma, Director CBI, Director ED, all officials, honorable judges, and friends. Friends, in history of any nation, a time comes where you have to shift from old to new. Before independence, we were governed by the laws which were meant to rule us and not to give us the rule of law. We inherited that law and series of other laws in 1947, and the country was craving, country was demanding and expecting that now there would be a Indianized version which, from the regime of punishment to the regime of justice, there would be a shift. But every revolution needs a particular time where several things comes together. We have a very vibrant and efficient decision maker as a Prime Minister. We have a very bold and intelligent Home Minister, a very vibrant Law Minister, and above all, the will of the people to make this change which was ready to happen since 70 plus years. It is that change which the Parliament brought and shifted the regime from punishment of those who are ruled to the justice of those who are citizens of India, who have given to themselves the Constitution of India. Friends, there are several new aspects which, of course, the very, very learned persons who are participating in the panel discussion would highlight. But to me, I would wish to highlight 2 or 3 very important changes in the regime, in the legislation, and in the way India thinks in the present era. I would like to highlight them. First, now we are in the digital era under the very able leadership of the Honorable Chief Justice of India, the judiciary, the judicial infrastructure, and even lawyers are shifting to the digitization and digital mode of dispensation of justice. For the first time, now the digital testimony of a witness is accepted to be a valid testimony. So now there is no necessity of people traveling all along from various parts of the country or the state to depose. This is a revolutionary change which was waiting to happen, waiting for a committed government who is committed to reform to bring it as a part of its legislation. Now, electronic mode is permissible in all criminal proceedings. Second, the problem which this country was facing was that those who were criminals, or at least facing criminal allegations, used to either flee the country or they used to go somewhere hiding, and the courts were helpless because there was no provision, and they were declared absconders. For the first time now, the Indian law provides that after a person who evades the process of law and is declared by the court to be an absconder, the court can proceed against him and even pass a sentence of conviction in his absence. This is a landmark change which we as a nation could achieve. People were facing one more difficulty, and this is where the role of the parliament comes. Parliament ultimately, across party lines, consists of representatives of the people, and the representatives have the pulse of the people. They know the day-to-day problems the people are facing. One of the main problems a common man was facing was a crime is committed, either with me, or I have been witnessing a crime, or I came to know about a crime and I want to get it registered. When I go to a police station, the police station would say, this is not within my jurisdiction, I will not register an FIR. And under the old law, that was permissible defense for the police. For the first time, by a statutory mechanism, there is a provision of a mandatory requirement of what is called zero FIR, meaning thereby, even if I go to a nearest police station having no jurisdiction, it is their responsibility to register a zero FIR and transfer it to a police station having the jurisdiction. Now, a common man of this country will not be told by any police station that we have no jurisdiction. They will have to register the FIR. One more problem which every criminal lawyer practicing on prosecution side or on the defense side or others who are connected with the field of law would know. The problem was the various devices which were found by some cunning litigants who were facing criminal investigation. And that was, the moment a person is arrested, he would admit himself into the hospital. There were some hospitals, let us face it, who were ready to oblige him by saying that he is suffering from a very severe disease, and therefore there cannot be any investigation, interrogation at this stage. And all of you are aware, under the provisions of the CRPC as it stood then, the first 15 days were crucial, If somehow an accused can pass first 15 days, the investigating agency would lose its right of investigation completely. This was being misused in most of the times, especially by those who are facing criminal charges and have the wherewithals, financial and otherwise. Now the new law provides that while retaining substantially the period of judicial custody, now that 15 days period is segregated. It can be used within 60 days or 90 days as the case may be, depending upon the nature of the allegation made against him, and it can be in installments also. This is not anti-people, this is anti-criminal who is seeking to avoid or evade the course of law. This would not affect a law-abiding citizen. There are several digital reformative measures which are taken in this law. I'm not going into the merits of those, but I must say that the digitization as a concept for being implemented in the delivery of justice, in the dispensation of justice, is inspired almost completely by Dr. Justice Chandrachud, who is the karta of our larger judicial and legal HUF. Friends, I thank the ministry to allow me to be here and share some of my thoughts. And I, as a citizen of this nation, thank the Honorable Prime Minister and the Honorable Home Minister to take a call maybe a little later, because they could take a call when they get the chance. And on the first available opportunity, they took this as an opportunity to reform, because continuing status quo is always an easy option. Changing status quo requires courage and conviction. Thank you so much.
बहुत बहुत आभार माननीय श्री तुषार मेहता जी, ऑनरेबल सॉलिसिटर जनरल ऑफ इंडिया. Ladies and gentlemen, a renowned legal luminary, having experience of more than 42 years of practice in the Supreme Court of India as a lawyer, learned Solicitor General of India, Honorable Shri R. Venkatramani ji, is gracing the occasion. May I now request learned Attorney General of India, Honorable Shri R. Venkatramani ji, to share his valuable thoughts and insights about these three criminal laws.
Looking at the galaxy of very eminent people here, the CBI Director, High Court judges, my additional Solicitor General, practicing lawyers, Mr. Mahesh Jethmalani, and the Chief Justice of India, I was wondering whether I should expose my illiteracy and ignorance. But then I took courage from what my learned brother, Solicitor General, said about, I gathered threads from where he left. Those of us who are beyond 50s and 60s of age will know that how the topography of a country, many cities, and the rural-urban landscape has undergone very significant and dynamic transformations. It's like you're looking at an old wardrobe, a wardrobe which is worn out. You look at the hanger which is worn out, the cloths which are fairly old, and the wardrobe has lost its sheen. And you want to do something about it. So commitment, the idea of change, the idea to look at change, the willingness to look at change and take risk. My venerable Professor Dr. Madhav Menon, when he brought me to practice in Supreme Court, told me one thing: be prepared to take risks in life. That is a prophetic word I now understand in my profession how it has worked. I suppose all of us, as administrators, judges, lawyers, and people who are part of an important segment of what I may call a social peace, if you're willing to look at changes, I think we have done 90% of the job. So the willingness and the commitment to look at change is something very fundamental. So while having said that, let me greet on my own behalf the Honorable the Chief Justice and the very affectionate Law Minister and my dear friends in the Law Ministry who keep interacting with me at a very high level of intelligence and cooperation. Let me greet them on my behalf on this very wonderful morning, and all of you are assembled here. While several parts of the world are in the midst of transitions from early democracy to mature democracy, or exposed to unsettling features in the social order, India is courageously charting out her paths to domestic peace and addressing equality claims and diversity management. Every emergence of a social change in economical, social, political, and technological may trigger changes in human behavior. The right and wrong of behaviors can become crimes or undesirable. We are witnesses to this phenomena. Many legislations attempt to deal with behavioral changes, bringing in regulatory and penalty elements. These could be from environmental wrongs to cryptocurrencies, cyber crimes that seem to involve young minds and other socially deviant peoples, or economic crimes, or even anti-social peace crimes. I would like to call anti-social peace crimes. Besides other worrisome social behaviors, look at what's happening in many of our educational institutions. Debates on enhancing the justice content of a criminal justice system may have to move towards an integrated approach. Virtually, at a different level, every country is called upon to assess and take stock of its criminal justice system. The criminal justice system is not merely the penal laws, the investigators, the prosecutors, the courts, the prisons, all in isolation, but in their interrelationships. As also the perceptions and attitudes of the peoples in the community towards crime is a very important element of administration of criminal justice. Any endeavor towards eliminating coercions, force, compulsions in the system, or enhancing fairness at every stage of the system, or providing for changes in the attitudes of the peoples must address these interconnections. Changes in isolation may not be effective in moving towards more and more of crimeless society. Bhutan is talking about gross domestic happiness. This GDF will symbolize social peace. Current studies in neurosciences are ambitiously entering old debates on why people commit crimes, or for that matter, why and how we respond to external stimuli in certain ways. This could help us in understanding police behavior or the perspectives of judges on what to do with what deviant behavior. The huge literature in this field call for a closer look at many of our theories of crime and punishment. Deterrence, retribution, or consequentialism in the field of punishment are all open to new challenges from worldwide experiences. A paradigm shift, as we talk about in the fields of science and sociology, may have to happen in the field of criminal justice administration. The new penal code is not a penal code, but a Nyaya Sanhita. The elimination of many deviant behavior from list of crimes means movement towards decriminalization. I understand the use of the word Nyaya signifies social justice, that is, balancing justice between peace and deviant behavior, or social defense against deviance. In a sense, we are not in the days of mere condemnation on any preconceived notions of crimes. We have moved away from Beccaria or Jeremy Bentham, whose thoughts influenced Macaulay. Social peace, I understand, is Nyaya for everyone. Since we do not have the ultimate keys for understanding deviant behavior or belligerent attitudes, and which may impact social peace, we still need to deal with all shades of human conduct. The selective violations of laws, behaviors by people for many a reason will always be a matter of concern and responses. I understand the Nyaya Sanhita is an attempt towards doing that. However, fairness in process and substance will remain largely non-negotiable. The very thought of Nyaya, the underlying idea of the new code, suggests that we are closing our eyes to colonial or other ways of thinking. But we need to further strengthen this idea and probably segregate different deviant behaviors and treat them differently within the broad limits of fairness. Similarly, the new procedural code is not procedural, but protection. It talks about Suraksha. Suraksha means protection and not mere procedure. This is in tune with moving away from a code which was an exclusive domain of investigation, prosecution, etc. All procedures must avoid coercions, compulsions, discomfort, and ensure self-protection. The famous Miranda warning of the US criminal law can become hollow if in substance other limbs of the criminal justice system are foul and they fail. The use of the word Suraksha is not merely symbolic, but the provisions are slated towards fairness. We need again to keep in mind the Nyaya element and the social peace element while looking at the Suraksha element. The Sakshya Adhiniyam has few features which seem to eliminate the needless clutter of evidentiary procedures. The law of evidence must be facilitating and not a house of choices or principles for the unethical. The legal fraternity for long has used the evidence law without ethical considerations. Some of the salient principles of Indian logic system or Nyaya Sastras have also not been invoked or used in the evidence law. I think we can have an appendix of such principles to guide the working of our system. We also need to have working guidelines for the investigation agencies as part of this law. Perhaps the world of police laws and codes of yesterday's need to be overhauled while retaining some time-tested features. Humanizing the police system can happen with these collaborations. Just as technology has fundamentally changed our lives and transactions, its utility in expedition and avoidance of wasteful procedures has been excellently captured in the Suraksha Adhiniyam and the Sakshya Adhiniyam. As I said, more experiments in the world of understanding deviant behaviors are called for. I find the 3 new legislative instruments are significant steps. It is true, some aspects can be questioned as remnants of the old code, but what is important is the room for transitions. The Indian Penal Code was static in one sense. The very thought of becoming dynamic and moving with the times is important. The 3 instruments are promising in this way. I do not propose to scan them. However, I carry a fond thought that when laws are seen as instruments and not as mere power, we would have moved away from a power-hungry system or a system blind to human dignity, or also negotiated social peace. That some people or some behaviors will always be questionable and may not tally with morality or social peace will always be addressed with due responses and considerations. Maybe we need to set up a National Institute for Criminal Justice Administration to connect the threads of the new triumvirate of the laws. Let me wish this deliberation today a great success, and thank you for your attention.
We are grateful to the learned Attorney General of India, Honorable Shri R. Venkatramani ji, for sharing his valuable ideas and insights ऑन दीज न्यू लॉज। दिव्य सज्जनों, मैं निवेदन करूंगा माननीय केंद्रीय विधि एवं न्याय राज्य मंत्री स्वतंत्र प्रभार माननीय श्री अर्जुन राम मेघवाल जी से कि वे इस अवसर पर अपने संबोधन के लिए पधारें।
आज का कार्यक्रम थोड़ा हमारे चुनाव के बाद आ गया सीधा। मेरा कल मतदान था और सीधा आ गया हूँ मैं। तो वैसे मैं लगता भी ग्रामीण हूँ और वेशभूषा भी मेरी ग्रामीण है, तो मैं थोड़ी ग्रामीण पृष्ठभूमि की बात करूँगा। थोड़ा आप सहन करोगे ना, क्या नहीं करोगे? 3 नए कानून, ये प्रोग्रेसिव पाथ है, ऐसा इस कॉन्फ्रेंस का सब्जेक्ट है मेरे ख्याल में। उस पे चर्चा करने के लिए आज की ये कॉन्फ्रेंस है। क्रिमिनल जस्टिस सिस्टम में क्या चेंजेज आया है उसको लेकर के। इस अवसर पर उपस्थित भारत के मुख्य न्यायाधीश माननीय न्यायमूर्ति डॉक्टर D.Y. चंद्रचूड़ साहब, आपने सहमति दी, क्योंकि ये मेरे मंत्रालय का ही काम था। सेक्रेटरी साहब थोड़े चिंतित थे, फिर मैंने आपसे बात की और आप आए, इसलिए आपका स्वागत है, वंदन है, अभिनंदन है। भारत के अटॉर्नी जनरल डॉक्टर R. वेंकटरमणी जी, आपने कहा कि 1984 में भी ऐसे ही दिखते थे, अब भी ऐसे ही दिख रहे हैं, मुझे अभी आप कान में कह रहे थे। तो इसमें इनका योगदान भी है, लेकिन इनकी धर्मपत्नी जी का ज़्यादा योगदान है, उनके लिए भी ताली बजा दीजिए आप। भारत के सॉलिसिटर जनरल श्री तुषार मेहता जी, उन्होंने धाराओं की बात की। अभी धारा क्या क्या है वो सब वो ठीक है, मैं धारा की बात करूंगा। थोड़ा फर्क है जी, धाराएं जो सारा डिटेल में उन्होंने बता दिया, वेंकटरमण जी ने भी बताया, लेकिन मैं भारतीय भाव की धारा जो प्रधानमंत्री नरेंद्र मोदी जी बाहर आए हैं उनकी बात करूं। हमारे न्याय विभाग के सचिव श्री SK जी रहाटे जी, हमारे विधि कार्य विभाग के सचिव डॉक्टर राजीव मणि जी, हमारे एडिशनल सेक्रेटरी हमारे अंजू राठी राणा, और पहले हमारे सेक्रेटरी रीटा वशिष्ठ जी, सचिव अभी है लॉ कमीशन में। आदेश अग्रवाला जी भी बैठे हैं, जो प्रेसिडेंट है सुप्रीम कोर्ट बार एसोसिएशन के। और ये जान करके हमें प्रसन्नता है कि CBI के डायरेक्टर भी हमारे सामने बैठे हैं और ED के डायरेक्टर भी बैठे हैं। ये भी एक नहीं, हमारे चुनाव में बड़ा मुद्दा था इसलिए बैठे हैं। वो सब आप बाकी समझ गए होंगे आप। हमारे दिल्ली पुलिस के भी काफ़ी अधिकारी बैठे हैं। और नहीं, मैंने कहा भाई हमने बनाया क्या ED और CBI? आपके ज़माने में बना, तब से चल रहा है ना, क्यों आप चिंता और कर रहे हो? सब ठीक करेगा। रूल ऑफ लॉ है ना, इसमें रूल ऑफ लॉ के अनुसार कार्रवाई होगी ना। लेकिन ये काफ़ी ये विषय चुनाव में रहा, ऐसा मैं कभी इनसे दोनों से अलग से भी बात करूँगा। इंडियन लॉ इंस्टीट्यूट के भी हमारे काफ़ी अधिकारी बैठे हैं, मिनिस्ट्री ऑफ होम अफेयर्स के भी बैठे हैं, लॉ एंड जस्टिस के तो हैं ही, स्टूडेंट भी हैं। मुझे ये बताया गया कि इस हॉल में जगह कम पड़ गई तो कुछ तो खड़े हैं, और कुछ 2 हॉल और राजीव मणि जी ने बुक किए हैं, उसमें भी लोग बैठे हैं। शायद राजीव मणि जी बैठे हैं ना उसमें, तो उनको भी बधाई मेरी ओर से। जो इधर सीधे नहीं देख रहे हैं, मेरे को वैसे देख रहे हैं, उनको भी बधाई। अब मैं साहब, अगर CGI साहब मुझे थोड़ा माफ़ करेंगे तो मैं थोड़ा सा डिफरेंट टॉपिक पे बात कर लूँ सर, आपको थोड़ा डिफरेंट टॉपिक कर लूँ। सर, ये 100 साल का जो सिस्टम है हमारे देश में, वो बड़ा महत्वपूर्ण है सर। 1757 में हमारे यहाँ प्लासी का युद्ध हुआ सर, और रेवेन्यू राइट्स बंगाल, बिहार, उड़ीसा को मिले। ये महत्वपूर्ण हमारे लिए इवेंट था भारत के लिए। 1757 ठीक 100 साल बाद सर, ठीक 100 साल बाद 1857 में अंग्रेजों ने तो उसको गदर कहा, लेकिन वो गदर नहीं था सर। एक कानून आया था सर कि भारतीय राजा अगर वो निसंतान हैं तो वो किसी को गोद नहीं ले सकते सर। कानून है बीच में यहाँ, और उस कानून के विरोध में ही आग लगी थी सर।
कि ये ऐसा कैसे कानून बना सकते हैं सर, जैसे मैं राजा हूं, अगर मेरी कोई संतान नहीं है तो क्या मैं गोद नहीं ले सकता? बोला नहीं ले सकते। तो फिर क्या होगा? तो उनको लगा मेरा राज्य हड़प जाएगा, तो इसके विरुद्ध में सभी एक साथ हुए सर। यहाँ ये 1857 हमारे लिए स्वतंत्रता संग्राम की पहली क्रांति थी, चाहे उन्होंने गदर कह दिया होगा। 1757 इंपॉर्टेंट, 1857 भी इंपॉर्टेंट, और सर 1957 भी इंपॉर्टेंट। वो 50 और 57, वो ये आजकल जो कानून बनते हैं उसमें 5% सर एडमिसिबल एरर होता है सर, तो उसको आप जोड़ेंगे, कम बेसी करेंगे, तो 1957 भी हमारे लिए बहुत इंपॉर्टेंट है। 50 से 57 तक बहुत से ऐसे कानून बने। मैं रेवेन्यू लॉज को देखता हूँ, रेवेन्यू लॉज तो सब 56-57 बने हर स्टेट में, बड़े इंपॉर्टेंट है सर। ये घटनाक्रम 100 साल का। अब मैं 100 साल का एक घटनाक्रम आपको याद दिलाता हूँ, वो है स्वामी विवेकानंद जी से संबंधित। सर ये टॉपिक से संबंधित तो आप कहोगे है या नहीं है, लेकिन थोड़ा टॉपिक से संबंधित भी है सर। वो 1895 में मिशिगन यूनिवर्सिटी में ऐसे ही एक कोई कॉन्फ्रेंस होती है, उसमें एक भाषण देते हैं। तो एक महिला पत्रकार आकर के उनसे पूछती है कि स्वामी जी आपने भाषण बहुत अच्छा दिया, लेकिन आप एक क्वेश्चन का जवाब दे सकते हैं? तो उन्होंने कहा क्या क्वेश्चन है आपका? उन्होंने कहा आपका देश आजाद कब होगा। अब ये क्वेश्चन तो कम डिफिकल्ट था। 1895 में कोई किसी से पूछे कि आपका देश आजाद कब होगा भारत, तो क्वेश्चन कठिन था या नहीं था? बताओ मेरे को। सरल था क्या? कठिन था ना? मातृशक्ति बोल रही कठिन था, लेकिन उसका जवाब दिया स्वामी जी ने। लेकिन यहाँ जवाब एक नहीं देते हैं, वो 3 जवाब देते हैं। वो महिला कहती मैंने एक ही पूछा कि मुझे 3 दिखे। स्वामी जी कहते हैं मुझे 3 दिखे, इसलिए मैं 3 देता हूँ। बहुत शानदार ये कन्वर्सेशन है स्वामी विवेकानंद जी का। मुझे लगता है कि इसमें ये ज्ञानवर्धक भी है और हमारे लिए प्रेरणास्पद भी है। उन्होंने कहा मेरा देश, वो फिर थोड़ी देर ध्यान में बैठ गए स्वामी जी। ये मेडिटेशन एक अलग विषय है सब। ध्यान में बैठ गए तो उस महिला ने कहा कि जब क्वेश्चन कठिन होते हैं तो बड़े बड़े आदमियों को मौन लग जाता है, ध्यान लग जाते हैं। तो 5-7 मिनट ध्यान में रहे, वो महिला जाने लगी तो स्वामी जी उठे। उन्होंने कहा कम नियर टू मी, नाउ आई विल एक्सप्लेन एंड आई विल आंसर योर क्वेश्चन। तो उन्होंने कहा बोलो क्या है? कि 50 साल के अंदर अंदर, अब आप सुनिए, आप 1895 50 साल के अंदर अंदर इंग्लैंड में और भारत में ऐसी परिस्थितियां बनेगी कि मेरा देश आजाद हो जाएगा। ये 1895। 1895 को 50 जोड़ो, कितना हुआ? 1945। क्या हुआ साहब? क्या हुआ? इतना ही हुआ क्या और कुछ हुआ? 1945 में सेकेंड वर्ल्ड वार समाप्त होता है, ठीक है। अब आप इंग्लैंड का चुनाव आप देख लो। इंग्लैंड का चुनाव आप 1945 का देखेंगे तो चर्चिल कहता है अगर मुझे सत्ता मिली तो मैं भारत को जल्दी आजाद नहीं करूंगा, घोषणा पत्र है उनका। और एटली कहता है मुझे सत्ता मिली तो मैं भारत को आजाद कर दूंगा। स्वामी विवेकानंद सही हुए कि नहीं हुए? बस आप बताओ मेरे को। ताली तो बजाओ स्वामी जी के लिए जोरदार। और परिस्थिति ऐसी बनी कि चर्चिल हार गया। अब जो आदमी सेकेंड वर्ल्ड वार जीतता हो वो आम चुनाव हार जाता है। ये साधारण घटना नहीं थी जी, यूरोप की बड़ी घटना थी ये। जो चर्चिल, और बहुत बहुत ज्यादा समय तक वो इसमें सांसद रहे हैं, प्राइम मिनिस्टर, बहुत लंबा पीरियड है उनका। जो सेकेंड वर्ल्ड वार जीत जाता है, सेकेंड वर्ल्ड वार में हमेशा इंग्लैंड का नेतृत्व करता है, लीडरशिप देता है, वो आम चुनाव हार जाता है, एटली आ जाता है। उसने कहा लाओ एक्ट। तो स्वामी विवेकानंद जी की पहली भविष्यवाणी सही हुई कि नहीं हुई? बताइए मेरे को। हो गई ना? अब दूसरी और महत्वपूर्ण है सब। उन्होंने कहा कार्ल मार्क्स के जन्म के ठीक 100 साल, भाई 100 साल का मामला महत्वपूर्ण है जी, ध्यान रखना है। कार्ल मार्क्स के जन्म के ठीक 100 साल बाद रशिया में एक क्रांति आएगी। उन्होंने कहा कौन सी क्रांति आएगी साहब रशिया में? रशिया में क्रांति आ नहीं सकती, आप झूठ बोल रहे हो स्वामी जी। रशिया तो एग्रीकल्चर कंट्री है, वहां काहे की क्रांति आएगी? अब आप देखना, 1816 में कार्ल मार्क्स जन्मे, ठीक है, और 1917 में रशिया में क्रांति आ गई। आई कि नहीं आई? बताओ सही। वो महिला क्रॉस क्वेश्चन करती है स्वामी जी से, स्वामी जी आप झूठ बोल रहे हो, यहां शायद जर्मनी में आ सकती है क्रांति, जर्मनी इंडस्ट्रियलाइजेशन तेजी से हो रहा है, रशिया में कोई क्रांति नहीं आएगी, लेकिन क्रांति रशिया में ही आई। सब आई या नहीं आई? हाँ, यस और नो तो बोलो, क्या कर रहे हो आप? हाँ आई। लेकिन एक क्वेश्चन और उन्होंने आंसर दिया बिना बताए, ठीक 100 साल बाद, ठीक 100 साल बाद जो क्रांति रशिया में आई, उस थॉट का समाप्ति होना शुरू हो जाएगा। तो हम 1917 से देख रहे हैं कि जो थॉट उस समय चला था रशिया से, वो धीरे धीरे गायब हो गया। और जो कम्युनिस्ट पार्टी के लोग हैं वो इन्वेस्टमेंट मीट करने लगे, जबकि इन्वेस्टमेंट मीट से वो चिढ़ते थे पहले। बंगाल में भी इन्वेस्टमेंट मीट हो गया जब कम्युनिस्ट पार्टी थी, और केरला में भी हो रहा है। मैं उनको पूछता हूँ आपका थॉट है क्या ये? तो मुझे स्वामी विवेकानंद याद आते हैं कि कार्ल मार्क्स 1816 में जन्मा, ठीक 100 साल बाद क्रांति आएगी, कम्युनिज्म फैलेगा भी, 2017 के आसपास कम्युनिज्म सिकुड़ जाएगा। अरे आपको लगा नहीं क्या ये? तो ताली तो बजाओ नहीं यार, ऐसे क्या करो। और एक भविष्यवाणी और की उन्होंने कहा, मैंने एक ही पूछा नहीं कि एक और सुनो। 21st सेंचुरी भारत की होगी। पहली सही हुई ना, मेरा देश 50 साल में आजाद हो जाएगा, सही हुई या नहीं हुई बताओ मेरे को? दूसरी सही हुई या नहीं? करीब करीब सही है, हो गई ना? तो तीसरी पे शक क्यों कर रहे हो जी? नहीं कर रहे हो क्या? तो फिर जोरदार ताली बजाओ भी स्वामी विवेकानंद के लिए। ऐसा नहीं, उसमें भी उन्होंने कहा कि 21वीं सदी का तीसरा दशक महत्वपूर्ण होगा भारत के लिए। ये दशक कौन सा है? 2020 से लेकर के 2030 तक है, और हम इसी दशक में हैं। हम इसी दशक में चर्चा कर रहे हैं साहब। ये तीनों हमारे कानून, जो एक 1860 में बना आईपीसी, एक 1898 में सीआरपीसी बना, एक एविडेंस एक्ट 1872 में बना, ये सब बातें आपकी आ गई। लेकिन मैं एक चीज़ कहूँगा कि मेरे भर्तृहरि मेहताब एक हमारे एमपी हैं, हमारे यहाँ महेश जेठ मिलानी जी बैठे हैं, हमारे एमपी हैं राज्यसभा के। भर्तृहरि मेहताब बोल रहे थे लोकसभा में जब ये कानून आया, बोला ये ऐतिहासिक कदम है, हमारे गृह मंत्री जी को धन्यवाद दे रहे थे। लेकिन उन्होंने एक नॉलेज की बात कही जो हम सबको ज्ञानवर्धन हुआ। उन्होंने कहा साहब, जब 1857 की जब ये हमारे यहाँ तो क्रांति हुई, उन्होंने कहा ये ठीक नहीं हुआ, ये भारत के लोग हिल गए, ये हमें हिला रहे हैं, ये ठीक नहीं, ये जाग गए। तो बोला सिस्टम बंद करो कंपनी का, क्राउन का सिस्टम लाओ। तो सीधा क्राउन का सिस्टम लाए। 1858 में एक एक्ट आया, उस एक्ट के तहत सीधा क्राउन हमारे कंट्रोल करने लग गया। लेकिन अब कैसे हम कानून कोडिफिकेशन करें, तो फुर्सत नहीं थी। तो एक आयरिश पीनल कोड था, बोला ये उन्होंने भर्तृहरि मेहताब ने लोकसभा में ऑन रिकॉर्ड बोला। फिर मैं पूछने गया, उन्होंने कहा मैं एकदम सही बोल रहा हूं, आयरिश पीनल कोड था, उसमें आयरिश हटा दिया और इंडियन पीनल कोड दिया। कुछ नहीं किया उन्होंने, कोई भारतीय भाव और उसमें कोई इंडियन हम कैसे करेंगे। और देखो कैसे बनाया, उनको ठीक कहा तुषार मेहता साहब ने, उनको हमें दंड देना था और नरेंद्र मोदी जी को न्याय देना है, दोनों में फर्क है जी। उनके लिए प्रायोरिटी क्या थी? 5 और 5 से ज्यादा आदमी ज्यादा इकट्ठे होंगे तो ये हो जाएगा धारा 145, 144, 145। बोला आदमियों के इकट्ठे होने से उनको डर था, और आदमियों पे अपराध हो जाए तो कहां ले गए? 376 पीछे ले गए, हम आगे लाए। ध्यान रखना है, ये फर्क है। उनके लिए नारी का सम्मान बहुत पीछे ले गए 376 में, और हम आगे लाए। ये भारतीय भाव की धारा है। 302 भी पीछे ले गए, हम आगे लाए हैं बीएनएस में। बीएनएस का मतलब समझ गए ना आप? भारतीय न्याय। अब समझ में आ गया, ताली बजा देते हैं आपके लिए जोरदार, मैं भी बजा देता हूं। मुझे लगता है थोड़ा बहुत न्याय करने की कोशिश करूंगा। मैं एक जगह कलेक्टर था, मैंने एक आदमी को सस्पेंड किया। अब सीजीआई साहब बुरा नहीं माने तो मैं कह दूं, मुझे एक जज साहब ने बुलाया कि आपको आना पड़ेगा। मैंने कहा साहब क्यों आना पड़ेगा, मैं बहुत अभी बिजी हो गया, एमपी भी बन गया। कह नहीं आपको आना पड़ेगा। मैं गया तो मुझे 2-4 घंटे तो बैठा ही रखा। फिर मुझे बुलाया, मैंने कहा साहब कैसे बुलाया, क्या हुआ? कि ये जो ऑर्डर पास किया है आपने, एक पटवारी को सस्पेंड किया है, ये आपके ही दस्तखत हैं? मैंने कहा हाँ है। तो मेरी बोला यहाँ करो दोबारा। तो मैंने दोबारा किया दस्तखत। बोला थोड़ा मेल नहीं खा रहा। मैंने कहा 10 साल हो गए, थोड़ा मेल नहीं खाएगा। कि आपने होश हवास में किए थे दस्तखत। मैंने कहा होश हवास में किए होंगे, अब याद नहीं है मेरे को। अब इसके लिए मुझे पूरा दिन लगा। अब इसमें क्या हुआ है साहब, इसमें मैं घर बैठे ही कंप्यूटर पे भी ऑनलाइन ही दस्तखत कर दूंगा। जज साहब को कहूंगा ठीक मिल गए क्या, तो मेरा काम आसान हुआ या नहीं हुआ, यही बदलाव है साहब, और कुछ नहीं है। आपको अच्छा लगा क्या ये सब वाक्य? तो ताली बजाओ भी जोर से, अच्छा लगा तो। ऐसे ही बदलाव है, टेक्नोलॉजी का यूज, धाराओं का चेंज, भारतीय भाव, ये सब चीजें हैं इसमें। और जो विकसित भारत की जो कल्पना प्रधानमंत्री मोदी जी ने की है, उसमें गुलामी के अंशों से मुक्ति, ये दूसरा प्रण है हमारा, ये दूसरा प्रण है जी हमारा। ये जो सुभाष चंद्र बोस की मूर्ति ऐसे ही नहीं लग गई यहाँ, पता है ना आपको? यहाँ किसकी मूर्ति थी पता है क्या? है जॉर्ज पंचम। और जॉर्ज पंचम की फिर हटी कब थी ये पता है किसी को? कब हटी थी? देश आजाद होने के बाद आंदोलन हुआ कि सारी जगह की मूर्तियां हटा दी आपने, ये जॉर्ज पंचम को क्यों नहीं हटाया? लेकिन जॉर्ज पंचम को नहीं हटा पाए, रखा रहे। पंडित नेहरू जी के समय तो हटा ही नहीं। 1968 में फिर एक आंदोलन हुआ। भाई क्या कर रहे हो आप? 67 में कुछ सम्मिलित सरकारें बनी इस देश में और कुछ आंदोलन हुआ, क्या 68 में हटा? अब वो हट तो गए, लेकिन छतरी वहीं की वहीं थी। लोग घूमने जाते तो कहते छतरी किसकी है? बोला जॉर्ज पंचम की, खाली रखा। गुलामी का भाव अगर तेजी से हट रहा है तो नरेंद्र मोदी जी के कालखंड में हट रहा है। इसलिए मोदी जी कहते हैं यही समय है, सही समय है, भारत का अनमोल समय है। क्यों बोले नहीं आप इसको? यही समय है, सही समय है, भारत का अनमोल समय है। और जब 1 जुलाई से ये तीनों कानून लागू होंगे तो भारत का ये समय और अनमोल बनने वाला है। ध्यान आ गया ना आपको? सरकार नई भी आ जाएगी। बहुत बहुत बधाई और शुभकामनाएं। धन्यवाद।
बहुत बहुत आभार माननीय श्री अर्जुन राम मेघवाल जी, माननीय मंत्री महोदय का। देव सज्जनों, आज देश की न्यायिक प्रक्रिया में और देश की अदालतों में जो मानवीय संवेदनाओं को केंद्र में रखकर भारत की आज की आवश्यकता के हिसाब से इतने सारे महत्वपूर्ण बदलाव हम देख रहे हैं, अनुभव कर रहे हैं, उसका लाभ भी ले पा रहे हैं, उस सबके प्रेरणा स्रोत हैं भारत के माननीय मुख्य न्यायाधीश ऑनरेबल डॉक्टर जस्टिस D.Y. चंद्रचूड़ जी। मैं ये समय है जब उनसे विनती करूं इस अवसर पर एक बार पुनः हम सबका मार्गदर्शन करें। अपने इनॉग्रल एड्रेस के लिए पधारें ऑनरेबल डॉक्टर जस्टिस D.Y. चंद्रचूड़।
थैंक यू। नमस्कार। Shri Arjun Ram Meghwal ji, Honorable Minister of State, Independent Charge, Ministry of Law and Justice, Shri R. Venkatramani, the Learned Attorney General for India, Shri Tushar Mehta, the Solicitor General, Shri S.K.G. Rahate, Dr. Rajiv Mani, Dr. Anju Rathi Rana, senior officials of the Government of India, all of you very distinguished members of the audience who have so graciously assembled here this morning for the inaugural event. Before I begin the formal part of my address this morning, I must share with you that it is very important to train our younger generation for the future that we hold in trust for them. And what better symbolism can we have than in the 4th row we have this little girl who is sitting in the audience with her mother. And I think that's the significance of the fact that we're catching the younger generation, if only to remind ourselves that we hold these legislations in trust for their future. With the enactment of these 3 parliamentary legislations, India is set for a significant overhaul of its criminal justice system. The Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam will, as we all know, replace the Indian Penal Code of 1860, the Indian the Code of Criminal Procedure of 1973, of course, which was preceded by the CRPC of 1898, and the Indian Evidence Act of 1872. These laws, in a sense, are a watershed moment for our society, because no law affects the day-to-day conduct of our society like the criminal law. Criminal law directs the moral arc of a nation and has the ability of depriving people of their cherished liberties as well. The underlying justification for the substantive provisions is the age-old harm principle, which is best summarized in the saying, "Your right to swing your arm ends just where the other man's nose begins." Procedural law, which governs crimes from the state of setting the criminal process in motion to the conviction for the commission of the offense, ensures that no person is charged and subsequently convicted for offenses without the due process of law. The one thing which was the striking aspect of our triad of criminal laws was their age, 1860, 1872, and even 1973. And I think the enactment of these laws by Parliament is a clear indicator that India is changing, India is on the move, and that India needs new legal instruments to deal with current challenges and the challenges which we envisage for the future of our society. The traditional harm principle found resonance with the understanding that crime is immoral. The father of criminology, Rafael Garofalo, defined crime as an immoral and harmful act that is regarded as criminal by public opinion because it is an injury to so much of the moral sense as is possessed by a community, a measure which is indispensable to the adaptation of the individual to society. The ideals underpinning the combination of harm and immorality are premised on the perception that deprivation of liberty leads to repentance and to moral salvation. There were two problems with this harm-linked approach to criminal jurisprudence. The first was that it is not a victim-oriented approach. The impact of the harm on the victim is not considered. Victims of crime often feel like their agency over their own decisions is lost by the commission of a crime. Our laws have therefore to aim to give victims a sense of agency and control in the criminal process, as well as a sense of justice. The second problem with the juristic foundations of our earlier laws was in regard to the harm and immorality approach, and that was that it advances a perpetrator perspective to crime, which views crime as an individual failing. It does not address systemic causes which push people to commit crimes. For example, a law addressing gender violence will rightly condemn such violence as immoral and punish it. But it does little to change the sexist and patriarchal approach and framework of our society, which induces the commissions of these crimes. Our laws needed to address these concerns and obviate age-old issues like delays in the examination of witnesses, delays in the conclusion of trials, the overcrowding of prisons, and the issue of under-trial prisoners. The 248th report of the Standing Committee of the Rajya Sabha on the Bharatiya Sakshya Sanhita of 10th November 2023 noted that the Indian criminal justice system has struggled to keep pace with the profound technological changes, our socio-economic milieu, and that these socio-economic changes have radically reimagined the way in which crimes manifest in society. The growing scope of technology and the new age crime which uses the digital landscape to create networks of collaborative units to commit crimes cannot be pinned to an investigative situs. Today's crime has no investigative situs, no physical situs. This has presented challenges in the investigation of crime, admission of evidence, and prosecution, as well as justice delivery. As a distinguished American jurist, Justice Oliver Wendell Holmes said, "In law in science and science in law, everyone instinctively recognizes that in these days, the justification of a law for us cannot be found in the fact that our fathers always have followed it. It must be found in some help which the law brings towards reaching a social end or a social purpose, which the governing power of the community has made up its mind that it wants." The newly enacted criminal laws have transitioned India's legal framework on criminal justice into a new age. Much needed improvements have been introduced to protect victim interests and carry out the investigation and prosecution of offenses efficiently. The BNSS encompasses a holistic approach to deal with crimes in the digital age. It prescribes audiovisual recording of search and seizures. For instance, in Section 105, and the presence of a forensic expert at the crime scene for offenses punishable with more than 7 years imprisonment, in Section 176(3). The audiovisual recording of search and seizures is an important tool for the prosecution, as well as for protecting the civil liberties of citizens. Very often in courts, we hear sordid stories of what happens in the course of a search and seizure operation, particularly under the Income Tax Act. The judicial scrutiny would safeguard the rights of citizens against procedural impropriety during search and seizures. Similarly, the presence of a forensic expert at the scene of the crime, which enhance the efficiency of the investigating team and allow for crimes to be decoded with the aid of the latest advancements in forensic technology. While we make strides in this direction, we must now confront the challenges of fulfilling the aims of the new criminal legislation. Detailed rules need to be formulated on the type of devices to be used for recording, incorporating the principles of natural justice, and lay down the consequences of not carrying out such recordings. Since I took over as the Chief Justice of India, and even before that when I was the chairperson of the E-Committee of the Supreme Court, which I continue to be, I have advocated for creating a natively digital court infrastructure. We have strategically and persistently worked towards creating technologically equipped court systems which can facilitate a citizen-centric and efficient mechanism from the filing of a case to its disposal. Recently, the Government of India has sanctioned a budget of 7,000 crores for the Indian judiciary as part of the e-courts project. Our challenge was, in the first year, was that between November and 31st of March, we had to expend 850 crores to upgrade the hardware and software across India. I'm happy to inform you that we have been able to deploy hardware, software, and a whole list of technological changes covering 825 crores out of the 850 crores that were sanctioned for the first year. It was therefore very heartening to notice that Section 532 of the BNSS allows for all trials, inquiries, and proceedings under the code to be conducted electronically in Section 532. As laudable as this addition is, we must continuously introspect and protect the privacy of the accused as well as the victim when dealing with digitization of proceedings and creating digital evidence. In the digital age, the data and sensitive information of a person has gained paramount importance. This data can allow us to gain unparalleled efficiency and ease. However, the power which comes with personal data puts a corresponding duty to make systems which are immune to penetration and leakage of data. In the courts, we confront the challenges of data leak every single day. The safety of a person, the stigma attached to an accused, the threat perception of a witness will be compromised if the privacy of the stakeholders is not protected by us. We must inspire public confidence in securing the privacy of our citizens to gain an overall efficiency and trust in the criminal justice system. Technology holds the key to a futuristic court system. It eases the court procedures for the litigants, court staff, and the judges. In particular, clauses 3 and 4 of Section 532 of BNSS allow for the examination of witnesses and evidence through the electronic mode. The access ushered in by this provision will impact the access of witnesses to the courts and reduce delays in trials on account of the absence of witnesses. While the new criminal laws create provisions which are synchronized to our times, we must also ensure that the infrastructure accompanying these procedures are developed adequately for the country to reap the benefits of the new legislation. This naturally means that we must heavily invest in capacity building for our forensic experts, conduct training of investigating officers, and invest in our court system. Key provisions of the new criminal law would only produce a positive impact if these investments are made as soon as possible. Let us take the example of the timeline prescribed for the completion of trials and the pronouncement of judgments after the judgment is reserved. The BNSS provides that criminal trials must be completed in 3 years and that a judgment must be pronounced within 45 days of it being reserved. This stipulation is a breath of fresh air for addressing the issue of case pendency, as well as the rights of the victim and the accused in a criminal case. But if the court infrastructure and the prosecution lack material resources to harness technology and conduct an efficient and speedy trial, then the guarantees of the BNSS may run the risk of becoming merely directory and becoming unimplementable. Recently, in fact, just this morning, I've addressed a letter to all the Chief Justices of the High Courts, emphasizing that the Bureau for Police Research and Development has prepared a module for training and development for training of all stakeholders, including judges, public prosecutors, and others. All states in the country have their state judicial academies. On the part of the police, we have the police training academies. Now, it is important that we synchronize the training which is taking place in the state judicial academies, as well as the police training academy, particularly the one in Hyderabad, to ensure that we are able to synchronize our efforts and truly reap the benefits of the legislation which Parliament has introduced. Citizen-centric approaches have been adopted for supply of a copy of the first information report to the victim and to inform them about the progress of investigation, including by digital means. Additionally, the BNSS has made a positive development in protecting the fundamental rights of under-trial prisoners. Section 481 prescribes default bail for an accused who has undergone 1/3 of the term of punishment for the offense charged against him. This is a complete and radical alteration from the earlier provision or the earlier prescription under the CRPC. The BNSS prescribes that in cases where the punishment for the offense is 7 years or more, the victim shall be given an opportunity of being heard before the withdrawal of the case by the government. Summary trial has been made mandatory for petty and less serious offenses. The magisterial system has also been streamlined. One of the problems of our criminal justice administration is that we treat the serious and the petty almost on the same footing. That has to change, which it has changed under the new laws. But the real challenge is about changing mindsets on our part to adapt to the new system. Bearing in mind the evolving nature of crime and the emergence of new digital crime, it is imperative to boost the infrastructure and capacity of our police forces. Crime in contemporary times reflects the technological advancement of our age. Because of the inertia in the law, unfortunately, and the procedures governing investigation, our ability to hold criminals to account has been affected. Our attention must be focused on improving investigation by allowing for multidisciplinary investigation teams with law enforcement officers and domain experts in the field of cybercrime and pattern recognition. Technology must also be harnessed to improve the capacity of prosecutions and the court to work more efficiently. The prosecution can use technology to streamline paperwork and data to identify similar cases. This will enable the courts to streamline the listing process. The digitization of files and infrastructure for conducting witness examination online must be harnessed to record and peruse voluminous material with the swiftness of a tap on the screen. Our laws and their implementation are an ever-evolving area. There is no finality to any law or the manner of its implementation. However, we must be willing to embrace positive changes to meet the needs of our times. I expect that with the implementation of the new criminal laws, we will discover loopholes and areas which need to be addressed. Such debates would be helpful in enhancing the efficiency of our criminal justice administration. The ideological framework at the heart of our analysis must be justice-oriented, with a civil liberty-centric approach which balances the interests of the victim and the accused. The moral advantage of a criminal justice system in a democratic society is that it affords the victim an opportunity to reclaim their agency and confront an accused. It also lies in the fact that all persons, no matter how high or how low, would get full opportunity to defend themselves before a court of law. I hope that the various panel discussions in this conference spark a positive conversation on various aspects of the new criminal laws. These conversations are vital for our collective growth in an evolving legal landscape. As we look to the future, we must learn from our past and take its teachings with us. The new laws will be implemented by existing personnel. Now, that is going to pose a challenge for all of us, because these laws will call for a change in practice, a change in mindsets, new institutional arrangements, the re-engineering of our processes. We will have to strengthen existing structures. Let us not forget that while these new laws have been enacted recently by Parliament, our structures, our institutions, are robust institutions in a democratic framework. So we will have to build on the existing structures which we have and not discard them. And I would particularly like to highlight the importance of the use of e-filing, better litigation management by the use of existing tools such as the National Judicial Data Grid, the adoption of technology to bring knowledge and information to all stakeholders, the digitization of records, building on the interoperable criminal justice system, facilitating the adoption of speech-to-text transcription of evidence and judicial orders. In the Supreme Court of India, we have already started implementing the transcription of speech-to-text in important hearings before the Constitution bench. The E-Committee of the Supreme Court of India, in conjunction with the Department of Justice, has prepared a pilot model of transcription of speech-to-text. Now, this simple innovation will speed the process of recording evidence, of recording judicial orders, and ensuring speed in our process. Finally, I'd like to stress on the use of artificial intelligence. AI will enable us to track progress in criminal trials right from the stage of the FIR to the conclusion of the trial. We must deploy AI for the purpose of noticing aberrations in the process. When a trial is delayed, when witness testimony is delayed, AI will be able to flag for us red marks on why these delays are taking place, providing decision makers for supervisory control at all levels of the criminal justice administration, creating templates for simple orders and simple pleadings and simple filings. So technology today is replete with a world of opportunity for us. So it is not enough for us to only notice the radically new provisions of these three new legislations. A conference like this is important for us to educate ourselves about the changes which Parliament has brought about. But equally, we must focus on ourselves, because these new laws will be successful if we who are in charge of implementing these laws adapt to them not only in terms of our institutional process, but in terms of our mindset as well. As a very distinguished judge has said, the law is the witness and external deposit of our moral life. Its history is the history of the moral development of our civilization. And therefore, I hope that with this conference, all of you and all of us will be alive to both the challenges, the opportunities, and the duties which are cast upon us as important stakeholders in the implementation of law. I would conclude by thanking the Department of Legal Affairs and the Union Minister for having so graciously invited me for this. I spoke at the CBI annual lecture just the other day. The director of CBI had invited me and I spoke on a similar topic. I think that fueled the invitation to this particular morning's conference. I'm thankful to you for inviting me and only want to assure all of you that in tandem with all the steps which you will be taken, the judiciary, which I represent as the head of the family, is equally alive to its responsibilities, and we are in the process of discharging our own responsibilities to make these laws a success. Thank you.
बहुत बहुत आभार भारत के माननीय मुख्य न्यायाधीश ऑनरेबल डॉक्टर जस्टिस डी.वाई. चंद्रचूड़ का। आप सब जानते हैं कि न्याय को लेकर, न्यायिक प्रक्रिया को लेकर उनकी जो दृष्टि है, चिंतन है, उनका जो समर्पण है, वो हम सब के लिए बहुत बड़ी प्रेरणा है। हम सभी हृदय से उनका आभार व्यक्त करते हैं। देवी सज्जनों, आपकी सूचना के लिए मैं ये एक बार फिर से आपको याद दिला दूं कि इस इनॉग्रल सेशन के बाद एक छोटा सा टी ब्रेक है और उसके तुरंत बाद बारी बारी से हमारे 3 टेक्निकल सेशंस हैं 3 लॉज को लेकर। आप ज़रूर उसे भी अटेंड करें क्योंकि उसमें डिटेल में ये बातचीत होगी और बहुत रेनाउंड लिमिनरीज हमारे पैनलिस्ट हैं जो अपने आइडियाज़, अपने एक्सपीरियंसेस हमारे साथ शेयर करेंगे। इस इनॉग्रल सेशन को हम कंक्लूड करें उससे पहले मैं आप सभी से रिक्वेस्ट करूँगा, आइए हम सब अपने अपने स्थान पर खड़े हों। राष्ट्रगान के लिए, नेशनल एंथम के लिए आप सबसे रिक्वेस्ट है, आप सभी अपने स्थान पर खड़े हों।
जन गण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे, तव शुभ आशीष मांगे। गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
बहुत बहुत आभार देवियों सज्जनों आप सभी का और आप सबकी तरफ से और डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस की तरफ से आभार। ऑनरेबल चीफ जस्टिस ऑफ इंडिया ऑनरेबल डॉक्टर जस्टिस डी.वाई. चंद्रचूड़ का जो मुख्य अतिथि के रूप में हम सबके बीच पधारे। आप सभी सिर्फ 2 मिनट के लिए रुकेंगे अपनी जगह पर। ऑनरेबल चीफ जस्टिस ऑफ इंडिया और दूसरे डिग्निटरीज को यहाँ से निकलने देंगे। आभार हम व्यक्त करना चाहते हैं केंद्रीय मंत्री श्री अर्जुन राम मेघवाल जी का, लर्नेड अटॉर्नी जनरल ऑफ इंडिया श्री आर वेंकटरमणी जी, लर्नेड सॉलिसिटर जनरल ऑफ इंडिया तुषार मेहता जी, डिपार्टमेंट ऑफ जस्टिस के सचिव श्री S.K. जी राहटे जी और डिपार्टमेंट ऑफ लीगल अफेयर्स के सचिव डॉक्टर राजीव मणि जी, और आप सभी का बहुत बहुत आभार। थैंक यू वेरी मच। आप सभी को मैं चाय के लिए इनवाइट करता हूँ। वी हैव जस्ट 15 मिनट्स फॉर टी ब्रेक, सो आई विल रिक्वेस्ट the joint secretaries and above officers, they will be coming to the VIP dining on first floor. Tea arrangements are there for them. सभी जगह एक ही जैसे arrangements हैं, लेकिन चूंकि लोग ज़्यादा हैं इसलिए अलग अलग जगह हमने इसको arrange किया हुआ है। So under secretaries and above and equivalent officers are guests, वे VIP lounge में आएंगे फर्स्ट फ्लोर पर ही। जो हमारे लॉ स्टूडेंट्स हैं ओपन एरिया में उनके लिए अरेंजमेंट है चाय के लिए, और इसके अलावा जो नालंदा और समरसता ऑडिटोरियम में भी जो हमारे विद्यार्थी बैठे हुए हैं, लॉ स्टूडेंट्स बैठे हैं, उनके लिए भी वहीं पर अरेंजमेंट्स किया गया है। बाकी से भी फर्स्ट फ्लोर जो फोयर एरिया है वहाँ पर तो 4-5 जगह ये अरेंजमेंट्स हैं। आप प्लीज़ ज्वाइन अस फॉर अ कप ऑफ टी एंड जस्ट आफ्टर 15 मिनट्स वी आर मीटिंग हियर अगेन फॉर आवर फर्स्ट टेक्निकल सेशन दैट विल बी on Bharatiya Nyaya Sanhita 2023. Thank you very much, ladies and gentlemen. देवी सज्जनों, आप सबसे रिक्वेस्ट है, हम्बल रिक्वेस्ट है कि आप प्लीज़ अपनी जगह ले लें, क्योंकि हमारा इनॉग्रल सेशन के बाद जो पहला टेक्निकल सेशन है उसके चेयर, को चेयर, पैनलिस्ट सभी आ चुके हैं और वो सेशन हम शुरू करने जा रहे हैं। 3 अलग अलग सेशंस हैं, बारी बारी से 3 अलग अलग जो क्रिमिनल लॉज नए बने हैं उनके ऊपर। तो समय की हम जितनी बचत कर पाएँ और एक मीनिंगफुल डिस्कशन का हिस्सा बन पाएँ, उसको विटनेस करें और कुछ चीज़ें ऐसी लेकर जाएं जो इन कानूनों के इम्प्लीमेंटेशन में हम जिस रोल में हैं सोसाइटी में, उस रोल को हम और बेहतर ढंग से निभा पाएँ। तो इसके लिए ज़रूरी है कि आप सबकी एक इन्वॉल्वमेंट, सीरियस इन्वॉल्वमेंट इन डिलिब्रेशंस के साथ हो। इसलिए मैं रिक्वेस्ट करूंगा, जो पहला सेशन है हमारा टेक्निकल सेशन भारतीय न्याय संहिता 2023, इस पर ही हमारा पहला टेक्निकल सेशन शुरू होने जा रहा है। आप सभी से जो ऑडिटोरियम के बाहर हैं उनसे भी, और ऑडिटोरियम में भी जो लोग खड़े हैं उनसे रिक्वेस्ट है कि वो सभी बैठ जाएं। मोबाइल फ़ोन काइंडली इंश्योर कि स्विच ऑफ कर लें या उसे कम से कम साइलेंट मोड पर ज़रूर कर लें, ताकि ड्यूरिंग द डिस्कशंस कोई डिस्टर्बेंस ना हो किसी तरह की। आप सभी से रिक्वेस्ट है, आप प्लीज़ टेक योर सीट्स। आप सभी बैठ जाएं प्लीज़, जहाँ भी जगह मिले आप बैठें, क्योंकि हम अपना पहला टेक्निकल सेशन शुरू करने जा रहे हैं। वी आर ऑलरेडी लेट फॉर 1 hour, So, ladies and gentlemen, on behalf of Department of Legal Affairs, Ministry of Law and Justice, we welcome you all in this first technical session of the conference, which is based on the Bharatiya Nyaya Sanhita 2023. ये हम सबका बहुत सौभाग्य है कि इस सेशन को चेयर करने के लिए ऑनरेबल मिस्टर जस्टिस अनूप कुमार मेहदी जी, जज दिल्ली हाई कोर्ट, उनकी गरिमामयी उपस्थिति हम सबके बीच में है। मैं रिक्वेस्ट करूंगा ऑनरेबल मिस्टर जस्टिस अनूप कुमार मेहदी जी, जज दिल्ली हाई कोर्ट, वो स्टेज पर आकर अपनी जगह लेंगे। This session is going to be co-chaired by Shri Mahesh Jethmalani ji, who is Member of Parliament and Senior Advocate, Supreme Court of India. मैं उनसे भी रिक्वेस्ट करूंगा ऑनरेबल मिस्टर जस्टिस अनूप कुमार मेहदी जी, श्री महेश जेठमलानी जी, रिक्वेस्ट करूंगा कि आप प्लीज स्टेज पर आकर अपनी जगह लें। द पैनलिस्ट इन दिस सेशन आर मिस ऐश्वर्या भाटी, लीड लर्नेड एडिशनल सॉलिसिटर जनरल, सुप्रीम कोर्ट ऑफ इंडिया, श्री प्रवीण कुमार, प्रिंसिपल डिस्ट्रिक्ट एंड सेशन जज, दिल्ली, Shri Raja Thakre, Special Public Prosecutor and Advocate, Bombay High Court. And this session is going to be moderated by Dr. Neeraj Tiwari, Assistant Professor, National Law University, Delhi. एक बार आपकी सबकी तालियों के साथ इन सबका हम स्वागत अभिनंदन करते हैं, इन सबको वेलकम करते हैं अपने पहले टेक्निकल सेशन में, which is based on the Bharatiya Nyaya Sanhita 2023. So before we start the deliberations, I will request Dr. Rajiv Mani ji, respected Secretary Sir, Department of Legal Affairs, Ministry of Law and Justice, कि वो आएँ और आप सबकी तरफ से, मिनिस्ट्री की तरफ से, डिपार्टमेंट की तरफ से इन सभी डिग्निटीज़ को यहाँ पर उनका वेलकम करें, उनका फेलिसिटेशन करें। एंड इन दैट ऑर्डर, फर्स्ट ऑफ ऑल डॉक्टर राजीव मणि जी से रिक्वेस्ट है कि ऑनरेबल मिस्टर जस्टिस अनूप कुमार मेहदी जी, जज दिल्ली हाई कोर्ट, उनको प्लांट और मेमेंटो भेंट करके उनका यहाँ पर अभिनंदन स्वागत करें। Honorable Mr. Justice Anup Kumar Mehdiratta is going to be, he is chairing this session, और आपकी तालियों के साथ उनका बहुत बहुत स्वागत अभिनंदन है। डॉक्टर राजीव मणि जी से, सेक्रेटरी सर से निवेदन है कि वे श्री महेश जेठमलानी जी, मेंबर ऑफ पार्लियामेंट, सीनियर एडवोकेट, सुप्रीम कोर्ट ऑफ इंडिया, उन्हें भी, जो कि को चेयर कर रहे हैं, इस सेशन के को चेयर हैं, उन्हें भी मेमेंटो और प्लान भेंट करके उनका भी स्वागत करें। डॉक्टर राजीव मणि जी से निवेदन है, हमारे पैनलिस्ट में शामिल यहाँ मिस ऐश्वर्या भाटी, लीडिंग लर्नेड एडिशनल सॉलिसिटर जनरल, सुप्रीम कोर्ट ऑफ इंडिया, उन्हें भी वेलकम करें, उनका फेलिसिटेशन मेमेंटो भेंट करके और साथ में प्लान भेंट करके। श्री प्रवीण कुमार जी, प्रिंसिपल डिस्ट्रिक्ट एंड सेशन जज, दिल्ली, ही इज ऑल्सो प्रेजेंट हियर एंड ही इज पार्ट ऑफ दिस पैनल। डॉक्टर राजीव मणि जी से निवेदन है कि उन्हें भी एक प्लांट और एक मेमेंटो भेंट करके उनका भी वेलकम करेंगे, उनका स्वागत करेंगे, उनका अभिनंदन करेंगे। आज के इस सेशन में उनकी उपस्थिति और उनकी पार्टिसिपेशन के लिए थैंक यू वेरी मच फॉर कमिंग सर। श्री प्रवीण कुमार जी, प्रिंसिपल डिस्ट्रिक्ट एंड सेशन जज, दिल्ली। श्री राजा ठाकरे जी, स्पेशल पब्लिक प्रोसिक्यूटर एंड एडवोकेट, बॉम्बे हाई कोर्ट, ही इज ऑल्सो प्रेजेंट हियर इन दिस एंड पार्ट ऑफ दिस पैनल। सो रिक्वेस्ट करूंगा डॉक्टर राजीव मणि जी से कि उन्हें भी, श्री राजा ठाकरे जी को भी मेमेंटो और प्लान भेंट करके उनका भी स्वागत करेंगे। डॉक्टर राजा ठाकरे इज स्पेशल पब्लिक प्रोसिक्यूटर एंड एडवोकेट, बॉम्बे हाई कोर्ट, और स्पेशली इस सेशन के लिए वो यहाँ पधारे हैं और इस सेशन को एक मेमेंटो भी उन्हें भेंट करने के लिए निवेदन है और उनका बहुत बहुत स्वागत है। इस सेशन को मॉडरेट करेंगे डॉक्टर नीरज तिवारी, वो इज़ असिस्टेंट प्रोफेसर इन नेशनल लॉ यूनिवर्सिटी, दिल्ली। उन्हें भी एक मेमेंटो और एक प्लान भेंट करके उनका भी हम इस अवसर पर अभिनंदन करते हैं, उनका फेलिसिटेशन। डॉक्टर राजीव मणि जी, सेक्रेटरी, डिपार्टमेंट ऑफ लीगल अफेयर्स की तरफ से, डिपार्टमेंट और मिनिस्ट्री की तरफ से, आप सबकी तरफ से इन सभी का और आप सभी का एक बार फिर से बहुत बहुत स्वागत अभिनंदन है। और देवियों सज्जनों, बहुत बहुत आभार डॉक्टर राजीव मणि जी का, ऑनरेबल सेक्रेटरी सर का। और मैं सीधे माइक्रोफोन हैंड ओवर करता हूँ डॉक्टर नीरज तिवारी जी को। एक रिक्वेस्ट ये हम ज़रूर करेंगे, बिकॉज वी आर ऑलरेडी रनिंग लेट, तो 45 मिनट्स में इस सेशन को कंक्लूड करेंगे, जैसे भी उन्होंने डिज़ाइन किया उस हिसाब से उसको कंडक्ट करेंगे, बट टाइम लिमिट विल बी 45 मिनट्स. थैंक यू वेरी मच. डॉक्टर नीरज तिवारी, प्लीज़.
Thank you, and very glad morning for everyone, and glad because we have already seen the tone being set in the inaugural session by so many thoughts coming in from all the legal luminaries. And this entire session is going to be for 45 minutes, so time is a little bit squeezed. And the pattern which we will follow is, we'll have some questions to the panelists, including the chair and co-chair. And then towards the end, we'll have some questions from the audience also. But before we begin with the questions, I would request the co-chair, Shri Mahesh Jethmalani ji, to give some opening remarks for this session on Bharatiya Nyaya Sanhita 2023.
Thank you, Neeraj ji. Distinguished members of this audience and distinguished members of this panel, it gives me great pleasure to be part of today's conference, and particularly this first technical session on the Bharatiya Nyaya Sanhita with all of you distinguished members, both in the audience and on the panel. I must state with some satisfaction that I have been involved in the most nascent stages of the conception of these three statutes, having been appointed as a member of the criminal law reform committees constituted by the Home Ministry in mid-2020. A lot of our work was done during the period of COVID. We had many sessions. Professor Bajpai, who chaired that committee, unfortunately is not present today, but he also put in some outstanding work, and we must remember his contribution. Many of these recommendations of the Criminal Law Reforms Committee have found their place in these three statutes. Now, if I was to very briefly describe the essence of the three statutes, I would say that the Bharatiya Nyaya Sanhita brings in some significant changes in substantive criminal law while retaining a substantial part of the Penal Code. The Bharatiya Nagarik Suraksha Sanhita introduces, on the other hand, sweeping changes in procedural law designed to galvanize India's justice system through the imposition of strict timelines for various stages and aspects of investigations, inquiries, trials, judgments, and appeals, as also by the introduction of liberal use of the electronic medium to enhance its efficacy. In addition, there are provisions to strengthen the integrity of investigations, make the criminal justice system victim-friendly, and afford fair procedure to persons accused of an offense. Minimal changes have been effected in the Bharatiya Sakshya Adhiniyam from the Indian Evidence Act, since the rules pertaining to admissibility and modes of proof of evidence have attained time-tested efficacy. However, with the technology boom, in the last 30 years or so, the electronic medium replaced the print one, and so rules of evidence have had to incorporate the admissibility and mode of proof of electronic evidence. For regular practitioners, I may state in passing, that Section 65B of the Evidence Act, which is so frequently invoked in modern times, has a new avatar now in Section 63 of the Adhiniyam, with a few additions to subsection 3. But today, it is, and in the first session, it is the Bharatiya Nyaya Sanhita with which we are now concerned in the first technical session. And so, to that statute, we must first turn.
Thank you, sir, for your opening remarks. So, I'll go with you only the first question of the day for this session. As we all know that all the three laws have been given an Indic name, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. So, what is really this transition which you can highlight from Dand to Nyaya, and what could be the underlying philosophy for this shift from Dand to Nyaya? If you can kindly underscore that and enlighten the gathering here about this switch from dand to nyaya in these laws.
The legislation has been given an Indic name, as you pointed out, part of your question. There is nothing objectionable in giving the new statute on substantive criminal law an Indic name. English is a colonial language, and while it may be difficult, at least at this stage, to replace it as a medium of discourse in courts, independent India needed to shed its colonial baggage, starting with colonial era legislation. Nobody in India spoke English till the East India Company, by royal charter, became first India's main trading partner and later a private colonial power. I welcome the new nomenclature of the statutes, although I am predominantly English speaking, because it heralds indigenous legislative output as opposed to alien imposed legislation. Now, the second part of your question. In discussing the philosophical rationale of the Bharatiya Nyaya Sanhita, it is first important to emphasize that the transition from dand to nyaya does not entail sweeping changes in the law that the Sanhita replaces, that is the IPC. There is a very nuanced shift between the Sanhita and the code, from a code that was predominantly concerned with the deterrence of crime through punishment or dand. We have moved to a Sanhita which, while retaining the deterrent aspect of the code, introduces provisions which focus on providing justice, nyaya, to all stakeholders. In a nutshell, this is what the Sanhita is designed to provide. It aims at providing safety and security to potential victims of crime. It introduces the reformative aspect of punishment as a community service, for instance, community service, and compensation to victims, as opposed to the singular pursuit of deterrence. The thrust of the code was to deter punishment, to deter commission of crime by deterrent punishment, going up to the death sentence. Here, on minor offenses, there's an attempt to move towards the reformist aspect of punishment. It replaces provision of the code. Now, this is very important, and later I'll come to it. It replaces provisions in the code securing the safety, in the Indian Penal Code, securing the safety of the colonial regime and its citizens from its colonized subjects, and it replaces this aspect with those enhancing security of a democratic state and its citizens from internal and external subversion, recognizes that women and children are most vulnerable to criminal activity, and introduces provisions for their security or suraksha, as also provides for sensitivity, sanvedanshilta, and compassion, karuna, for the differently abled sections of society. The preamble of the Sanhita, now this is important because this is not a sweeping change. The preamble of the Sanhita emphatically states that the act is not a complete break from the code, but a reformist exercise, amending provisions of a colonial past befitting to Indian independence, to an independent India. Now, this is what the preamble states, and that summarizes everything. The preamble states that the Sanhita is an act to consolidate. So it's a consolidating act. And most of the Indian Penal Code provisions, at least 80%, find their place in the Sanhita as well. So it's an act to consolidate and amend the provisions relating to offenses and for matters connected therewith on incidental thereto. Now, how the philosophy of the new statute, the Sanhita, the Nyaya Sanhita, plays out in practice, what are the provisions which seek to achieve its aims, is an answer to your 10th question, which is the last question, which you will pose to me, no doubt.
Yes, sir. So, what the answer is from your side about this nuance shift and about retaining majority of the provisions of IPC in the Bharatiya Nyaya Sanhita, but we also witness re-chapterization and reorganization to a great extent. Now, 420 is no more a 420 offense, is 318. 302 is 103, and 318 is in the enacted law, sir. It was in the bill 316, now it's 318, sir, in the law. Yes, sir. It was earlier bill. Yes, sir. I think we all have to gear up for the new law from 1st July to read the act and not the bill. So my next question is to Ms. Aishwarya Bhati, ma'am, that with this reorganization and re-chapterization, and also giving precedence to the offense against women and child, coming in a new chapter, immediately after chapter on incomplete offenses of abetment, criminal conspiracy and attempt, as the first chapter on substantive crime, how do you see that, how significant these changes are about the reorganization and re-chapterization first? And second, whether you think that this will make the job easier or difficult for all the individuals or citizens, practitioners, judges, academicians, students, everyone. So from these two counts, I would like to have your response on the reorganization and re-chapterization.
So Neeraj ji, I think my thoughts on this is, Chapter 5, that is the new law. It's divided into 5 parts, and all offenses with regard to offenses against women and child are put into this Chapter 5. And it comes immediately after the 4th chapter, which is incomplete offenses, so abetment, conspiracy, etc. But I think one significant thought that we always used to, I mean, it occurred to me, and I'm sure it occurred to many of my colleagues, that why does law have to be such a difficult formula that it is easily understandable to no one? It takes a lot of effort by practitioners of law, people who are involved in the justice delivery system, the dispensation of law, investigators. It takes a huge amount of reading, training, rigorous training for us to get a grasp of the law, and every time we have to go back to the bare act. Imagine how lost the citizen must be feeling, an ordinary citizen of the country. If you look at just the index of Chapter 5 of the new act, you will see that what was divided into, I think, 4 chapters in IPC. So it was Chapter 16, 20, 20A, and 22 of IPC has all been consolidated into Chapter 5, making it easily understandable for the common citizen for whom the law exists. The law, it's not, I mean, the justice delivery system may be giving all of us livelihoods, identities to stand in court. But let's never forget that the justice delivery system exists for dispensing justice to the citizen. And from the citizen perspective, it is very important for us to see that Chapter 5 exists in this manner. If you see the arrangement of offenses also, in Part A especially, which are the sexual offenses against women, what is very striking is all the judgments of the last 75 years, you know, so independent thought, Supreme Court, in the judgment of independent thought, Supreme Court said that you know, you can't treat, in the definition of rape, you can't treat a married woman who's minor different than a child. A child is a child, whether she's in marriage or she's outside of marriage. So understand from a common man's perspective, he had to go through IPC and what Supreme Court has held on that, and whether that law has been reversed, whether that law has been followed. Today you look at the law, you take out Chapter 5, the definition is very easy. And we have kept all the, so we have made changes in law which you know, in accordance with the judgments. We have kept all the reform that took place. Now these are areas which saw a lot of reform in the last 10 years or more. I'd say POXO was the first watershed moment where crimes against children became gender neutral, but then from then on, after Nirbhaya, post-Nirbhaya amendments, 2018 amendments, this area of law saw, substantive law saw a lot of amendment, and all that has been retained. So the expansive definitions, etc., have been retained. I feel that the majority of the change in the substantive law has happened by putting it all together in one chapter and divided into easily understandable parts, 5 parts.
As you rightly pointed out, ma'am, about the incorporation of many remarkable Supreme Court judgments from last 1 decade, and this has been very much acceptable phenomena of all 3 laws. So more than 24 of Supreme Court rulings have been incorporated or translated into the provisions of all 3 laws. So moving forward to another important segment of this very Bharatiya Nyaya Sanhita is about the reformative approach to the accused. Now, for the first time, we witnessed something like community service being introduced as a punishment form. My question is to Honorable Mr. Justice Anup Kumar Mendiatta, sir, that how do you see this form of punishment being introduced in the Bharatiya Nyaya Sanhita? Because the form is not prescribed, like what will be the nature of the community service. So how difficult it will be to monitor it? And secondly, is it really going to assist or help in reduction of recidivism in the society? So your thought on these 2 questions.
Well, taking the thought further, as Aishwarya pointed out, that it is not about changing the mere scheme of the act. It is from the perspective of a common citizen. Ultimately, the takers of this law are not only the advocates, judges, and the investigating agencies. The main takers are the citizens of this country. So it is for them to understand. Let me make it or put it very clearly. You see, though substantive changes have been brought out in all the 3 acts, but so far as BNS is concerned, you see, it is about introduction of additional offenses, re-scheming of the offenses, as well as putting out some changes by way of adding of punishments, reduction of punishments, and minimum statutory punishments. And one of the most reformative aspects is the community service which has been introduced. So as a common man, when you see what are the sections which even you will recollect, it is 302 murder, rash and negligent driving, cheating, 304B, 498A. Now these are like dowry death, harassment, and these. So you will always recollect these offenses actually by the ingredients. Ingredient means the broad headings of the offense. Merely because the sections change or the numbering changes, it doesn't matter even a bit. So from that perspective, when you view the entire law, you will find that it is by and large the same. The only purpose is how do we effect. The changes are there, very beneficial changes are there, but they are in the Code of Criminal Procedure. But when you again go back to Indian Evidence Act, you will find that the changes are minimal. So you have to look into all the 3 laws with the positive changes which have come, but ultimately it is the stakeholders who have to deliver it. You see, I would put up like these laws are the blood. You can't change the blood of a body. The phrases may be changed. The heart is the system which runs it. So system will keep on adjusting to how these laws operate, or how these changes to the new sections have to be adopted, or whatsoever beneficial provisions are there, how well they are adapted by the system. Now, coming back to the question which has been posed to me, I would observe that luckily for us, the chapter of punishments, which was earlier section 6 to 52A and was placed at chapter 2, now again finds referred in chapter 2 as section 4 to 13 in the new code, BNS. The earlier attempt had been from deterrent to retributive. We never had this provision earlier in the code, but now the change is from retributive to reformative. But at the same time, I would say that the entire scheme of the act doesn't point out that it has gone out to the reformative aspect. You see the enhancement of the sentences, the posing of minimum statutory sentencing pattern. It reflects that still the code, somewhere in the mindset and the spirit, adopts the earlier pattern which is there. But definitely, so far as this community service is concerned, it has been introduced for the first time. And what are the parameters? What the code gives us an indication or some sort of a guideline as to in what manner this service will actually have to be performed has been left to the discretion of the court and as to how actually it will be implemented and executed. Firstly, I would just specify as to the 6 offenses for which the community service, in fact, has been prescribed. These are the offenses relating to, since it's a new code, even I have to carry a note with me. So, first of the offenses is public servant unlawfully engaging in trade. This was an offense which is punishable with 1 year or fine or both. And in this particular section, which is now section 202 in the new code, the community service has been provided as an alternate. The second offense relates to non-appearance in response to a proclamation under section 84. This used to be earlier section 82 and 83 of the code, which the investigating agencies might be interested to know because earlier we were proceeding under section 82 and 83. And there was a distinction in section 82 with regard to the offenses wherein a person may be declared as a proclaimed offender and wherein the person may be declared as a proclaimed person. Now, the distinction between the two was made on the basis of specifying of the offenses in earlier section 82(4), wherein most of these offenses were punishable with imprisonment for a period of 10 years or more, barring 3 sections. This related to section 393, 436 relating to mischief, and section 402, wherein the punishment prescribed was for a period of 7 years or more. Now, this particular provision in the new act under 84(4) has been dealt with, and the distinction no longer exists as to specifying these sections wherein the declaration is to be made. So far as 84(4) is concerned, you will find that now a declaration can be made under the aforesaid section, but the punishment with reference to 84(4) is much more. But only the community service has been provided with reference to section 82(2), wherein the offense is punishable with less than 10 years. The third section in this respect, which has been introduced, is new section, it is 226. This is attempt to commit suicide to compel or restrain exercise of a legal process by a government servant. So this is important. Again, this is a section which is only punishable with imprisonment up to a period of 1 year. So herein also the community service has been provided. The next section relates to theft, which was earlier 378, 379, 380, and now it has been provided under section 303(2). So it is a change of sections, but basic ingredients of theft remain the same, except that snatching has been separately classified as an offense. Now herein I did find an anomaly, and which I would like to bring it to the law department. You see, so far as the offense is concerned, offense of theft is concerned, correlating it to the schedule of Code of Criminal Procedure, you will find that the offense is cognizable, non-bailable. But when we come to the second part of section 303(2), it is in respect of when the value of the property is up to less than 5,000, and upon return of the property, the sentence imposed could be by way of a community service. But with respect to 303 part 2, what comes to my notice, and this is prima facie my opinion, it may be rechecked by the department, the offense is classified as non-bailable, non-cognizable, bailable. I think this is one area which is likely to pose a lot of issues, because no separate provision is required to be provided in Schedule 1 in the classification of the Code of Criminal Procedure, now BNSS. So this is one part, I think so, which will be required to be looked into, lest the offenses relating to a theft of less than rupees 5,000 are tried and are treated as non-cognizable offenses. There is a distinction for the audience, for the information of audience, I may inform that cognizable and non-cognizable offenses under the Code of Criminal Procedure have been carved out differently because an investigation into a non-cognizable offense cannot be carried by the investigating agency without the permission of the concerned judicial magistrate. So this is one important part which will have to be looked into. Then there are two other offenses for which community service has been provided. This is misconduct in public by a drunken person. This earlier was punishable only with SI for 24 hours. And the last offense is relating to defamation. So if you see the scheme, community service, though it has been introduced only with regard to offenses which are punishable for imprisonment for a period of 1 year or so. And I hope that it is extended to heinous offenses. It is not that community service has been introduced for the first time. We had a legal base for introducing the community service in the infamous Sanjeev Nanda versus Union of India. There in the Honorable Apex Court for the first time, this is a case relating to a motor vehicular accident wherein the 6 persons were killed, and ultimately the trial court had convicted them under 304, which was set aside by the High Court as under 304A. But finally, the Apex Court restored the conviction under 304. Then, apart from the imprisonment undergone, the offender was required to pay a fine amount of 50 lakhs plus also undergo a community service. So this is the first case in our legislation. And the reason I say is that this can be extended to heinous offenses or somewhere offenses which are punishable up to 3 years, and that would go a long way. The other enactment wherein the provision has been made for the purpose of community services under the Juvenile Justice Act 2015. Therein also under section 18, there is a provision for community service. Now, actually, what purpose does a community service serve? Or what are the dangers relating to community services is actually about recidivism. Recidivism is that wherein the offender returns back to commit an offense.
I request the chair, Honorable Justice Medreta, to just conclude it.
So concluding, I have got 2 lines to say that before introduction, we'll have to look into is that what is the impact of recidivism. Though generally speaking, our offender should not return back for commission of a second offense, since it has been provided only for offenses relating to punishment up to 1 year by and large, what I perceive it. Thank you so much.
Thank you, sir. So I take the clue for the next question from the remarks made by the Honorable Chair of the day, for this session rather, that it is a shift from deterrence to retributive and from retributive to reformative, where in 6 offenses this new community service has been prescribed as an alternative form of punishment. But at the same time, we also witness that the punishment has also seen an increase in 41 offenses, 23 offenses mandatory minimum of punishment has been prescribed, and 83 offenses, amount of fine has been rationalized. So my next question is to Shri Praveen Kumarji on this very feature of the Bharatiya Nyaya Sanhita. How you see it alongside the community service, the enhancement of punishment of fine as well as imprisonment? Will it really act as a deterrent and discourage people from committing a crime? Or how do you see it, like we are going back to retribution or deterrence again?
First of all, thank you, sir, for inviting me in this conference. So now coming to your question. In my opinion, hello. Thank you, sir, for inviting me for this. Thank you, sir, for inviting me in this conference. So now coming to your question. So in my opinion, enhancement of imprisonment alone will not discourage the people from committing crime. As we all know, the punishment prescribed for murder, it is either death penalty or life imprisonment. Even then, murders are taking place. we have seen in Nirbhaya case that convicts were given stringent punishments. Even then, we are seeing daily rape cases are reported. So, in my opinion, the socio-economic condition and psychology of a person influences his criminal behavior. I would like to give you an illustration from Mahabharata. In Mahabharata, Duryodhana said, I know what is dharma, but I cannot practice it. He said, मुझे पता है धर्म क्या है, पर मैं उस पर चल नहीं सकता. So, likewise, there are people who know the consequences of the crime, but even then they commit crime. So, in my opinion, if a offender knows that he will be certainly caught, if the investigation is fair, if the charge sheets are filed without delay, and if the trials are concluded expeditiously, that will act as a deterrent. In our BNS, there are several provisions where punishment have been increased. For example, in section 106, which relates to death in an accident, and there are other sections also. Now, the time will tell its impact in reducing the crime. So lastly, I would like to refer to a latest judgment of the Supreme Court. This year, in January 2024, the Apex Court has delivered a landmark judgment. In that case, the title of the case is Dinesh Gupta versus State of UP. In that case, a complaint was filed by the complainant, which was false and frivolous. On that complaint, FIR was registered by the police of PS Gautam Budh Nagar, Noida. Charge sheet was filed. Cognizance was taken by the CJM, and accused were summoned. So out of the 7 accused persons, 2 filed a petition for quashing of the FIR and the summoning order. The Apex Court not only quashed the FIR, but imposed a fine of rupees 25 lakhs on the complainant for filing frivolous complaint. The judgment starts with a beautiful line, which I would like to quote. It says, that unscrupulous litigants should not be allowed to go scot-free, unquote. In my opinion, if heavy fines are imposed, that will certainly act as a detriment.
Thank you, sir. And I think you have rightly pointed out that deterrence alone may not be sufficient, but when it comes with certainty, it surely creates some deterrence, or rather deter people from committing crimes. And that is precisely what has been done in the BNSS, when the timeline and the technology, they go hand in hand to create that environment of certainty right there in BNSS in the procedural law, and leading to the less, I think, chances of people getting scot-free now due to the delay in the entire disposition of the case. Now, I have the next question on another very important, significant part of the Bharatiya Nyaya Sanhita, and that is with respect to the deletion and addition of crimes. So what has been experienced that in total 8 offenses have been deleted from the erstwhile IPC, and 20 offenses as specific offenses or subcategory offenses have been created by the Bharatiya Nyaya Sanhita. So my question is to Sri Raja Thakurji, that how do you see the new law striking a balance between over-criminalization and decriminalization?
Thank you, Dr. Neeraj. Well, talking about the criminality, as we know, that criminality is like a gunpowder lying harmless in the gun unless it is ignited by some external act. So actus reus. And there are various factors which then constitute the offense if it is actus reus is accompanied with the mens rea, and factors which may result into the commission of the offenses have got moral grounds, greed, anger, jealousy, temptations, economic needs, etc., condition, hunger, etc. The offenses which are there in the Indian Penal Code drafted way back in 1860, particularly the general offenses under the offenses against the human body, offenses against the state, offenses against the property, the major offenses are so strong and so perfect that it was not found necessary to delete any of them. Nonetheless, there are certain major changes, certain major offenses which have been deleted in this particular thing. Now, we have these 4 major offenses, I can say. One is that section 377, that is unnatural offense. As we know that Supreme Court has already watered it down, and therefore that has been deleted. Then the offense of adultery has also been deleted. That is after the Joseph Shines versus Union of India, it was struck down, and naturally that adultery now has gone out of the statute book. One more important is the attempt to commit murder, that is 309 originally of the Indian Penal Code, because of the Mental Health Care Act. So that is also deleted. However, to strike the balance, I must add, there is a new provision which has been made. The attempt to commit suicide to compel or restrain a public servant from performing his public duty. This has been considered to be yet an offense and is made punishable under the new law. So that is a welcome addition into the offenses. Then apart from that, I must make a mention about section 124A, that is sedition. That sedition has also been deleted because it was something which was against the British Raj. Anything which was being done, or you can say acting against the government, that was considered. Now that has been, so to say, substituted by the new section 152, and which is a welcome this thing. It's a thing which was a necessity. It is necessary to control the particular activities which are affecting the security, integrity, or unity, integrity and security of the state. And therefore, that section addition of 152 is a well taken step for the purpose of controlling the menace which may be done by this. Now, so far as over-criminalization is concerned, as we have seen that a number of cases in which the punishments are enhanced. But particularly, I must mention about one provision which has been made, which according to me is a very nice provision. That is in respect of the hit and run cases. When in the motor accidents cases, most of the times if the person is knocked down, he dies, and the driver runs away without reporting the matter. So that offense has been taken care of under section 106 of the BNS, which is now substituted 304A. For rash and negligent act, the punishment is enhanced to 10 years. And for the purpose of the rash and negligent act, or causing death by rash and negligent act, the punishment for the doctors, because there may be a death at the hands of a medical professional. So for a medical professional, the punishment is only 2 years and is not enhanced as is enhanced in respect of the offenses against the drivers committing the offenses so far as road accidents, etc. are concerned. Then there is also a special note is taken off for enhancement of the penalty in respect where in causing the grievous hurt, a person is made to live into vegetative state. In that case also, the punishment has been enhanced under 117(3) to 10 years. That shall not be less than 10 years is what the, and which may extend to the imprisonment for remainder of that person's life. So that is a kind of punishment which reminds us about the retributive, because a person is suffering for his whole life. That's why the offender also should be given the punishment of to the remainder of his life. These are some of the changes which have been brought into these offenses.
Thank you, sir. So, one of the changes, as you pointed out, and rightly so, that 152 has been introduced and 124 stands deleted. But another important section which has been introduced is section 69. And my question is to Ms. Aishwarya Bhati ma'am about section 69, which criminalizes the act of sexual intercourse by a man with a woman on false promise of marriage. How do you see this new offense being introduced in the Bharatiya Nyaya Sanhita? What could be the probable social impact of this new offense on the society, if you can throw some light on that?
So, Neeraj, I know we are running short of time, so this is not a new provision. This was already criminalized and it was part of rape. That is how it was read. The Supreme Court judgments made it very clear that false promise to marry, if intention from the beginning is to defraud, then it comes under rape. I think this is a very significant step to segregate it out of rape, because false promise, now it's not false promise to marry. Now the definition says it is deceit. So if there is a deceit in promise, and that deceit, the explanation says it could be false promise of employment, promotion, marrying by suppressing identity, etc. So deceit is the focus. Segregating it out of a regular, a heinous rape, and prescribing a lower punishment. So the punishment here is up to 10 years. So I think this is very significant, because false promise to marry cannot be equated with other cases of rape, which has to be kept separate, and that the Supreme Court mandate has been kept into consideration by saying without any intention of fulfilling the same. So if there is deceit, see, there is a fine line that has to be drawn. Live-in relationships is the norm today. It's not an exception in the society anymore. And the statistics shows that there is a large number of complaints that are lodged with regard to Section 376 complaints, which are actually promised to marry. So we are a developing society, and these are, one of my favorite lines from a Constitution bench judgment is that fundamental rights are like empty vessels. Every generation has to fill them with its own wisdom. So we are, in transition, our society also has to find a balance. This is the balance, though there is a little criticism about not including marital rape. That is the way the society has to progress, but are we ready for it today? Actually, as per me, ultimately, rape has to be gender neutral. But are we ready for it today? So these are progressive steps that have been made, and I'm sure this will pave the way for a better progression in these areas while balancing out the requirements of the society.
I think very apt answer given by you to this very question, which was very tricky actually for many. So moving forward, and because of the very much lack of time on my part, I have been asked to conclude it. But before we conclude, actually, we'll have one question posed to Sri Mahesh Jethmalani ji, and then we'll go for a couple of questions from the audience, and then finally a concluding remark by the chair. So my question to you is about the very object of this new law. How much this new law, Bharatiya Nyaya Sanhita, has achieved its object of decolonization? How do you see this new law achieving that end?
Hello. There is substantial change. There is a very, very ideologically contrived break from colonial legislation. This was definitely required, and I'll give you a few concrete examples, right? Sedition is one. Sedition is certainly, look, you cannot enjoy your fundamental rights under the Constitution unless you have security of the state, right? Security comes before enjoyment of any rights. So there's a strong emphasis for security of the state in this. Now, the chief section where this has been brought about is 124A, which Mr. Thackeray rightly pointed out. He welcomed it, and I also welcome it. The shift is from the mindset of the colonial masters who said that anything which excites disaffection against the government of the day, it was to protect the colonial regime from its colonial subjects. It was the government of the day. Now there's a real shift here in emphasis. The new act says, 152, that whoever excites disaffection against the stability and integrity and unity of India, it is now the Indian state against whom you cannot excite disaffection, not the government of the day. 124A, when it was used, it was misused. When you had these instances of advocacy of secession and all that, it was misused because it was the government of the day, as per the provisions. So that's a very welcome change now. What you are trying to do is nip in the bud Fissiparist tendencies, secessionism, external and internal rebellion, Northeast India, the Khalistan movement, ISI-inspired terrorist attacks cross-border. These required 124A. And 124A in its new avatar, 152, answers that problem very effectively. All right. Now, equally, the new Sanhita also brings in the offenses of terrorism and organized crime. Organized crime is a menace. Maharashtra, where I come from, first detected it. We had the first Makhoka Act. Right? Now it has become a nationwide problem. So also this act now brings in 111 and 113, I think, which in the new Sanhita punishes terrorism and organized crime. Right? Now, fourth, very important. So all these are all security of the state. That's the thrust. We are now trying to protect citizens so that they can enjoy their constitutional rights. Right? As I said, first security, then rights. Right? Now, very important and is what Aishwarya concentrated a lot on, which is chapter 5 of the new act. Right? Now, that's a refreshing change. The old colonial legislation used to treat women as chattels. It's an 1860 legislation. Right? Women had no right to vote at that time. They had no right to stand in elections. And they were basically, their domicile followed those of their husbands. Right? They were appendages, women, under the colonial. Now, this act furthers, it gives further impetus to what Prime Minister Modi is trying to do. So it started with dignity for women, with the Shauchalaya welfare measures, open defecation. First, dignity. Then, you gave them reservation. So you gave them political rights. Today, women are at the forefront of every profession. Armed forces, the Coastal Guard, everywhere. This part 5, recognizing offenses against the women, right? Under a separate chapter, under the Indian Penal Code, it was scattered. You had rape under offenses against the human body. Chapter 5 recognizes the need for protection of women, for them to now enjoy the other rights given to them. Securitizing and protection of women from male violence, domestic violence, rape, sexual assault, etc., is a precondition. So this is another move away, a drastic shift away from colonial mindsets where women were not given that prime importance. You have a whole chapter dedicated to women only, offenses against women and children. Now, I want to show you just two examples of 75 years, how people have let grass grow under their feet. And I mean, there was nothing done. People in Parliament must have been completely, deaf to the legislations in the most important area of criminal law. All right, now, these are two things which people must understand as to what happened. And they are both to do with abetment, right? Now, abetting murder in India. Okay? This was 108A. This is how it read. it's an illustration to 108A, right? It says this: A in India instigates B. Now note the next part. A in India instigates B, a foreigner in Goa. Goa got independence in 1961 from the Portuguese. And nobody in the previous regimes, except Prime Minister Modi's government, for 75 years, this has been on the statute books. So now now the 108, which is now section 47, reads, A in India instigates B, a foreigner in country X, right? To commit a murder in that country, A is guilty of abetting murder. So this is the kind of legislative neglect there was, that on your statute books you had the shame of not acknowledging that Goa was a part of India since 61. Now, one more thing, right? This is another colonial legacy consigned to the dustbins of history. Right? It's now incorporated in section 48 of the Sanhita, right? It creates a new offense: abetment outside India for offenses in India. This is a reverse situation, right? The illustration to section 48 makes it clear why the acts prescribed as an offense by section 48 did not find favor with the British. British never had this section. Why? Because if a section corresponding to new section 48 in the Sanhita existed in the IPC, a British native instigating someone to commit a murder in India, which would be half the rulers of England in those days, right? Committed a murder and he would be liable for punishment in India for abetting murder. We have taken this out now and put a new section in. So this is the kind of legislative, I would say, deep sleep previous regimes had gone into.
Thank you, sir.
I can only
can we
take
have
1 minute.
Quick remarks by Raja, sir, on the two crimes, terrorist act and organized crime being introduced in the general criminal law.
Right. So far as the organized crime is concerned, it's a welcome move, because organized crime is not faced only in this state of Maharashtra, Gujarat or Delhi, but there are some 5-6 states in which the makoka is there. But it's a common phenomenon in all the entire country. Therefore, it was necessary to curb those organized crime syndicate activities. The offense was necessary. So only one thing is certain, that so far as the terrorist act is concerned, I think that there would be a conflict, because there is already a central legislation. Under the Unlawful Activities Prevention Act, the definition of the terrorist act is the same verbatim as the definition of organized crime, which is given under the Sanhita. So I do not understand there is going to be some conflict, because there are certain protections which are given under the UAPA Act, like there has to be sanction, etc. No such protection is given under the Sanhita. And therefore, there will be a lot of litigation, because the powers are also ultimately given to the officer of the rank of Deputy Superintendent of Police to decide whether an offense of terrorist act is to be registered under the BNS or it is to be registered under the UAPA. Such a serious offense affecting the national level or the security of the country, such an offense cannot be left to the discretion of an officer of the rank of SP. That is my humble this thing.
Thank you, sir. And before we conclude the session, we can have a couple of questions, quick questions from the audience. If anyone would like to have any questions to any of the panelists or the chair or co-chair. Yes. Can someone please pass on the mic to the audience? Or unless your voice is loud enough to be heard by the entire.
Actually, I couldn't understand. Anti-social peace crime. There are provisions to deal with this in the new law regime. Actually, I wanted to know what is the aspect about. Learned attorney used that word. Actually, I wanted to know what is that aspect all about. Anti-social peace crime.
I think you'll have to ask the Attorney General that question.
I think for that matter, if we see section 111, which talks about the petty organized crime, it has got wide inclusion. it ranges from taking up the offenses such as land grabbing, cyber crime, trafficking of persons, drugs, weapons, illicit goods of services, trafficking for prostitution, etc. These are also taken as the organized crimes. And these type of crimes would probably be coming under the category.
Is anyone else? No, no.
So good afternoon.
On the front.
I'm Dr. Tushita, and I'm an academician. So my question is on the absence of the important aspect that was covered in Section 377 in the IPC, and which is now missing in the BNS. No doubt, the Supreme Court has read down partly 377, which was related to unnatural offenses, but the aspect which is still retained in the Penal Code has been completely left out in the BNS. I believe that is an aspect that needed protection, particularly for adult non-consenting individuals and citizens. Please give me your response on that. Thank you.
Aishwarya ma'am, yes.
Well, I think, if the Supreme Court judgment already took away the consensual aspect of it, what remains can already be addressed in the rest of the chapters. But there are two things I must draw your attention to. In chapter 5, the fifth part, which deals with offenses against child, two of the sections, section 96 and 99, have been made gender neutral. So it covers all child. Now, I see your point. So that aspect of 377, where it is non-consensual, but as a sexual activity, it is not punished. But the punishment there in any case was up to 2 years. And there is punishment prescribed for hurt, for assault. All that will cover these aspects in any case.
So, so we'll have one last question before we wind up the session. And who's that lucky person in? So you can ask the questions to anyone.
Mr. Jetmalani ji, I pointed out before the parliamentary committee when my evidence was recorded, when discussion was going on this issue.
I recall you seeing you there, yes.
Yeah. So why there is no time limit for the court to take cognizance? Other things you have fixed the time limit. But for taking cognizance of the offense, there is no time limit.
All right. That is a matter for the Bharatiya Nagarik Suraksha Sanhita. And I think that is covered. So you'll have to wait. I don't want to trespass because the time is also short.
Yes. Well,
we can discuss it privately, but
I would like to comment on it. You see, so far as the cognizance, the provision which is there for default bail under section 167(2) is only with regard to conclusion of the investigation within a time period and filing of the charge sheet. But you see, so far as the aspect of taking of cognizance is concerned, that primarily concerned with the court. So it cannot be said that either of the parties stands prejudiced in case it is taken thereafter.
I think BNSS has something to do with it.
Yes.
Just see. Not on this, not on cognizance.
So cognizance, there is no timeline as such.
You may be right.
Yes. So with the permission of chair and co-chair, I think we should wind up this session now with your final concluding remark by the chair on this.
Thank you so much for giving such a patient hearing. And I would say that it has really been a brainstorming session. What I would just like to clarify is that with reference to 106(2), with regard to which my colleague had referred, I think that particular part stands stayed. And so far as the criminal prosecution in relation to medical practitioners is concerned, you see, the governing principle goes in accordance with Jacob Matthew 2005 Supreme Court case, wherein they have made a distinction between the criminal negligence in medical cases and civil negligence. And primarily that is the reason what I feel, that though they have enhanced the sentence for death due to rash and negligent act to 5 years in case of, generally when we say, except for the deaths which are caused during the medical procedure. So that is one clarification I would like to make. So far as the offense of sedition, as it has been pointed out, I would say that it has been welcome step. It has been in line with the statement of the government before the Honorable Supreme Court of India, though the earlier definition and the new definition of sedition under 152 would still be subject to some litigation, since the term subversive activities used therein or for the purpose of encouraging, there is a particular term which is used that is with reference to encouraging the feelings of separatist activity. So these are the two words which I think that since these are broad-based, they may be challenged on the point of Shreya Singhal, wherein section 66A was challenged on similar grounds, but otherwise this is a section which is perfect, which specifies all the grounds on the which the activity may amount to a secessionist activity. So these are my concluding remarks. Thank you once again to all of you.
Thank you, sir. And with this, we really thank all the panelists and chair, co-chair, and everyone sitting in this hall and contributed to our learning and understanding on the new criminal law, which is the Bharatiya Nyaya Sanhita, going to be implemented from 1st of July. So with this, I thank everyone, and we break for the lunch and reassemble what time? No? You'll have another session? Okay, you will further be tortured. How do you know it's 1st of July? We don't know it's 1st of July. Notification has come, sir? It's already been notified? Yes, sir. It's notified. Notified, but it will be implemented from 1st July. Implemented from 1st of July. Effective date is 1st of July. After the elections, everybody is taking it for granted, same government will do it. Could be, sir. There is no dispute on that. Thank you.
Thank you very much. I will request all of you to please remain seated because we will move on to the next session, technical session, जो दूसरा हमारा है भारतीय नागरिक संहिता, नागरिक सुरक्षा संहिता 2023, and again we will try to wind up that session also in stipulated time, but let's see. हमने अभी भी कोशिश की थी कि थोड़ा समय से कुछ चीज़ों को हम मैनेज कर पाएं. But anyway, thank you very much, Dr. Neeraj Tiwari, for moderating the session. We are grateful to Honorable Mr. Justice Anup Kumar Mehdiratna Sahab, Honorable Judge, Delhi High Court, who chaired the session. Shri Mahesh Jethmalani ji, Member of Parliament, Senior Advocate, Supreme Court of India, who co-chaired the session. Thank you very much, sir. So, the panelist, Aishwarya Bhati ji, Learned Additional Solicitor General, Supreme Court of India. Then we had Praveen Kumar ji, Principal District and Sessions Judge, Delhi. And Raja Thakre ji, Special Public Prosecutor and Advocate, Bombay High Court. And this session was moderated by Dr. Neeraj Tiwari, Assistant Professor, National Law University, Delhi. ये podium का mic on करें, please. Console. Podium का mic on कीजिए. So now we move on to the next technical session that is based on Bharatiya Nagarik Suraksha Sanhita 2023, ladies and gentlemen. And it will replace the 1973 Code of Criminal Procedure. उसको replace करेगा ये जो नया कानून है भारतीय नागरिक सुरक्षा संहिता 2023. बहुत important इसके aspects हैं और especially इसमें जो हमारे जुडिशियल ऑफिसर्स हैं, पब्लिक प्रोसिक्यूटर्स हैं, पुलिस ऑफिसर्स हैं, उनका इसके संदर्भ में बदले हुए भूमिका किस तरह की होगी, क्या जिम्मेदारियां होंगी, रखी गई हैं जो आज के टाइम के बहुत अनुरूप हैं और बहुत इम्पॉर्टेंट है. सो वी आर गोइंग टू स्टार्ट द नेक्स्ट टेक्निकल सेशन एंड इन दिस सेशन we are privileged to have Honorable Mr. Justice Ashwini Kumar Mishra ji, Honorable Judge, Allahabad High Court, who will chairing the session. Co-chair will be Honorable Mr. Justice K.N. Shankaran, retired and now member of Law Commission of India. The panelist will be Vikramjit Banerjee, Shri Vikramjit Banerjee, Learned Additional Solicitor General, Supreme Court of India. Shri Vinod Kumar ji, Principal District and Sessions Judge, Delhi. Shri D.C. Jain, IPS retired, former Special Director, Central Bureau of Investigation. Mr. Praveen Kumar, IPS, Additional Director, Intelligence Bureau, Government of India. And Shri E. Chandrasekharan, Advocate, Madras High Court, These will be the panelists in this session, and this will be moderated by Dr. Upma Gautam, Associate Professor, Guru Gobind Singh Indraprasth University, Delhi. So I will request all of you to please be seated, and let's participate in this session also. After that, we will have a lunch break. So I will request all of you to please take your seats. So I will request Honorable Mr. Justice Ashwini Kumar Mishra ji, Judge Allahabad High Court, to please take his seat on the stage and chair the session. Co-chair will be Honorable Mr. Justice K.T. Shankaran, retired member, Law Commission of India, और सभी panelists. Vikramjit Banerjee ji, learned Additional Solicitor General, Supreme Court of India. Vinod Kumar ji, Principal District Session Judge, Delhi. DC Jain Sahab, IPS retired, former Special Director, Central Bureau of Investigation. Praveen Kumar, IPS. Praveen Kumar ji, Additional Director, Intelligence Bureau, Government of India. And E. Chandrasekharan ji, Advocate, Madras High Court. And the moderator is Dr. Upma Gautam. एक बार आप सबकी जोरदार तालियों के साथ, with a huge round of applause, let's welcome the Honorable Chair, Co-Chair, and all the panelists in this session. And before we start the deliberations, I will request Dr. Rajiv Mani ji, Honorable Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, to felicitate and welcome the Honorable Chair, Co-Chair, and the panelists. Dr. Rajiv Mani ji से मैं request करूँगा, Honorable Secretary Sir, Department of Legal Affairs, कि वो आएँ और इस सेशन में इस सेशन को चेयर कर रहे हैं Honorable Mr. Justice Ashwini Kumar Mishra जी को, Honorable Judge Allahabad High Court. सबसे पहले उन्हें एक प्लांट और एक मेमेंटो भेंट करके उनका फेलिसिटेशन, उनका स्वागत, उनका अभिनंदन करेंगे. और मैं रिक्वेस्ट आप सबसे करूंगा, ये हमारा लंच के पहले का लास्ट सेशन है. आफ्टर दिस वी विल हैव अ ब्रेक फॉर द लंच, सो प्लीज़ बी सीटेड. और इस सेशन में भी आपकी मौजूदगी, आपकी प्रेजेंस बहुत इंपॉर्टेंट होगी. ऑडिटोरियम से बाहर जो लोग हैं उनसे भी मैं रिक्वेस्ट करूंगा, क्योंकि हमारी आवाज़ वहाँ तक पहुँच रही है, तो मैं सभी से रिक्वेस्ट करूंगा, जितने ज़्यादा से ज़्यादा लोग होंगे इस हॉल में डिलिब्रेशंस को सुनेंगे और हम सभी उसके साथ जुड़े हैं. पूरे इस जो सिस्टम है जस्टिस डिलीवरी का, उसके साथ हम किसी न किसी भूमिका में हैं, इसीलिए हम यहाँ हैं. तो इसलिए ये ज़रूरी होगा कि सब लोग यहाँ इस पैनल डिस्कशंस का हिस्सा बने, उसको विटनेस करें, उनकी डिलिब्रेशंस को सुने, और उसका लाभ आपको ही नहीं मिलेगा, सोसाइटी को और इस देश को मिलेगा. दैट इज़ वाई इट इज़ वेरी इंपॉर्टेंट. और अब समय है ऑनरेबल मिस्टर जस्टिस अश्विनी कुमार मिश्रा जी, जज इलाहाबाद हाई कोर्ट, जो सेशन को चेयर करेंगे. सबसे पहले उनको ऑनर करने के लिए, उनका फेलिसिटेशन करने के लिए मैं रिक्वेस्ट करूंगा डॉक्टर राजीव मणि जी, सेक्रेटरी डिपार्टमेंट ऑफ लीगल अफेयर्स, कि वो प्लांट और मेमेंटो भेंट करके ऑनरेबल मिस्टर जस्टिस अश्विनी कुमार मिश्रा जी को यहाँ पर उनका वेलकम करें, उनका स्वागत करें. और स्वाभाविक सी बात है कि इस वेलकम में, फेलिसिटेशन में आपकी तालियों की बड़ी भूमिका होगी. थैंक यू वेरी मच सर फॉर ज्वाइनिंग अस एंड फॉर एक्सेप्टिंग द रिक्वेस्ट टू चेयर दिस सेशन. एक मेमेंटो भी है, उसे भी स्वीकार करेंगे. आई विल रिक्वेस्ट डॉक्टर राजीव मणि जी to felicitate and honor and welcome co-chair of the session, Honorable Mr. Justice K.T. Shankaran, retired, who is a member Law Commission of India. उनका भी इस अवसर पर बहुत बहुत स्वागत, अभिनंदन है इस सेशन में, और इस सेशन को वो को-चेयर करेंगे. हमारे लिए सौभाग्य की बात है. हमारे इस सेशन में जो पैनलिस्ट हैं, श्री विक्रमजीत बैनर्जी, लर्नेड एडिशनल सोलिसिटर जनरल, सुप्रीम कोर्ट ऑफ इंडिया, उनको बुके, उनको प्लांट और मेमेंटो भेंट करके उनको भी इस सेशन की शुरुआत में हम वेलकम कर रहे हैं आपके तालियों के साथ. विच ए ह्यूज राउंड ऑफ अप्लॉज लेडीज एंड जेंटलमैन, अश्विनी विक्रमजीत बैनर्जी. वी हैव हियर इन दिस पैनल श्री विनोद कुमार जी, वो इज़ प्रिंसिपल डिस्ट्रिक्ट एंड सेशंस जज दिल्ली. डॉक्टर राजीव मणि जी से रिक्वेस्ट करूंगा कि विनोद कुमार जी को भी यहाँ पर प्लांट और मेमेंटो भेंट करके उनका भी स्वागत करेंगे इस मौके पर. इस सेशन में उनकी भी उपस्थिति है. In this session, we also have Shri D.C. Jain Sahab, IPS retired. He is a former Special Director, Central Bureau of Investigation. Part of this panel, I will request Dr. Rajimani to welcome Mr. D.C. Jain with the plant and also presenting a memento to him. D.C. Jain Sahab, बहुत-बहुत स्वागत है आपका. We also have Praveen Kumar Ji, IPS, who is Additional Director, Intelligence Bureau, Government of India, part of this panel. So I will request Dr. Rajimani Ji to welcome and present a plant and memento to Praveen Kumar Ji, IPS, Additional Director, Intelligence Bureau, Government of India. Shri E. Chandrasekharan Ji, Advocate, Madras High Court. He is also part of this panel and we welcome him. I will request Dr. Rajimani Ji to present plant and memento and felicitate Shri E. Chandrasekharan Ji, Advocate, Madras High Court. Thanks for joining us and being part of this panel. And this session is going to be moderated by Dr. Upma Gautam Ji, Associate Professor, Guru Gobind Singh Indraprasth University, Delhi. उन्हें भी एक मेमेंटो और एक प्लांट भेंट करके उनका भी इस मौके पर हम स्वागत अभिनंदन करना चाहते हैं. Dr. Upma Gautam. Thank you, Dr. Rajimani sir, Secretary sir. Or now microphone. I'm going to hand over to Dr. Upma Gautam with the request to please conclude in 45 minutes. Thank you very much.
A very good afternoon to all, and to my esteemed panelists. I have been given a very difficult task to sum up in very limited time. I think this session is going to be summed up in the least time, though the major changes, the most changes are being made in this act. So it requires more time to deliberate upon, but many important aspects are being already touched upon in inaugural session. So we'll take the lead from there, and I'll not take much of the time, and I'll just supplement in between. So, sir, my first question is to Honorable Mr. Justice Ashwini Kumar Mishra, sir. Sir, a lot has been said about the procedures. Yeah.
Chairman has done is requested in the group, requested all of us to focus on the particular topic. So we answered that I'll be concentrating on this topic. So that time can be saved, it will not be have repetition. So first of all, we'll complete that, then we'll come to question.
Okay. But
that will be better, otherwise the chairman's words will have no meaning.
No, I will invite sir with opening remarks. I'm just about to invite him for his opening remarks, and then we will open up for the questions. So, taking the lead from there, sir, I will request you to kindly give the opening remarks and to highlight the key areas. Thank you, sir.
Very good afternoon to all of you. Sometimes it happens, we have to rush through because when we have very eloquent speakers in the previous sessions and many of the discussions, basic topics remain the same, then time overlaps or the difficulties of this time at times occur. Now, so far as this present session is concerned, we are this discussion is with regard to the second law, which replaces the CRPC, that is Bharatiya Nagarik Suraksha Sanhita. Some discussion about this law has already, in the first session, in the inaugural session, there were references to this legislation. See, every society, and ours is a very ancient civilization, has its quest for justice, particularly in our context. If you take it right from the ancient times, the concept of Ram Raj, we always endeavored to have a just society where the rights of people are respected. The society works as a holistic setup in which everybody gets his due without affecting the others. Now, we had the colonial times, the legislations which came, and criminal justice system for a very long has had basically 3 legislations which we all know. That is the IPC, the CRPC, and the Evidence Act. Now, the need to undergo a drastic change was being felt because different sections of the society possibly thought that the criminal justice system is not able to deliver what is expected of a just society. The reasons are many. The legal system, because since 1950, when we gave to ourselves the Indian Constitution with the promise to provide justice, social, political, economic to all, we were for almost 75 years now endeavoring with the legislations coming off and on, amendments coming to address the problems which were being faced by the system. But now, I think the Parliament has realized that there has to be an Indianization of the criminal justice system while retaining the time-tested provisions or the system which actually serves the cause of justice. There is some misgiving when people say that we are having new laws, and people say, no, many of the provisions are retained. Yes, many of the provisions are retained. That is for a reason. The reason is that we are in it's the same constitutional setup which continues, and therefore the provisions which adequately subserves the larger objective of providing justice have to be retained. What has to be addressed is the areas of concern. Now, it is in that context. See, in 1975, Justice Krishna Iyer, his lordship's, in a 1975 judgment said that procedure is the handmaid of justice. So, the ultimate object is to ensure justice. But the procedure, when it becomes very cumbersome, it becomes very tiring, it becomes such that it is failing to provide much of the ultimate justice which is expected of the system, then some thought has to be given, and I think that is what has been done in this particular provision, in this particular case. I'll start with some of the changes because, in fact, this is one subject we were just deliberating, and we all understand that possibly a few days discussion, if we take up each provision or the ramifications which we have, we'll be requiring a lot more time. And then, therefore, in one particular session to sum up, it is always a difficult thing. But I'll try to briefly place what are the major aspects that have been brought in. The definition clause has been, is the first provision which has to be noticed. It says, audio, video, electronic means has been defined for the first time. It has been defined to include use of communication devices for the purpose of video conferencing, recording processes like identification, search, seizure, as well as transmission of electronic communication, and for such other purposes as may be provided by the rules. Electronic communication has also been defined. See what is happening in most of these matters, and I'll say it from my own experience at the bar and also with some year experience on the bench. What is actually happening in courts is, number one, at the first stage, when somebody goes to lodge an FIR, there are delays. It was addressed, and this particular aspect was taken note of. That's where the first thing starts. This has been attempted to be addressed by bringing in a provision of zero FIR. Wherever you want, you can lodge an FIR. The second thing is that when the investigation begins, at that stage, either the accused is not available, the investigation becomes so difficult, you want to serve, summons have to be served, service has to take place. There's so many aspects at every stage, there is a delay. Now, therefore, the technology is sought to be brought in. And the first provision which I would like to refer to, although Honorable the Chief Justice of India also referred to it, is clause 100, section 105, which provides for recording of search and seizure through audio, video, electronic means. Now, this is a provision which was not there in the CRPC and has come for the first time in the BNSS. Then there is also a provision for search by police officers. Now, these are provisions which have very, very far-reaching consequences. It has far-reaching consequences to ensure that the investigation concludes expeditiously. At the same time, the rights of the persons have to be taken care of. So section 1 says the search shall be conducted through audio, video, electronic means, preferably by mobile phone. Now, on this, I would like to say that possibly the necessity to have the rules framed, in what manner these provisions are going to be implemented. We are going to introduce this particular provision from 1st of July. There has to be a lot of thought given to the rule making, how these things are going to be implemented. It will definitely cut short the delays aspect, but how are we going to do it has to be given a more serious thought. Then the procedure for investigation, which is there under section 176, this also says that option is there to record statement by any audio, video, electronic means, preferably cell phone. These are all provisions which will definitely cut short on the investigation aspect. Then there are also provisions for recording of confessions and statements. This also, there is a provision that the proceedings have to be videographed, audio, video means have to be, but this was something which were more or less earlier also in the provision. 164(5)(a) was already brought in. Then the test identification parade, recording of confession. These are all provisions which have been brought in under the BNSS, which have far-reaching consequences, which hopefully would take care of much of the delays concerned, and some more thought has to be given to it with regard to the manner in which these provisions have to be enforced. Now, the technological compatibility for issue of service and summons are there. Technological compatibility and use of electronic means in investigation and trial. Then the offenses committed by means of electronic communication, that is also recognized. Service of summons on corporate bodies and other persons by electronic means, though this is something which is going to be of great help. But possibly one of the areas which will have to be seen is that how this service will be treated as sufficient. Like in WhatsApp, we have that you send the summons. Now the question is that whether there are 2 tick marks, blue tick marks, in what manner the sufficiency of service will have to be treated. All those are aspects which will have to be thought over. Then zero FIR, I have already said. There is also a provision of preliminary inquiry, which has now been brought in. And there possibly the earlier judgment of the Supreme Court in Priyanka Srivastava is also there. So these are, then the protection of interest of victims is one very major area which is a very, very welcome move. It also enables that the withdrawal of prosecution, etc., also cannot be without the consent and the knowledge of the person concerned. At least the information part is there. Then the supply of copies of police report and other documents. There has to be the progress of investigation has to be updated. And this is something which is a very, very welcome provision, because otherwise a man who's actually the victim, he doesn't know. He has no concern in whatever is happening. So the responsibility that he has to be kept informed, these are very, very welcome changes. Then there is also a requirement of a district directorate of prosecution. This is something which is a very welcome provision which has been brought in. It will have to be implemented. How quickly we can do it, that is something which has to be. Then the provisions of discharge in summons case. This was not there earlier. This has been brought in. Then this will be, in a way, provisions. In fact, notice to prospective accused is something which has been brought in for the first time. And this would apparently contain frivolous prosecution, but may also end up causing delays. That is something which is, as in due course of time, possibly we will understand. Then in serious cases, the provision of proceeding against the accused in absentia. See, I, as a judge, often I'm surprised by the fact that while we are hearing appeal, criminal appeal, some of the persons are still absconding. And what it has happened, in fact, in some of the matters, I've experienced it myself. The same set of witnesses in one set of trial, in the same matter, come up, depose in one manner, and when the trial is segregated for the other set of persons who are absconding, later on, they come out with a different version. So these are complications which possibly will be taken care of, especially in serious offenses. Then there is this videography aspect. I've already said that there has to be guidelines provided. There are, in fact, I had taken note of some of the provisions which I would have loved to state, but I'm conscious of the time constraints. And we have very eminent panelists with us. I think they will be addressing different aspects of the matter. I'll just say that this is just a beginning. My understanding is it's a welcome change, a new beginning. It requires a lot of thought to be given as to how these provisions are actually going to be implemented. Honorable Chief Justice of India, in the first session, His Lordship rightly observed that there has to be a change in mindset. But we have to be acquainted, we have to be made aware of what the provisions are. How those provisions will be implemented. Merely providing for a particular course of action is one thing. How it is to be implemented, it has to be thought through. The necessary rules have to be brought in. People have to be made aware so that the implementation, when actually starts, we are able to reap the harvest of what is intended by this legislation. I'll conclude at this. I'm there, and although I would have loved to take a little longer and in a more orderly fashion address you on all these aspects. But since the proceedings have already begun, we are getting a little late. I would look forward to more such opportunities when we can possibly one day session only for BNSS would be something which I would suggest that should be there. Thank you.
Thank you, Your Lordship. Yes. Now, I would like to invite Justice K.T. Shankaran to talk about briefly on the topic that he is very passionate about and want to enlighten all of us. Thank you.
Honorable Chairman and panelists, I will concentrate only on two sections. One is old section 167(2) of the CRPC, which is equal to, pardon? It is not audible? (167) of CRPC, which is same as 187 of BNSS. which provides for police custody. Originally, under 167(2), it was 15 days. Now also it is 15 days. But the interpretation made by the Supreme Court was, it was the first 15 days. Such an interpretation is possible also by the words of the section. Now, in the new section 187(2), it has been made very clear, for a term not exceeding 15 days in the whole or in parts, at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days, as the case may be, as provided in subsection 3. As you are aware, that investigation should be completed within 60 days or 90 days, as the case may be, depending on the gravity of the offense. So in cases where it is 60 days, within 40 days you can have this 15 days custody in parts or as a whole. Or in cases where the investigation has to be completed within 90 days, you can have within 60 days, you can avail this facility of police custody for 15 days. It's a very welcome change. Otherwise, what happens is that rich and powerful people, what they happen is that immediately after the arrest, they pretend some illness, they will be taken to a hospital of their choice, and they have got their own hospitals. They will say that this man cannot be moved to any place for 1 month. Finished. He cannot be questioned by the police. That has gone now. It is a very welcome change. Next is, I am criticizing this. 223 of BNSS, which is the same as section 200 of the CRPC. See, 223, first proviso. 223 is examination of complaints to the magistrates. First proviso says that 223 speaks of private complaints. Provided that no cognizance of offence shall be taken by the magistrate without giving the accused an opportunity of being heard. What shall be done on receipt of a private complaint? The magistrate has to decide whether he has to take the evidence of the complainant and the witnesses present. It is a must. Once the magistrate decides to look into, record the sworn statement of the complainant, he has taken cognizance of. Then where is the question of taking cognizance again? So it's a misnomer. Secondly, hearing the accused at that point of time is quite unheard of. It is against all canons of law. There are umpteen Supreme Court judgments on that point. I will cite only one decision. Next objectionable part is subsection 2. A magistrate shall not take cognizance on a complaint against a public servant for any offence alleged to have been committed in the course of discharge of his official duties, unless such public servant is given an opportunity to make assertions as to the situation that led to the incident so alleged, and a report containing the facts and circumstances of the incident from the officer superior to such public servant is received. These are the twin conditions. A public servant is there. Already there is a provision for public servants, 210 of BNSS, which is also there in CRPC, where sanction is required, 218 of BNSS. Sanction is required for prosecuting public servants. Not only that, here what is to be done, public servant should be invited to come. He should be heard of what? An opportunity to make assertions as to the situation that led to the incident. He has to make assertions. Then a superior officer's report. Suppose a police officer took you into custody, no FIR registered. You are put in police station for 5 days, beaten black and blue. What is your remedy? Your remedy is either to file a suit for claiming damages for illegal custody or to file a private complaint. You cannot file a private complaint because of all these restrictions. And what is this report of the superior in such cases? The police officer superior DSP will file a report in favor of the police officer. So this will lead to police raj. Secondly, it will lead to enormous delay. Waiting for the report of the superior officer, the magistrate is made a subordinate. So the magistracy will be weakened. Once the magistracy gets weakened, the criminal administration system comes to a standstill. That is, from experience, we can say that time will prove that these amendments on 223 has to be withdrawn, is my submission. Then, the questions which arise on the face of 218 of BNSS, which contains protection for public servants, does another protection at the inception required as provided in subsection 2 of section 223? First question. 2. The proviso to subsection 1 provides an opportunity of being heard to the accused before taking cognizance in a complaint case, and subsection 2, public servant to make assertions. This is contrary to all canons of law. What shall the court do after hearing the accused before taking cognizance? Can the court dismiss the complaint? No. Dismissal of complaint, there is a specific provision which provides that after considering the evidence of the complainant and the witnesses, if there is no ground to proceed, the court may dismiss it. It does not speak of the assertions made by the public servant or the report made by the superior officer. So, what is the purpose of this amendment? What is the purpose of that report? And what is the power of the court in such situation is blank. So, experience will say that these provisions are not proper. Another question, 223.2 uses the expression for an offense alleged to have been committed in the course of discharge of his official functions. In the course of discharge. Suppose I am taken to custody by the police. In the police station, the police constable kicks me. He is doing it in the course of his discharge of his duty. But what is protected is discharge of official duty, he is protected. Not what is done illegal in the course of discharge. That is 223.2, 218, while acting or purporting to act in the discharge of his official duty. What is protected under 218, sanction is required is an act committed by him while acting or purporting to act in the discharge of his official duty. On the other hand, what is stated in 223.2 is done in the course of discharge of duty. So I am in the course of discharge of my duty in the police station. I kick somebody. It is in the course of it. Whereas it is not part of my official duty. What is protected under 218 is part of official duty. But what is protected under 223 is in the course of it. Both will not go together. This will lead to litigation, and private complaints will be stagnated in different criminal courts throughout India. Pendency will increase like anything. This will be the result. These are the 2 points which I wanted to mention. Thank you very much.
Thank you, sir.
That does not mean that I am against these amendments. Don't think that there are very many welcome amendments. Very many. Only pointed out the flaws.
Hearing my esteemed chair and co-chair, it reminds me of an old saying that there are two sides of the coin and the coin itself. So let's move on to the next aspect of amendment very quickly. And I thank my chair, co-chair to actually cover very important aspects and highlight certain very critical issues. So my question is addressed to Shri Vikramjit Banerjee, sir. And this is about the accountability, the aspect of prosecution reforms that are being done in the current legislation. That what changes do you foresee because of these amendments in the new legislation?
I think, yeah, I'll just stress it because I understand we are like really short of time. I think the two important provisions, 19 and 20, address this, and I think broad hierarchy, it's been streamlined, qualifications
the supervision, accountability,
DPP,
yeah.
the Director of Public Prosecution. It's been streamlined, qualification, eligibility criteria have all been put out. But I think the two salutary provisions, which I think is extremely key, is the one which said that shall look into as to whether appeal is to be filed, and you know, they are going to certify within anything within above 10 years of punishment, whether the appeal is to be filed or not, that is going to have some sort of supervisory of the DPP, which I think is a fantastic thing, because a lot of appeals are filed quite gratuitously. We know that. And the second issue is also, between 7 to 10 years, they will have the responsibility of ensuring resolution of the matter, which gives a huge sort of supervisory aspect to that. I think these two, are salutary, and I think, it's a wonderful intervention.
Do you foresee any more vetting of FIRs or more leading to more convictions, or maybe justice being delivered in a proper manner?
The great thing about this act is not pro-conviction or pro-freedom. This act tries to ensure this balance is struck, whether their justice is done. And supervisory capability of the DPP would ensure that there is supervision, so that the documents are in order, and so that there is someone who's looking over it to ensure that the process reaches its conclusion. Because it is, as you know, common law, the old thing of common law, it is the process which delivers justice.
Yes, rightly. And there would be more coordination between prosecutors and investigating officers.
Of course.
Okay. Thank you very much. And this leads to me to another question, which is addressed to Shri Vinod Kumarji, that as Banerjee sir was also pointing out, will BNS improve the perception of criminal justice machinery amongst the stakeholders?
Yes, definitely. And first of all, I'm telling you, being head of a district in Delhi judiciary, that there is a lot of enthusiasm in magistracy, judicial officers, district judges, our prosecutors, and police officers. This is totally a new beginning. Yes, old provisions are there, but as you say, old wine in new bottle, I would say new wine in old bottle. So there is a new spirit which has generated among the entire legal fraternity, police officers, and all the stakeholders. Regarding protections, I would say the new act provides protections to public servants, to victims, to the witnesses, and everyone who is involved in criminal justice system at every stage. I will give only one instance, which is normally seen in criminal courts. You see, complaints under Section 138 Negotiable Instruments Act are filed. Now, many times a company is the accused, and its all directors are also the accused persons. Many of the directors had already resigned. Sometimes some of them are sleeping. There is law that person who is looking after the affairs of the company is responsible, and who is responsible for day-to-day functioning of the company has to be prosecuted, and other have to be executed, have to be held to be not responsible. So when magistrate issues summons, 10 people come and they have no remedy. Magistrate has to frame the notice, charge. Now provision has been provided. They may argue the matter. And I tell you, as a revisional court, I have seen that sometimes complaint is time barred. Some technical defect is there. And this is a purely legal issue, but accused is unable to address this before the magistrate. And then he has to come to the, either to the Sessions Court or to the High Court. So this is one example. If you read the entire act, I would say that at every places, a care has been taken that the rights of every person, be they victim, be they accused, they are protected. But as working at the cutting edge of Indian judiciary, I know where the shoe pinches. I will only point out one provision, though there are many. The procedure of warrant trials and complaint cases. Now in complaint cases, if it is trial in accordance with the warrant trial, the witnesses are called twice in case it is filed by a public servant. And witnesses are called thrice if it is filed by an ordinary complainant. Now see the plight of Government of India, a giant. It is a big entity, powerful state, but in criminal court, it is a giant with clay feet. Just try to see and find out what is the fate of the cases filed by the government under the Customs Act. You will find there is a languishing for 10 years, 15 years. Why? The witnesses are public servants. They are transferred and they will be called time and again. Because procedure is such that first, after summoning, the prosecution evidence will be recorded, witness would be cross-examined, then arguments on charge would be heard. You see, this is surprising. The witness is being cross-examined before framing of the charge. And if charge is framed, then accused will not naturally opt for summoning those very witnesses for further cross-examination. So, this is the reason that the complaint cases filed by the government under Customs Act and other acts also. For example, Central GST Act. Unless you change this procedure, there is no hope for Government of India. There is Foreign Contribution Regulation Act, new act, and there is an old act, Drugs and Cosmetics Act, and many more such cases. I would request that if there is any researcher, just to find out what is happening in all those cases. You will find that cases are languishing from years together. So, I request that this provision should be made akin to the warrant trials instituted upon police cases, police report. So, we are already having a paucity of time, so I will not continue further. Thank you.
Thank you, sir. Thank you. And that leads me to Shri D.C. Jainji to kindly comment on, in the backdrop of the observations given by Vinod Kumar sir and Shankaran sir, that if he can throw light, or if you can please throw light on the pendency and investigation as far as trial are concerned, and specifically in general and specifically regarding public servants. Thank you.
Okay. Thank you so much. Before I begin, we must acknowledge the presence of young officers from CBI, in large number who have just joined us from the academy. And taking the discussion further, from the point of view, I would in fact recall what Praveen sir said in the previous session about these unscrupulous litigants. He referred to the judgment of Supreme Court, Honorable Supreme Court, this Dinesh Gupta, state of UP. As a public servant, we have faced this problem as a practitioner also. I think one of the biggest problem our criminal justice system faces is the problem of false litigations, because that burdens our system. So it is very important to tackle this menace of lodging false complaints, because as we also know, the process itself is a punishment. We may say, particularly in the context of public servants, that you have the provision of this prosecution sanction. So before you prosecute, you will require sanction. But we also know that the process is quite it takes a lot of time, and the process itself is punishment. So in the new act, what I see is they have tried to strike a balance. Obviously, the balance is that we should also ensure that these kind of unscrupulous litigants, they are discouraged to lodge false complaints. So if you remember, the first change they have made is in this section 173 BNSS pertaining to lodging of FIR. And we already have a Supreme Court verdict on that, Lalita Kumari. So they have provided for this provision of registering a preliminary inquiry by the officer in charge, provided that the information is ambiguous, it doesn't disclose commission of a cognizable offense. So in certain set of offenses, the officer in charge now will have the discretion to first do a PE to find out that an offense has happened. We also know about the misuse of section 156(3) CRPC, and I'm not saying this. This was also stated by the Honorable Apex Court in Priyanka Srivastava versus State of UP, because this section provides powers to the magistrate to order registration of FIR. But we all know that many a times these unscrupulous people, they directly reach the magistrate and they claim that they went to the police station or they went to the SP office, but they were not entertained, because of which they have come to the court. So in Priyanka Srivastava versus State of UP, Apex Court laid down certain guidelines for the magistrates that have been incorporated in this law, that the complaint will have to be accompanied by an affidavit, and then the magistrate will make necessary inquiry, and also the concerned police officers will also be given an opportunity to present their side of the story, whether this person had actually come or not. And then regarding the public servants, because public servant, when they discharge official duty, obviously we should be conscious and we should encourage that a conducive environment is created. They should not have the fear of being victimized. So I think the new act has tried to take care of that. It has, if you ask me, in my opinion, they are not taking away the power of the magistrate. They are only making certain provisions. They are saying that before you order registration of FIR, please obtain a report from the superior officer of that public servant regarding the incident, and also provide an opportunity of presenting the side of the story by the public servant. In fact, it is in tune with our laid down principle of natural justice. That, and particularly it is only in the context trying to provide a safeguard to a person who is doing duty. And we all know people do make all sorts of allegations. So if you ask me, this is a very welcome change. And we have already listened about the corresponding changes in section 200 CRPC, which is 223 BNSS. Regarding prosecution sanction, I'd like to highlight a very, very important change has been made in BNSS. So far, there used to be a time limit in certain acts like the Prevention of Corruption Act. But the competent authorities would not take any decision. They'll keep it pending for many years. Now, first time in the history of this country, we have a law where they have made the provision of what we now know as deemed sanction. So if the request is not decided, say, within a period of 120 days, then it will be deemed to have been issued. So obviously in that case, either it will prompt the competent authorities to decide such requests fast, or it will help us in completing the investigation without delay. Further investigation power of police, no time limit in the existing act, and we know that even after filing charge sheet, police keeps matters pending for further investigation for many years. So now in the new act, it has been laid down that if police will not be able to continue further investigation during trial without the permission of the court, and there again they have imposed a time limit of 90 days. If it is to be extended, again you'll have to obtain permission of the court. Regarding the deposition, I think sir mentioned, because the public servants and other witnesses, they have to be called again and again. I think a very important provision, a new section has been added, what we know as section 336 of BNSS, where they say in such kind of cases where, first of all, in case of public servants, when their report or document is not disputed, there is no need of their deposition. If it is disputed, and particularly if the public servant is not traceable or transferred, died, or it would cause delay, then the successor officer in the place of that public servant can depose for him. So I would say many fundamental changes have been introduced to address these issues. I think it is going to go a long way. Thank you so much.
Thank you. Now I move to Shri Praveen Kumarji. Sir, a lot has been said about the changes by our esteemed panelists. So what kind of infrastructural support do you you foresee, as in which would be required to implement these changes?
So thank you. For implementing these three new laws, I would like to focus in the next 5 minutes on all the 5 verticals and ensure that whatever technological tools are required for the video conferencing part, so these things would be put in place well before, and at least the infrastructure part, the requirement part, I would say, since the states have to be procured, so it's not a top-down approach that we will say that you have to do this X, Y, Z. So we will, so the idea is to lay out a standard template. The idea is to lay out a standard operating procedure, and then request the states and the UTs to adapt them to their local conditions. As I say, if I am aware that some of you must have downloaded the e-Sankalan app that is available on the iOS and Android. So if somebody has not downloaded these apps, it is from the NCRB. So you can download this Sankalan app. It is a good reckoner about the new acts, and it also has a comparative table as compared to the old CRPC and the new laws, and the old IPC and the new laws, and the old Evidence Act and the BSA. The third is the crucial part of the forensics. So forensics is something that has happened in some of the states, but for the first time it is now mandated, and there is no if and but. So if there is a crime that has a punishment of 7 years plus, you have to have a visit by a forensic expert. Now, this thing is going to revolutionize, I would say, investigation per se. I do realize that there could be an inequality in terms of an infrastructural support, but to wait for that, I would say, good morning to take place, or to give a leeway of 5 years as that has been given in this act. So the spirit is, in the next 5 years, there has to be a timeline where each and state and the UT, they have to say that, okay, we have prepared from this day. The hand-holding part, the Ministry of Home Affairs is aware. So as the forensic infrastructure in some of the states and the metros like Delhi is much more advanced. In Delhi, since 2022, most of the offenses that attracted punishment of 6 years or more, they had a compulsory visit at the scene of crime by, I would say, scene of crime officers. Now, sometimes we try to confuse between a scene of crime officer and a forensic expert. A scene of crime management is something different, and that is the first thing to take place before a forensic expert could reach a place and derive the data from that place. Now, in the new BNSS, there are provisions like videography and recording on a mobile phone or on a device. So these SOPs are being prepared. The kind of, I would say, the kind of support, technical support that is required, the kind of cloud hosting that it would require, whether it would be a centralized architecture or a decentralized architecture. The CDAC is already aware, ma'am. And CDAC is working out, it is thrashing out the details, and soon I am told that they would be sharing the beta version with states and the UTs for a feedback. So the training, the technology, and the forensics, I think these are the 3 pillars on which the 5 main pillars of the criminal judicial system, they would be driving the implementation of these 3 new laws. Thank you.
Thank you. Now I will like Chandrasekhan sir to kindly throw light on the rights of the victim and how BNSS is more supportive and more protective for victims. Yes. Thank you.
Good afternoon, everybody. Being a practicing advocate for 27 years, whenever your name is called in the court, there is an impulse that you should stand up. That has made me to do that now also. Advocate cannot sit like a sitting judge and speak. At the outset, I should thank the chair, Honorable Justice Ashwani Kumar Mishra, and the Union Law Secretary, Rajiv Mani sir, for their hearty invitation to me. With the blessings of my parents and my teacher, Mrs. Vrinda Mohan, Advocate Pondicherry, I am here in front of you. Being a student from 94 to 97 in a law college, any teacher comes inside will say this law was borrowed from this place. We have borrowed this part from this place, Canada, USA, UK, Germany. And is it not sane for a student of me to ask a question unto myself that so nothing belongs to my country? The answer was made by the Honorable Law Secretary in the morning that all these laws can be traced from the Indian Dharma system. And my brothers from 2024 batch of law college will have the relief to listen to the professors telling that we have got 3 indigenous laws. So the country is self-sustained not only in rocket science, but also in law from 2024. The credit goes to the present government. And there is a saying that neighbors envy owners' pride. When the world was staring at us, that the government was constructing a new parliament, the parliamentarians have made 3 new laws which are progressive in nature, replacing regressive laws. As was spoken by the Honorable Law Minister in the morning, those laws were made by the British, for the British, and of the British. These laws are made by us, for the welfare of us. Madam has asked a question, can we say that finally laws have become, BNSS have become victim-centric? I am afraid to answer in affirmative that it is fully a law victim-centric, because in the teeth of Article 14, I should not answer like that. These parliamentarians adorning the throne of parens patriae has got a duty to balance the rights of the accused and also the right of the victim. And this BNSS, in all my humbleness, would say, is an earnest attempt and achievement that the Parliament has achieved a balance such that the rights of the accused is well protected, the doctrine of reasonable doubt, presumption of innocence, and fair trial, free legal aid, and harassment from arresting was protected by Section 35 now, and 273 and 399, it is Section 273 and 399 of BNSS. I am referring all provisions from BNSS only. It is all preventing and protecting the accused from false imprisonment and malicious prosecution also. Now coming to the topic assigned to me, it is always difficult to be a last batsman in a play, but I will try with the blessings of the chair and all of you. There, I have culled out 20 provisions which students assembled here, you can jot it down, which projects this law as a victim-centric, and these laws are comprehensive in nature, and I can say with pride that any country which wants to make out a law for protection of its citizens can borrow from my country's BNSS 531 provisions, which is a treasure of protective laws. Okay, I will start from Section 18 of BNSS. Section 18 BNSS speaks for the mandate of the government to have a public prosecutor who is in charge of prosecuting the case on behalf of the victim. 18 subsection 8 gives her a leverage to appoint a private advocate of her own choice. Then coming to Section 173 of BNSS, it says a victim can register an electronic FIR for the first time in the country, which is going to happen from 1st July 2024. If at all any one of you had been to a police station for registering an FIR, you will know the pain and the wisdom of Parliament to invent such a new provision. Registering an FIR is not an easy joke in spite of so many verdicts of Lalita Kumari. And now that the registration of FIR is made easy, justice is in your mobile phone, you can load it, and police is mandated to register the FIR, and you have the liberty of signing it within 3 days. Secondly is, as the Honorable Law Minister and the Honorable Chief Justice said, it is a zero FIR. I do not want to dwell on it once again. Third, a novel thing is, if she is a rape victim, police, a woman officer shall come to the residence and register the FIR. And the extra feature is, copy of FIR, previously it was given only to the complainant, now it is given to the victim and the accused also. So what does non-registration of FIR by the station house officer warrants? You should follow the procedure in 173, you should appeal to the superintendent of the police, And the new law is superintendent of police shall examine himself or depute a investigating officer. Previously, he should direct the station house officer for obliging the mandate. Now that was made. And what happens if the superintendent of police also doesn't oblige? Where will the victim go? Answer is in section 175 of CRPC, which says an application to the magistrate is a remedy. Then coming to section 176, it deals with procedure of investigation. It says if she is a rape victim, then the police should come to her residence or any place of comfort. This is with relation to registration of FIR. Section 154 of the code, 184 of the code says medical examination of the victim has to be done within a time frame of 24 hours on her consent. Because now in state of Jharkhand versus Shailendra Kumar Rai, the Honorable Supreme Court has said, has condemned the two-finger test. You cannot do all this, it becomes a medical negligence. And section 184 says you cannot perform a medical examination on her without her consent. Then from 184 coming down the line, it is 193, which is charge sheet. If it is an offense of rape or a POCSO offense, legislature has mandated 2 months' time. Within that, the investigation agency has to complete it. Coming down to section 230, supply of free copies. It is unimaginable that this parliament has made the player the victim who is always behind the screen. In any criminal trial, you have got two players. One player is the victim who starts the ignition key and disappears in vanity. She doesn't know how the car goes, where the car breaks down, and what is the result. Now section 230 says, whenever court gives a free copy to the accused, victim also should be given. It is a very, very innovative legislation. And at this moment, if the victim receives the copy of the charge sheet, she will protest and make a protest that this is not the way I have expected and this is not the complaint. And she can invoke the judgment of the Honorable Supreme Court and Bhagavan Singh versus Commissioner of Police. She can make a protest petition. This is 193. This is 230. Then coming to 232, committal proceedings. If at all the case is triable by the Sessions Court exclusively, then neither the victim nor the accused cannot make any dilatory tactics of filing so many applications and keep the committal proceedings pending for years together. Now the mandate is any application filed by the accused or victim before the committal court shall be put up with the main bundle and it should be sent to the Sessions Court in time. This is section 232. Coming down the line is section 290, 291 and 293. What 290 speaks of? It speaks of for plea bargaining, which is a triangular convergence of the accused, the complainant and the court also, where the accused can make a plea and can get a sentencing which ranges from one half until 1/6 of the punishment, if at all he goes for a trial. And what 292 speaks of? 292 speaks of a mutual disposition which they can get along. 293 speaks of disposal of the plea bargaining case. What is more interesting is plea bargaining is not applicable if it is an offense as against the woman, child, socio-economic offenses and offenses which are less than 7 years. Coming to section 356. What is 356? There were loads of cases which was referred by the Honorable Chief Justice of India and the Honorable Minister also. A man who is charged by the police will never be seen. He lives in disguise. Now the new code 356 says, like in civil case you call a defendant absent and set ex parte. Now in absentia proceedings can be made for inquiry, trial and judgment also will be pronounced in his absence. This is section 356. 360, there were lot of cases where the complainant lady or a man will initiate the complaint. Public prosecutors will withdraw and run off. Now it is the mandate of the present day government which says you cannot withdraw without the victim being heard. This is one laudable objective that has to be made in section 360. Coming down the line is section 396, 397 and 398. What is 396? It is victim compensation. 397 is victim treatment first aid, free of cost, in lines with the judgment of the Honorable Supreme Court in Lakshmi versus State, followed by Ravada Sasikala versus State of AP. Then what is 398? It is the judgment of the Honorable Supreme Court in Mahendra Chawla versus Union of India. It is victim protection. See, whatever you do, any investigation by CBI, ED, IB, whatever it is, if you don't protect the victim, then all the process of investigation and prosecution will go to dogs. So this is one such excellent innovation, 398. Coming down to section 404, furnishing of free copies of judgment to the victim. Judgment of the copy of the judgment will not be seen by the victim at all. Now the victim can apply for a free copy of the judgment, 404. 413 speaks about appeal by the victim without begging the state. She need not ask for a special leave from the state. The victim herself or himself go on an appeal with some conditions that it can be as against an acquittal of an accused, or if at all the sentence is for a lesser offense and inadequate compensation, they can go. 530 is the last provision, which in all humbleness I would say, it is a dream of everyone that no man wants to go to the court and the police station and waste time. It is justice coming to the doorstep right from the inception of registration of FIR till appeal. A victim can conduct all these proceedings in digital world. Thank you so much. I love you all.
Thank you, sir. As the time is running by, I would like, before I open the session for questions, I would like chair and co-chair to kindly comment very briefly on the balancing of individual rights and effective law enforcement in the backdrop of technology infusion. Thank you.
I must congratulate Mr. Chandrasekharan for his very, very lucid exposition. In fact, what we felt, I was feeling all through that so many provisions, so many good provisions were not highlighted. This Mr. Chandrasekharan has done. In fact, we are, ultimately, whether we are judges, we are advocates, we are all students of law. As students of law, we have certain concerns. A very laudable legislation has come into existence. The purpose of these conferences are to ensure that we are able to foresee what kind of difficulties may come, while appreciating it on one hand, what are the aspects that requires to be taken care of. So that's the aspects with which we are discussing, sometimes some provisions for sometimes some difficulties that we foresee and how it is to be handled. So far as this, because ultimately the Supreme Court's judgment and after that this Data Protection Act, individual liberty has to be, it's balancing of interests, individual liberty as well the right of privacy and also the right of the society to ensure that the crime is eliminated has to be balanced. And so far as this particular provision is concerned, I was also a little concerned as to how we are going to deal with all these provisions. But I just checked up this Digital Personal Data Protection Act. It says that two kinds of data can be retrieved. And that is, one is that based on consent. The other is that for the performance by the state or any of its instrumentality of any function under any law for the time being in force.
Yes.
And therefore there is no, apparently there is no dichotomy between the two. So far as investigation or court purposes are concerned, they are lawful functions. That is also defined. That what is lawful is something which is not prohibited by law. So therefore that will take care, and ultimately what all the personal data which would be taken aid of for the purposes of solving the crime would be in the larger interest of the state. And to that extent, possibly we will have to draw the balance. It will not, in due course, The same
was highlighted by Honorable Justice Chanchud also.
Yes. So therefore, this will have to be, I don't really see. The only concern which I would like to flag is that it's such a far-reaching legislation which has come in, how we are going to implement it has to be thought through more seriously. And those implementation aspects have to be then provided for, because sometimes very good legislations, unless it is backed by, as Mr. Praveen also said, that these are aspects which are already engaging the attention of the relevant stakeholders, but possibly it has to be given a lot more priority so that we are able to address those concerns, and then people are made aware before we actually implement the provision itself. So there's something which is good. We just need to catch up. We need to catch up so far as making of rules are concerned, making of provisions are concerned, making people understand public awareness. These are things, and it's a very, very good move. In fact, today's conference being initiated by the Honorable Chief Justice of India, it's a very, very welcome move. And what I would at the last suggest and request is that let there be more such deliberations, and I would be very happy to see separate sessions being held to address all three legislations with no time constraints. And see, ultimately, once you implement the law and then you face the problems, it's better that you please discuss it, foresee the problems, and address at this juncture. Thank you.
And in answer to the doubt expressed by me, my learned friend said about the public servants, their protection and all those things. It is true, they should be protected. What happens is that if a private complaint is filed, which is summons procedure, there is no method to stop it. It has to go till judgment. So the public servant will have to suffer throughout. But in K. M. Matthew versus State of Kerala, Justice Ketty Thomas had said that the court has power to stop the proceedings under 258 CRPC. But later, a three-judge bench of the Supreme Court overruled it in Adalat Prasad. Now, 280 is the in BNSS, that is a provision. A small amendment will solve the problem of all the problems of public servants who are facing it. Now, what is the wording? If a complainant, 281, in any summons case instituted otherwise than upon complaint, the magistrate of the first class or with the previous sanctions, etc., may, for reasons to be recorded by him, stop the proceedings at any stage without pronouncing a judgment, and where stoppage of proceeding is made after the evidence of the principal witness has been recorded, pronounce a judgment. So even without a judgment, the magistrate could stop the proceedings and save the accused if it is necessary, provided it is a private complaint with respect to warrant trial. But with respect to summons trial, this will not apply because the wording is otherwise upon complaint. So this otherwise upon complaint you delete. At any time it can be stopped. So the public servant comes to the court and says that I am justified in doing so. The court can at any stage, even without a judgment, can stop it if what you say is correct. But at the same time, the citizens are also to be protected, the courts are to be protected, pendency should be reduced. In every private complaint, whether public servant is not there or not, notice has to go to the accused. Where are we? Crores and crores of cases will be pending in courts. Speedy justice will go away. Access to justice will not be available. So that will be a disastrous result. I am sure, I am predicting that the Parliament will delete it in due course.
Now I open the floor for the questions. Okay. If I may ask one question to Banerjee sir and Vinod sir, will plea bargaining be an opted option now after BNSS?
So that I think it should be, and we expected it to, be quite a part of the process, and people will take advantage of it.
So more prosecution reforms are required, or within this framework only the plea bargaining will see the success, the road of success?
As I agree with what was discussed, that we need to work it out. And I've been saying that from day one, this is not the blanket end. You will need additions, you will need amendments, you will need to come out with rules, and you'll all, possibly through rule making, it may be better to address plea bargaining and the prosecution and things of that sort. But let us see how it works out. It'll go to the courts, we'll have to work it out. It's too easy to predict in advance. I don't think finally it works out that way.
I think plea bargaining clauses in our system are not so effective. Reason is that an accused has all the expectations that during trial he will be acquitted. For example, he may compound the offense with the victim. He may win over the victim. And he has expectations that there will be, even if the witnesses support the prosecution case, there will be many lacunas in the prosecution case, and he will be acquitted. So, for plea bargaining, we must adopt Western concepts. Western concepts are, yes, you are allowed to bargain the plea of guilt. Prosecution may say, yes, instead of 302, we are ready to convict you under section 304. But in case you are convicted at the final stage, then minimum sentence would be this. Only then it will be successful.
Any questions?
Ma'am, can I just add to the plea bargaining thing, because there are two important changes that have been made in BNSS regarding plea bargaining. One is that now an accused will be able to enter into plea bargaining before the trial begins, not during trial. That is a very important change that has been made, because they say that an accused will be able to file an application for plea of bargaining within a period of 30 days from the date of framing of charges. So we know the current practice is that at any stage during the trial one can come out with this application. So that is one change. And second change that has been made is they have tried to reduce the punishment, like if there is a mutual satisfactory disposition which has been spoken about. So for the first time offenders, without any previous conviction, if there is a satisfactory disposition, then the court or the magistrate will be able to give a punishment which will be like 1/4 of the minimum punishment for that offense if it is prescribed, or 1/6 of whatever punishment is applicable in that particular offense. So these two important changes have been made regarding plea bargaining in the new law. Thank you.
So with this, I wind up this session. It was okay. Please.
Proviso added to section 190 BNSS. Corresponding section of CRPC is 170. This is provided that if the accused is not in custody, the police officer shall take security from such person for his appearance before the magistrate, and the magistrate to whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not taken in custody. So this is proviso to subsection 1 of section 190. Previously, that's existing section in CRPC subsection. This says, or if the offense is bailable and the accused is able to give security, shall take security from for his appearance before such magistrate. So here this proviso has been added to this earlier existing provision. So one may like to get certain clarification. Is this regarding also applicable regarding non-bailable offenses? If it is so, then provisions under chapter relating to bail, like corresponding provisions to section 437 subsection 3 CRPC, that must be here in BNSS, like section number 480 and similar subsection. So I seek some clarification. As a trainer, I'm a director of Central Academy of Police Training, Bhopal. So there are certain queries from, we are conducting courses for all 5 main pillars, including judiciary, police officer, prosecution officers, and forensic scientists and prisons. So there has come certain queries from our participants also. Sir, thank you.
There is a judgment of the Honorable Supreme Court in Siddharth versus State of UP, 2021, wherein the Honorable Supreme Court has answered this question that any charge sheet filed under section 170 of CRPC, irrespective of whether it is bailable or non-bailable, and basically charge sheets are filed under section 173 of the, I am thinking it is an older CRPC, no, the present CRPC, right? Any charge sheet filed under section 170 of the older CRPC, the Honorable Supreme Court has said it will be offences irrespective of bailable or non-bailable. It will be offences where investigation will be completed without a lengthier process that usually happens under 173 of CRPC. So the Honorable Supreme Court said if the police comes with a charge sheet, you need not put that person, or you need not compel the person for taking bail, whether he is present or not. I will hand it over for any additions
just supplement
before the Honorable Co-Chair.
May I just supplement to what he said? You know, like, see, the current 170, section 170 of CRPC, when we read it, it gives an impression that the magistrate or the court will accept the charge sheet only when the accused is brought along with the charge sheet. That is the problem. And as Sir Chandrasekharan Saab has already said, it has already been decided in many judgments that you need not bring the accused along with the charge sheet. And you know why this is so? Because corresponding changes were made in section 41 of CRPC way back in 2009. Earlier, in all non-bailable offences, police would arrest. But in non-bailable offences also, now particularly for offences which were punishable for 7 years or less, and you know Arnesh Kumar versus State of Bihar. So the idea was that we should complete the investigation even without arrest of an accused, even in a non-bailable offence. So when you can even complete the investigation without arrest of a person, why should you arrest that person only because you want to produce or file the charge sheet under section 173 CRPC? So there was an ambiguity that has now been cleared in this, clarified in this section 190 of the BNSS very clearly, unambiguously, that while you are filing police report, now under section 193 of BNSS, you need not, arrest the accused only for the purpose of producing charge sheet along with the accused. I hope this clarifies. Thank you.
You can also add Satender Kumar Antel versus CBI 2022. See, one thing is requirement of arrest is different from necessity of arrest. Okay, thank you.
Hello.
Section 1480, subsection 3 of BNSS, when a person accused or suspected of the commission of an offence punishable with imprisonment which may extend to 7 years or more, or of an offence under Chapter 6, Chapter 7 or Chapter 17 of the Bharatiya Nyaya Sanhita 2023, or abatement of or conspiracy or attempt to commit any such offense is released on bail under subsection 1, the court shall impose the conditions. So ABC, this was also inserted through in original CRPC, that Act 25 of 2005, section 437, subsection 3. This is corresponding to that. So these are offenses against human body and state and against property, these 3 chapters. So what will happen about it, where that certain police officer takes security in these cases also? So that clarification is specific I sought. Thank you, sir.
Will you like to say? In fact, we should not confuse between bail provisions and taking security. Means you are only taking a security, the police officer is in this case they are not talking about bail in section 190 of the BNSS. They are only asking that you take a security from that person, that you would appear before the court as and when you are summoned by the court. That does not tantamount to, and it is not the same thing as if you are releasing that person on bail. So let us not confuse. This has nothing to do with the bail provisions, which are independent and separate to this. Thank you.
Thank you. Honorable Justice Ashwini Kumar Misra, sir. Myself, Dr. Manoj Gorkela. I am practicing lawyer in Supreme Court last 22 years. And I got opportunity to deliver lecture in CBI Court Judges, National Judiciary Academy, and various institutions of our country. I deliver lecture to forest officers, new law, CRPC, and different laws. Sir, इस country में सबसे बड़ी problem जो है, जो मैंने face किया है, जो police officers को lecture देते समय, CBI, even paramilitary forces के officers, वो problem ये है कि जो investigation होता है, FIR जो होती है, वो IO investigation करता है, sub inspector rank officer. He is not well versed about the English communication and English writing skills. So my humble request to our Secretary कि इस तरह के जो नेशनल कॉन्फ्रेंसेस हैं वो हिंदी में भी होने चाहिए सर, ताकि उन लोगों को ये खबर पहुंचे. फर्स्ट पॉइंट. सेकंड इंपॉर्टेंट पॉइंट, थैंक यू सो मच, क्योंकि ग्रास रूट में जो सबसे फर्स्ट ऑफिसर है सर वो पुलिस ऑफिसर है. FIR करने वाला भी हिंदी में करेगा, लिखने वाला भी हिंदी में लिखेगा. सेकंड इंपॉर्टेंट, और इस मोटिव जो ये भारतीय सुरक्षा संहिता है, इसका मोटिव भी हिंदी में रखने का ये है कि मोस्टली 80% जो हिंदी मीडियम स्टेट्स हैं वहाँ पर डिफिकल्टी ना हो. सर सेकंड इशू ये मेरा ये है, मैंने ये लेटर मिनिस्ट्री ऑफ होम को भी लिखा था कि भारत में पहला स्टेट मेरा स्टेट है सर. आई बिलोंग टू द स्टेट ऑफ उत्तराखंड. द ट्राइबल एरिया बिलोंग टू द लास्ट बॉर्डर एरिया ऑफ द चाइना तिब्बत नेपाल इस मुनस्यारी. वहाँ पर सर पहला स्टेट है भारत का जहाँ पर मर्डर केस का इन्वेस्टिगेशन पटवारी करता है सर, लेखपाल. ये बात मैंने यूनाइटेड नेशंस में भी बोली थी सर, ये पहला स्टेट है. और उस बारे में वहाँ पर जो इन्वेस्टिगेशन होता है सर वो पटवारी करता है, और जो चार्जशीट फाइल करता है सर यहाँ पर DSP रैंक का ऑफिसर फाइल करता है, वहाँ नायब तहसीलदार रैंक का ऑफिसर फाइल करता है. मर्डर केसेस, रेप केसेस, पॉस्को केसेस. तो इस बारे में जो बहुत डिफिकल्टी है सर वहाँ पर, क्योंकि पटवारी के पास प्रॉपर जेल नहीं होती है, लॉकअप नहीं है, रिमांड के लिए कोई प्रोसेस नहीं है. इस बारे में भी बहुत सारा वो होना है. और मोस्टली इलाहाबाद हाई कोर्ट में मैंने देखा है जितने भी मैटर्स आते थे सर, पहले इलाहाबाद हाई कोर्ट होता था, अब तो उत्तराखंड हाई कोर्ट हो गया, तो उसमें भी ये क्वेश्चन उठा था सर. इन्वेस्टिगेशन में सबसे बड़ी प्रॉब्लम ये है. मेरे 2 इशू है. थैंक यू.
आपका जो ये कहना है इन्वेस्टिगेशन, देखिए इन्वेस्टिगेशन सबसे इम्पॉर्टेंट है. और क्यों हिंदी? आप सदर्न स्टेट्स में जाइए तो वहाँ की अपनी भाषाएं हैं, और इसीलिए अब इस समय एम्फेसिस, इवन सुप्रीम कोर्ट, ऑल जजमेंट्स आर गेटिंग रिस्पेक्टिव लैंग्वेजेस में सबको कम्युनिकेट करना है. आपकी ये बात बिल्कुल सही है कि जिसको इम्प्लीमेंट करना है उसको पता होना चाहिए, और ये बात उस तक पहुंचनी चाहिए, उसकी भाषा में ज़्यादा आसानी से पहुंच सकती है. बिल्कुल वेलकम मूव है. जहाँ तक ये पटवारी की बात है, ये मेरे लिए न्यूज़ है. और मैं अगर नहीं मैं आप अच्छा, और आपने अच्छा इसमें I have some of our friends at Uttaranchal High Court. I'll definitely like to pull them up. What are they doing sitting there? It's on the lighter side. But definitely, agar aisa hai, to it requires how can somebody who, in fact, there are a number of things. Like I'll just share it, though it is not exactly concerning here. Revenue के बहुत से matters में आप देखिए, पूरी की पूरी रेवेन्यू में जो पटवा जो से बहुत से, और फॉर दैट मैटर कंसोलिडेशन, जैसे आपने यूपी की बात किया, कंसोलिडेशन कोर्ट्स हैं, कंसोलिडेशन ऑफिसर, सेटलमेंट ऑफिसर, कंसोलिडेशन ऑफिसर, डीडीसी, ये सारे वो ऑफिसर्स हैं जो अल्टीमेटली सिविल कोर्ट की पावर्स वर्चुअली एक्सरसाइज करते हैं, बिकॉज इन दैट रिस्पेक्टिव एरिया उसमें से किसी के पास लीगल ट्रेनिंग नहीं है. दीज आर मैटर्स जो शायद लेजिस्लेशन को एट अप्रोप्रिएट स्टेज देखने पड़ेंगे. एंड यू हैव राइटली सेड इट टू Mr. Mani will pass on the consent.
And I'll just, on the question of tribal laws is, I was, for a short period of time, मैं AG था नागालैंड के. वहाँ पे भी customary law से बहुत सारे criminal matters, वहाँ पे भी बहुत सारे criminal matters try किया जाता है. वहाँ पे जो कहते हैं spirit of CRPC is going to be applicable, spirit of IPC is applicable, spirit of Evidence Act is applicable. और ये बात भी है, हम बहुत डाइवर्स देश हैं और ये हमारे बहुत सारे चीज़ कॉन्स्टिट्यूशनली भी प्रोटेक्टेड हैं और हमें देख के चलना है. नाउ ऑफ कोर्स इवन इन नागालैंड हम कोशिश कर रहे हैं कि CRPC is now applicable district by district everywhere, but it is not feasible. So my whole thing is wait, समय आएगा. सब लोग, now there is extension of CRPC applicability in district by district. District courts are being formed in Nagaland. Hoga, ho jayega. Same thing I'm sure in tribal areas. They have their customary law, they're entitled to have it. Don't rock the boat, it will sort itself out.
Now you are saying that throughout Now you are saying that throughout India the FIR and all those things should be in Hindi? No. If that is so, I have to say no.
Can we just have a chit chat on lunch in a break? So I'll thank you, my respected panelists and all the audience. Thank you.
Thank you so much. But one humble request, small request, but important request. पैनलिस्ट का तो थैंक्स है, लेकिन आप में से कई लोगों ने, काफ़ी लोगों ने लंच शायद किया भी हो और जिन्होंने नहीं किया वो कर लें. बट वी विल कंटिन्यूइंग विद द नेक्स्ट सेशन बिकॉज वी आर प्लानिंग टू हैव द थर्ड सेशन from 2:30 to 3:30, and at 4 p.m. we have the valedictory session. So we have running short of time, so we have to manage that. As an organizer, this is the biggest challenge for us. So, but before that, we are grateful to the all the members, especially the chair of the session, Honorable Mr. Justice Ashwini Kumar Mishra ji, Judge Allahabad High Court, Co-Chair Honorable Mr. Justice K.T. Shankaran, retired member Law Commission of India, Mr. Vikramjit Banerjee, London Additional Solicitor General, Supreme Court of India, Vinod Kumar ji, Principal District and Session Judge, Delhi, DC Jain Sahab, IPS retired, former Special Director, Central Bureau of Investigation, Mr. Praveen Kumar ji, IPS Additional Director, Intelligence Bureau, Government of India, and E. Chandrasekharan ji, Advocate, Madras High Court, and we are thankful to Dr. Upma Gautam ji, Associate Professor, Delhi, GGS IPU, for moderating the session. Thank you very much. We will take 5 minutes to rearrange the sitting arrangement at the stage, and we will continue with the third session. And that session, ladies and gentlemen, is dedicated to the third law regarding this criminal justice system, which is going to be introduced and being implemented from the 1st of July 2024. And that is based on the Bharatiya Sakshya Adhiniyam 2023. So, जिन्होंने अभी लंच जो कर चुके हैं वो प्लीज़ आई विल रिक्वेस्ट ऑल ऑफ देम टू बी रिमेन सीटेड, और जिन्होंने लंच नहीं किया वो लंच करेंगे. और अगला सेशन जो है हम उसको वी विल स्टार्ट विद इन 5 मिनट्स द नेक्स्ट सेशन. सो आप जितना ज़्यादा से ज़्यादा पार्टिसिपेट कर सकते हैं, क्योंकि हम भी चाहते हैं कि ये ऐसे टेक्निकल इश्यूज़ हैं जिस पर ज़्यादा से ज़्यादा डिलिब्रेशंस हों. और इसीलिए डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, गवर्नमेंट ऑफ इंडिया ने ये पूरे दिन का कॉन्फ्रेंस रखा है. और आपको ये भी बताएं कि ये कॉन्फ्रेंस यहाँ दिल्ली में हो रहा है, नेशनल कैपिटल में. इसके अलावा देश के अलग अलग हिस्सों में भी, डिफरेंट पार्ट्स ऑफ द कंट्री, वी आर गोइंग टू ऑर्गेनाइज सच काइंड ऑफ कॉन्फ्रेंसेस फोकसिंग ऑल दीज थ्री क्रिमिनल जस्टिस सिस्टम, न्यू क्रिमिनल लॉज. सो ये हमारी कोशिश है कि जितने स्टेक होल्डर्स हैं, जितने लोगों की इन्वॉल्वमेंट इस जस्टिस डिलीवरी सिस्टम में है, जिनकी इन्वॉल्वमेंट, वो सभी इसके साथ अच्छी तरह से इसको समझें, जानें उसको इम्प्लीमेंटेशन के लेवल पे जो लोग इन्वॉल्व हैं डायरेक्टली, वो उसमें अपना कंट्रीब्यूट करेंगे जितना बेहतर ढंग से कर सकते हैं, क्योंकि ये देश के लोगों के लिए और जुडिशियल सिस्टम के लिए एक बहुत इम्पॉर्टेंट एक चैप्टर है जिसकी शुरुआत होने जा रही है इस रूप में। तो आप सबसे मैं रिक्वेस्ट करूंगा कि काइंडली रिमेन सीटेड और अगले सेशन में आप हों, ज़्यादा से ज़्यादा लोग हों तो अच्छा लगेगा। वैसे ये जो प्रोग्राम है इसको हम सोशल मीडिया प्लेटफॉर्म्स के ज़रिए भी लोगों तक पहुंचाएंगे, ताकि जितनी डेलिब्रेशंस है, जितनी बातचीत है, जितनी क्लैरिफिकेशंस हमारे एक्सपर्ट्स और स्पेशलिस्ट या इस फील्ड के जो ल्यूमिनरीज हैं उन्होंने हमारे साथ शेयर की हैं, वो हमारे लिए एक गाइडिंग प्रिंसिपल की तरह काम करे। और डेफिनेटली हर चीज़ में समय के साथ बदलाव होता है, आगे भी होगा, लेकिन आज ये सबसे बड़ी ज़रूरत है कि हम इन लॉज को पहले अच्छे से समझ पाएँ, और समझेंगे तो उसकी इम्प्लीमेंटेशन में आसानी होगी, और वो सही ढंग से सही स्पिरिट के साथ उसको हम कॉमन मैन तक जो एक्सेस टू जस्टिस का एक संकल्प है, हमारा गोल है, उसको हम पूरा कर पाएंगे। तो मैं रिक्वेस्ट करूंगा सभी से जो लंच कर चुके हैं वो प्लीज़ बैठेंगे, क्योंकि वहाँ लंच काउंटर्स पे ज़्यादा रश नहीं है, इसलिए जो लोग लंच के लिए जा रहे हैं अर्लीस्ट पॉसिबल वो वापस आ जाएं लंच के बाद, तो बहुत अच्छा होगा, क्योंकि आप बैठे होंगे हॉल में तो अच्छा रहेगा। और अगला सेशन भी वी विल ट्राई टू कंक्लूड, वी रिक्वेस्ट ऑलवेज वी विल ट्राई टू कंक्लूड इन 45 मिनट्स, बिकॉज एट 4 PM वी हैव वैलेडिक्टरी सेशन। और गेस्ट्स ने, एक्सपर्ट्स ने, पैनलिस्ट ने, जो भी डिग्निटीज़ हैं, उन्होंने टाइम शेड्यूल के हिसाब से अपना शेड्यूल जो है रखा हुआ है। सो वी आर ट्राइंग हार्ड टू मेंटेन the schedule and the whole event as per the guidelines and as per the schedule. देवी सज्जनों, आज का जो हमारा तीसरा टेक्निकल सेशन है और इसके बाद वैलिडिक्टरी सेशन है, उसको इसके तुरंत बाद वो भी होगा। तो टेक्निकल सेशन जो कि हमारा भारतीय साक्ष्य अधिनियम 2023 इस पर बेस्ड है, इसकी हम शुरुआत करने जा रहे हैं। ऑडिटोरियम के बाहर हमारे जो भी गेस्ट होंगे उनसे रिक्वेस्ट करूंगा कि वो लोग भी अंदर आकर जगह ले लें, ताकि ज़्यादा से ज़्यादा लोग यहाँ रहेंगे। एक बहुत अच्छी अपॉर्चुनिटी हम सबको इस रूप में मिली है कि इस फील्ड से या इस सब्जेक्ट से जुड़े तमाम स्टेक होल्डर्स, उसकी बड़ी हस्तियाँ जो हैं, बहुत बड़े बड़े विशेषज्ञ, एक्सपर्ट्स, वो सब हम सब के बीच में यहाँ हैं अलग अलग पैनल्स में। तो आइए आपके सामने हम अपना अगला सेशन, जिसमें हम चेयर करने के लिए ऑनरेबल मिस्टर जस्टिस C.D. सिंह साहब, जज दिल्ली हाई कोर्ट, उनकी गरिमामयी उपस्थिति हम सब के बीच होगी। यहाँ को चेयर के लिए श्री M. करुणानिधि, एडवोकेट एंड मेंबर पार्ट टाइम लॉ कमीशन ऑफ इंडिया, वो इस पैनल में हम सब के बीच बैठे होंगे। इसके अलावा श्री राजेश कुमार जी, IPS चीफ एग्जीक्यूटिव ऑफिसर I4C, मिनिस्ट्री ऑफ होम अफेयर्स। I4C मीन्स इंडियन साइबर क्राइम कोऑर्डिनेशन सेंटर। इसके अलावा श्री ज़ुहैब हसन साहब, स्पेशल पब्लिक प्रोसिक्यूटर एनफोर्समेंट डायरेक्टरेट, और श्री अमित प्रसाद जी, स्पेशल पब्लिक प्रोसिक्यूटर एंड एडवोकेट दिल्ली हाई कोर्ट, वे हम सब के साथ इस पैनल में शामिल हैं। और इसे मॉडरेट करने के लिए डॉक्टर K.S. पांडे साहब, प्रोफेसर डॉक्टर राम मनोहर लोहिया, नेशनल लॉ यूनिवर्सिटी लखनऊ। एक बार आपकी तालियों के साथ इन सभी का हम हार्दिक स्वागत, अभिनंदन करते हैं। और फॉर्मली विभाग की तरफ से, मंत्रालय की तरफ से इनका वेलकम करने के लिए और इनका फेलिसिटेशन करने के लिए मैं रिक्वेस्ट करूंगा डॉक्टर राजीव मणि साहब से, सेक्रेटरी सर से, डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, गवर्नमेंट ऑफ इंडिया, जिससे होस्ट करने का ये मौका मिला है इस इवेंट को, इस कॉन्फ्रेंस को। और देश के अलग अलग हिस्सों में भी इसी तरह के कॉन्फ्रेंस की प्लानिंग है, जहां इन विषयों को, नए कानूनों को लेकर लोगों के साथ, लोगों के बीच हम पहुंचेंगे। तो अभी हमारा थर्ड टेक्निकल सेशन जो है, उसमें इसको चेयर कर रहे हैं ऑनरेबल मिस्टर जस्टिस C.D. सिंह साहब, जज दिल्ली हाई कोर्ट। उनका सबसे पहले स्वागत, अभिनंदन करने के लिए मैं निवेदन करूंगा डॉक्टर राजीव मणि जी से कि उन्हें एक प्लांट और साथ में मेमेंटो, तालियां आप सबकी तरफ से ज़रूर होनी चाहिए। उनका बहुत बहुत स्वागत, अभिनंदन है ऑनरेबल मिस्टर जस्टिस C.D. सिंह साहब का। साथ ही को चेयर के लिए जिनकी गरिमामयी उपस्थिति है, श्री M. करुणानिधि साहब, एडवोकेट एंड मेंबर पार्ट टाइम लॉ कमीशन ऑफ इंडिया। We welcome Shri M. Karunanidhi ji, who is going to co-chair this session. बहुत बहुत स्वागत। Then we have Shri Rajesh Kumar ji, IPS Chief Executive Officer, I4C, Indian Cyber Crime Coordination Center, Ministry of Home Affairs. उन्हें भी एक प्लांट और मेमेंटो भेंट करके उनका भी स्वागत इस मौके पर। और ज़ुहैब हसन साहब, ज़ुहैब हुसैन साहब आप जानते हैं स्पेशल पब्लिक प्रोसिक्यूटर हैं इन्फोर्समेंट डायरेक्टरेट में, उन्हें रिप्रेजेंट करते हैं। तो वे भी इस सेशन में हमारे साथ हैं और उनका एक्सपीरियंस और उनके जो व्यूज़ हैं वो भी हमारे लिए बहुत इंपॉर्टेंट होंगे। तो उनका भी बहुत बहुत स्वागत, अभिनंदन इस सेशन में, इस टेक्निकल सेशन में उनकी उपस्थिति के लिए, उनकी मौजूदगी के लिए। आपकी तालियों के साथ उन्हें प्लांट और साथ में एक मेमेंटो भेंट करके उनका बहुत बहुत स्वागत है। और इसके अलावा श्री अमित प्रसाद जी हैं इस पैनल में, जो कि स्पेशल पब्लिक प्रोसिक्यूटर एंड एडवोकेट हैं दिल्ली हाई कोर्ट में। तो उनका भी इस मौके पर बहुत बहुत स्वागत, डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस की तरफ से इस कार्यक्रम में और इस सेशन में, टेक्निकल सेशन में, जो कि भारतीय साक्ष्य अधिनियम 2023 पर बेस्ड है, उसमें वो पधारे हैं। और इस सेशन को मॉडरेट करने के लिए डॉक्टर K.A. पांडे साहब, प्रोफेसर डॉक्टर राम मनोहर लोहिया, नेशनल लॉ यूनिवर्सिटी लखनऊ, वो हम सब के बीच में हैं, लखनऊ से यहाँ पधारे हैं। तो उनका भी इस मौके पर बहुत बहुत स्वागत हम करना चाहते हैं। और उन्हें भी एक प्लांट और साथ में एक मेमेंटो भेंट करके डॉक्टर राजीव मणि जी, सेक्रेटरी डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, गवर्नमेंट ऑफ इंडिया, उनका भी स्वागत कर रहे हैं। तो डॉक्टर राजीव मणि जी का बहुत बहुत आभार, एक बार पुनः सभी का बहुत बहुत स्वागत है। और बिना समय गंवाए ये रिक्वेस्ट करते हुए प्रोफेसर डॉक्टर K.A. पांडे साहब से कि चूँकि 4 बजे से हमारा वैलिडिक्टरी सेशन भी है, तो थोड़ा वो ध्यान में रखते हुए इस सेशन को मॉडरेट करेंगे तो बहुत मेहरबानी होगी। तो मैं रिक्वेस्ट करूंगा डॉक्टर पांडे से कि वे इस सेशन की शुरुआत करें।
Thank you very much. And as you said that we have 35 to 40 minutes. this session, that is the technical session number 3, is on the most technical of these 3 laws. Not only the most technical of these 3 laws, but also there are least number of amendments made in the Indian Evidence Act, that is now the Bharatiya Sakshya Adhiniyam. But the amendments that have been made and the changes that have been brought in, they are so significant that a discussion amongst those who have been practicing in the code of law and those who have been deciding cases based on evidence is need of the hour. So, with permission of chair and also the co-chair, may I straight start asking questions to the panelists. Sir, may I? So my first question is for Mr. Rajesh Kumar. Mr. Rajesh, of these 3 laws that are now going to be unfolded from July 1, 2024, these laws have had a long history. And if we look back into the history and historical events that led to enactment of these laws, would you agree that the evolution of law of evidence in India has been smoother than the other 2 laws, both substantive and procedural? And also what led to the evolution of Bharatiya Sakshya Adhiniyam? Your comments, your opinion on that.
Thank you so much for having me here. And I think there are eminent people on the dais with me who are better in a position to answer that question. But nevertheless, I'll give my take on this. Yes, evolution of this law has been much smoother than any other procedural or substantive law. And I would like to say that this has been because the basic principles of criminal justice are immutable. And in a country where we follow the process of proving a case beyond reasonable doubt, there is not much scope for maneuvering. So the Indian Evidence Act, the way it was in 1872, has more or less substantially remained the way it has been. There were changes which were affected in the year 2000 and 2008 because of the IT Act, and therefore again in 2018 because certain sections had to be included for crime against women, but it has largely remained same. And even if you look at the Bharatiya Sakshya Adhiniyam, there have been very changes which are very wide, will have very wide impact. But compared to the other 2 laws, there has been minimal. These are the least. So I agree with you when you say that this has been more resilient and more time-tested than the other any kind of law. Yeah, and what brought this act? The same philosophy which governs the bringing of the other 2 acts, the BNSS, and the BNS has led to bringing up of this act, the Bharatiya Sakshya Adhiniyam. In that, it has to be more Indianized in the context, and it has to be able to adopt it to the changing circumstances in which it should be adopted to the technological changes that are taking place all around us. Any investigating officer or any judicial officer who is looking at a criminal case would agree that a lot of evidence is found in the digital realm today. And therefore, the law had to be adopted in such a manner that the digital evidence, the electronic documents are considered in the way they deserve to be considered during a course of an inquiry or a trial. And therefore, these cases were brought in. So that's my answer. Thank you.
Thank you for that. My second question is for Mr. Amit Prasad. What, in your views, are 3 most notable features of the Bharatiya Sakshya Adhiniyam that the Indian Evidence Act lacked?
So, to summarize, what I would say is BSA essentially covers up all the missing points which were there. It has updated the rules of evidence regarding the electronic evidence. It has expanded the territorial extent of applicability, and most important thing what it has brought is protection for citizen. So I will just classify these three things. For example, now with the BSA, it classifies what is electronic evidence. It also covers different types of electronic documents and recordings. And most important, it perhaps now recognizes the evidence recorded in this new age. Things like network device, cloud storage, semiconductors, memories, all these are new age technology, and these are in thing today. And those are what needs to be addressed, which was not been addressed in the earlier act. The courts had over a period of time tried to identify these, had over a period of time laid down guidelines, principles to follow, and those have now been incorporated in the new act to fill in that gap. So BSA, to my mind, is a firm step. It's a forward-looking legislation to deal with the new scenario that's there. Second, so far as the territorial expansion is concerned, so for example, we have to rely on, in the cases, on Google search history. Now, Google search history, if I have to prove that Google search history, I have to, one, get that data from Google, which is overseas. I have to lead a witness who is going to produce that evidence. So merely somebody gets the document, it does not become an evidence. It has to be tendered by somebody. Today, to tender that document, I have to call somebody from overseas, or some way I have to manage, or otherwise I cannot tender it. Today, BSA takes care of that. Today, BSA gives me an opportunity that I can record the evidence online through digital mode, and the territorial implication is not there. So a person sitting in US or anywhere else, he can depose there and it can be recorded here. And third aspect which I was saying is regarding the public friendly. We have seen section, that particular section is there regarding accomplice.
138 in the BSA.
BSA.
Yes.
Now, the earlier act was that uncorroborated testimony can become the basis of conviction. Now, the accomplice statement can be basis of conviction only if it is corroborated.
Conviction is not illegal if it proceeds on.
Exactly. So
yes.
The premise is that conviction will not be illegal if it is based on corroborated statement of accomplice. So these are features which are public friendly. So it is for protection of the citizen. These are new features which are there. These are notable changes.
All right.
Anything else?
Just one supplementary question to the point that you mentioned, that how it has a now extraterritorial reach as well.
Yes.
But isn't the law of evidence lex fori? And even if some evidence is collected in some foreign jurisdiction,
yes,
whether that is admissible or not would be tested through the touchstones of the rules of admissibility and relevancy under the BSA and
yes,
not otherwise.
So the point is, during the course of investigation, the investigating agency has taken the search history, or say, or whatever, just let's go by the search history on Google. Now, once they take the search history on the Google, that can be collected by the investigating agency either through MLAT process or LR process, whichever they take. You have got that data. That data does not become an evidence on its own. It has to be converted to an evidence to be read in evidence. Now, how do you convert that into an evidence? By tendering it in court. The person who tenders it in court has to be subjected to a cross-examination. All that process could, if I am relying on that data today under the Indian Evidence Act, I have to get a witness who has produced that document. I have to get his certificate under 65B.
True.
He has to tender the evidence and the 65B, and then he has to be subjected to cross-examination. Now, if a person refuses to come to India, do I have means to get him? I do not. So either he cooperates and he comes. If he does not, then how do I do it? That part is taken care of.
All right, all right, all right. Thank you for that insight into that important issue, of course. My next question is for Mr. Zoeb. Mr. Zoeb, the Bharatiya Nagarik Suraksha Sanhita, it brings in the concept of a trial in absentia in certain cases. So section 24 of the Bharatiya Sakshya Adhiniyam, that corresponds to section 30 of the Indian Evidence Act, adds an explanation that a trial of a person in absentia along with another will be a joint trial. So will it still be a joint trial if both the co-accused persons are tried in absentia, or one must be tried in person to make section 24 of a BSA applicable?
So as I read explanation 2, it appears to be an enabling provision, which basically the essence of the enabling provision is that a person should not, an accused should not take advantage of his own wrong. So if he is absconding, a trial can proceed in absentia, even if the person is not available. Now the interesting feature about your question is, if all the accused persons are absconding, can you still take advantage of confession of one of them? The answer to that lies in section 23, I feel, because confession can be given not only in trial, but even during inquiry to a magistrate. So if a confession has been given by one of the accused persons, then the provision can be interpreted in a manner that it can proceed in absentia irrespective of whether any accused person is available or not. So suppose a person gave concession during inquiry and investigation when he was available, but for some reason at a subsequent stage he has gone missing, absconding. He has, we have seen in our experience, even if there is an LOC, they use the Nepal border route or some other route to escape. So assuming they've all escaped, even then the confession can be used and the trial can proceed in absentia. And I think a little bit of judicial interpretation would be required of this provision to give it full force and flesh it out. So that's my small response to it.
The next question is on the definition of document, which now very specifically includes electronic records as well. And this question is addressed to, once again, to Mr. Rajesh Kumar. Mr. Rajesh, the definition of document in section 2(1)(d) of Bharatiya Sakshya Adhiniyam, this now specifically includes electronic and digital records, and a new illustration has also been added to exemplify this. Additionally, the definition of evidence in section 2(1)(e) of BNS, it includes statements given electronically. So, would you please explain the practical implications of these changes?
Okay, so these are two game changer amendments that have been brought about in our opinion. Now, the change that has been brought in Section D in the definition of document, it has inserted the word by means any matter expressed or described or otherwise recorded. So it can be recorded electronically as well, magnetic, optical, any other, on any other kind of a storage. And in the last sentence, that document includes electronic and digital records. So that once and for all, it is settling the debate whether electronic record in the form of an SMS, a log, or something which is stored on the cloud, whether it is document or not. So it is once and for all settles that it is a document, and it will have the same validity as something which is in print form or signed form. So this will go a long way in helping the prosecution in cases where evidence lies in the digital realm. And we are seeing that almost in every criminal case, we will find some evidence in the digital space. Now, this has been further elaborated in the illustration as in so many words. In 6, it says it will include an electronic record on email, server log, documents on computers, laptops, smartphones, messages, websites, locational evidence, which is saved in the form of a log on a cell phone, voicemail messages stored on digitals, and they will be documents so far as the purpose of this is concerned. Now, to support this, it was necessary to bring the change in what is evidence. So it is saying that we will include statements given electronically. Now, the distinguished panelist when he was speaking about electronic evidence, we see that during trial, you will not find the people who were associated with that investigation. So some people get retired, some people go somewhere else. And especially in cybercrime, we will find that the person who has to give evidence may be in another part of the world. We are seeing that a lot of evidence is there on the cloud, and the biggest cloud service providers in this world are all located out of US. So even if we are able to get a certificate and we want that person to adduce evidence at the time of the trial, this is the enabling provision. So this is going to reduce the time taken to complete a trial. This is also going to reduce time taken during investigation. So now this provision will help me in sending my summons and warrants electronically as well. From across this, from one part of one police station or one court to another court, we can just use this provision to shorten the time we need to complete an evidence or complete any process that is mandated. So these two are very significant, and read with how the changes have been made in the definition of primary and secondary evidence, it is going to be a game changer, and it is the need of the hour, given the volume of electronic evidence that needs to be gathered in any kind of an investigation these days.
Thank you. That brings me to another very important improvement or change that has been brought in. In fact, the definition of primary evidence, which is now section 57 of Bharatiya Sakshya Adhiniyam, it has come up with the 4 new explanations. That's a very substantial and significant addition. Explanation number 5 clarifies that where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. So my question is to Mr. Zoeb again, that what in your opinion would amount to proper custody, and what potential disputes do you envision in this regard?
As rightly pointed out by my learned brother, my learned friend here, that this is one of the foremost achievements of this act, the new act, is that now electronic evidence can be introduced as primary evidence. The challenges on the ground that I foresee is that the lower judiciary will require sufficient standard operating procedures, training to be able to accept and introduce how to introduce primary evidence. For instance, if you have phone recording, or if you have CCTV footage, or if you have other kind of electronic evidence which is sought to be introduced, what will be the best practices to introduce them? How to see the proper custody, like you said, is there any discernible clue in the law as to proper custody? For instance, one of them I was seeing, if you could turn to explanation to 81, gives some clue where the origin is legitimate, it would amount to proper custody. So these will be questions which will have to be thrashed out in courts over a period of time. How to accept a document or electronic evidence which may have got, part of it may have got infected by malware. So for all these things, it will be an evolving process, but it will require significant training at the lower level, at the level where the evidences will be introduced for the first time. Now, there's another very unique feature which maybe we'll discuss later. When you are introducing electronic evidence, unlike 65B, today there is a form which requires an expert certificate. Who is an expert? For that, there is some clue in the Act, that is the examiner who is notified by the central government. But the common man, will he have access? So there will be questions which will arise. So it's something that we have to keep an eye out.
True. And that exactly would be my next question, again addressed to Mr. Rajesh Kumar. As Mr. Zoeb said that there are many concerns that would be raised from July 1, 2024 itself regarding admissibility of an electronic record. So when you see the structure of BSA, you would find that section 61 of Bharatiya Sakshya Adhiniyam is a new provision which categorically recognizes electronic and digital record as having the same legal effect, validity and enforceability as paper records, subject to section 63 of Bharatiya Sakshya Adhiniyam, that is section 65B of Indian Evidence Act. Now, as you pointed out, that now there is a schedule appended to the Bharatiya Sakshya Adhiniyam, and that schedule has one form that must mandatorily accompany any electronic evidence which is secondary in nature. And though some kind of a certification or certificate was required, even under section 65 capital B, but there was no format. I remember that in PV Anwar versus PK Bashir case, the Supreme Court had said in 2014 that it should be a declaration that the computer or the computer system was properly functioning and should be signed by just one or a couple of people who were in charge of that computer system. That requirement has been made more stringent. So my question is that what are the potential hurdles that you see in this regard that would be impacting the litigants when they would be trying to rely on secondary evidence of an electronic record?
Okay, so this earlier no pro forma was prescribed. Now in the annexure we have this, and there are two parties where the party has to sign and then an expert has to be signed. Now, as the distinguished panelists spoke about, we may not be having that number of experts today, but in due course we will have as many experts. Other issue which was brought is that do we have sufficient capacity at the level in the districts or at the municipal court or any lower court level? The government is in the process of creating those capacities. In fact, if you look at the cabinet in the month of February had decided that they are going to spend around more than over 2,000 crores just to build those kind of facilities, right from the national digital forensic labs up to the state and even the mobile forensic lab. So the capacity to issue that certificate is definitely going to increase. The government is seized with that matter and it's already acting on it. In fact, training of government officials in all the three major wings of the criminal justice system has already started, and Bureau of Police Research and Development is on the task to do this. So yes, when the transition takes place in July, we may have a bit of a problem to begin with, but this was time and again taken up with all the states, and they are at it. And we hope that once it gets rolled out, within no time or within a very short period of time, we will be able to create infrastructure at the grassroots level so that this doesn't become an issue, it doesn't become difficult to secure this kind of a certificate. Sir.
Hello. One second.
Sir.
For understanding of all three things, I think we have to go by first section 39.
Sir.
Section 39 says about the expert opinion.
Yes.
And then we have to go by section 57, which are the corresponding section of 61 of the old act. Then 58, that is secondary evidence, then 61 of the new act, and 65. The 65 is also required under section 65, the expert certification as per the schedule. But in the new act, that 37 act has relaxed that anybody can be expert, can certify that documents. Therefore, it will be easier now to certification of the electronic documents as per the section 37.
All right. All right.
Please read 37. 39, yes.
39 is
yes.
What is section 45 of the Indian Evidence Act?
Yes.
Yes.
Now expert is now the relaxed, broader sense.
All right.
Now the technical person are the people who knows that, are the expert person who knows that about documents. Can any can be
Any
expert?
person.
Any person.
From
can
any
be,
field may be
any
an expert.
field, maybe.
Maybe an
Can
expert.
certify that set documents.
That's very significant improvement from section 45. Indeed. Indeed. Thank you, sir, for this very important intervention. Now, because we are running short of time and it's almost 5 minutes, only 5 minutes to 4 o'clock, when this valedictory is supposed to start. May I ask this, breaking from tradition and with the permission of the chair, may I ask this final question to Mr. Karunanidhi. Mr. Karunanidhi, this question is on section 120 of the Bharatiya Sakshya Adhiniyam, which corresponds to section 114 capital A of the Indian Evidence Act, which talks about presumption in certain cases of rape. Section 120 of BSA limits its scope to the punishment for rape under section 64 clause 2 of Bharatiya Nyaya Sanhita, which are though aggravated forms of rape, but gang rape of an adult woman punishable under section 70 clause 1 of Bharatiya Nyaya Sanhita has been left out. So your comments on this, and do you think that this needs to be rectified at the earliest?
Thank you for, hello. Thank you for having given me this nice opportunity, sir. Sir, to my view, this is a cautious omission. In general, in case of a rape, the learned defense counsel would argue the consent of a woman can be inferred. If the consent is not obvious, the consent of the rapist of the woman can be inferred from the evidences adduced on the side of the prosecution. So, the lawmaker so consciously used the word in section 120 of BSA, let me read, sir. And such woman states in her evidence before the court that she did not consent. Insofar as section 64 bracket 2 of Bharatiya Nyaya Sanhita 2023. It speaks about rape, but does not include gang rape.
Gang rape.
To my view, even as per the moral view was taken by the lawmaker and consciously omitted, even on consent, those offenders should not be left out. That is why lawmaker so consciously framed these provisions.
Thank you for your comment, sir. And of course, please.
Very quick comment.
Please.
If you see the categories in 64(2), which are aggravated forms of rape, even there the concept of unequal power between the person accused and the victim is noted in some of the categories.
True.
For instance, during sectarian violence, etc.
True.
So therefore, personally, I felt something incongruous that it should have been included. The presumption should be extended even to gang rape, because this is a very progressive legislation. And there has been judgments under 376D, which where the presumption does not extend, MP High Court, etc., have taken a view that this appears to be a oversight by the legislature, but we cannot provide casus omissus. But I think a progressive judge may as well feel and say that I'm extending 120 presumption to even gang rape. And maybe I'm sitting next to one of them.
Very rightly observed. And I would just add to it that prior to 2013, it was not so. I remember that before those amendments were made in the punishment provision, section 376 of IPC, gang rape was punished under section 376(2), and this presumption of section 114 capital A would apply to gang rape as well. But since 2013, it has unfortunately perpetuated. So thank you very much for very insightful comments, all the panelists. And before I request Honorable Chairperson of this session, Justice Singh, for his final remarks, may I request the audience, if you have a question or two, we can take those questions and direct those questions to the learned panelists. All right. Thank you very much for that. So, without further ado, may I now request the Honorable Chairman, sir, for his final comments on Bharatiya Sakshya Adhiniyam. Thank you very much.
Good afternoon to everyone. I would like to take this opportunity to express my gratitude to Ministry of Law and Justice for organizing such a most needed conference after the enactment of the last year by the Parliament, the new evidence law, or in two others, criminal laws. When we are sitting in the rear room, we have discussed something with Joab and others panelists. I'm also thankful to the Dr. Pandey and all panelists. They have covered, I think, most of the area of the new Evidence Act, that is Bharatiya Sakshya Adhiniyam 2023. One question asked by Mr. Joab, that suppose if evidence was collected prior of this act commence in July 2024, how the prosecution will proceed, whether by new law or the old law, and if trial is not commenced, as per section 170. So that is one question I think every panelist can be, I have given the answer, but I am inviting this answer on that point also. This is the one. Second, I have also some concern, because this is a law enacted after 175 years. It was needed due to some reasons, due to the pendency in the criminal matters. About 5 crores matters, 3 crores are from the criminal matters are pending in the courts. Second, for the Evidence Act, why the Evidence Act has been enacted, decriminalization of the law. Second, humanize of the law, and the modernization of the law. Modernization, I have discussed that electronic evidence now became a primary evidence, can be acceptable as per the certain definition 2, section 2, and section, this is section 2(1)(d) is definition of documents. Section 2(1)(e) is definition of evidence. Section 24 is very important section, where the proclaimed offender can be tried with the other co-accused also. Third, definition of the expert in section 39, 57, 58, 61, 65, 90, and 122. These are the sections which are included in the new law, is, I think, a great change in the old law. The concern is that Evidence Act is not like a criminal other law. Evidence Act is also applicable in the civil law also. Whatever the definition in the Evidence Act which are applicable in the civil matters or civil cases, whether the changes in CPC is required or not required. That is also discussed in the rear room by all the panelists. There is one concern that has to be addressed, and this is my personal opinion, that CPC is also required to be changed. In the courtroom, 30 years, 40 years, matters are pending. Due to now the evidence has changed, how this change of the Evidence Act can be applicable in the CPC or in the civil law. Second thing is, there's artificial intelligence and data protection. Two things are very important for the accessibility of the electronic evidence or its digital signature, digital evidence. We are not expert, not in India and all over the world also, how to collect the electronic evidence, how to put in that safe custody, how do you check the frauds. Suppose, that is one question as asked by Dr. Pandey to Joab, that how the expert, because expert is necessary to give the certificate of the documents. If anybody has given the investigating agency collected the evidence, and that evidence can be changed by defraud not in India, but sitting in America also. That are the challenges. And that challenges can be addressed when this acts came into the action. I think 170, you have to address on that 170. What was the result if the evidence has been collected and trial has not commenced? What will be happening?
Very helpfully, the discussion led to the conclusion that the evidence, if it is collected prior to the coming into force of this law, would be governed by the prior law. And I think that's the only logical way to proceed. Otherwise, there will be an anomaly and incongruity which the legislature never envisaged. So I think, thank you, sir. Thank you. That was
probably an equally intriguing question would be that suppose offense is committed on 29th of June and the evidence is collected on 2nd of July. So what would be the law applicable in that case is also something that not only from the perspective of law of evidence, but also from procedural laws perspective.
Evidence Act is a procedural law. Therefore, procedural laws can apply
retrospectively
to events that has happened earlier.
True. Correct.
So there's no problem.
Correct. So that brings this panel discussion to a close. I must extend my gratitude to Honorable Chair, Honorable Co-Chair for gracing this panel discussion and giving very, very insightful comments on that. The panelists deserve a special thanks for very, very insightful answers to the questions that I was a little hesitant when I framed that whether those questions would be eliciting the desired responses or not. So thank you one and all. Thank you the organizers for this wonderful opportunity. Thank you once again. Thank you very much.
Thank you so much, Professor Dr. K. Pandey Sahab, Professor राम मनोहर लोहिया, नेशनल लॉ यूनिवर्सिटी लखनऊ से आप आए और मॉडरेट किया इस सेशन को। बहुत बहुत धन्यवाद। बहुत बहुत आभार व्यक्त करना चाहेंगे हम इस सेशन को चेयर कर रहे ऑनरेबल मिस्टर जस्टिस सी डी सिंह साहब, जज दिल्ली हाई कोर्ट, को चेयर श्री एम करुणानिधि साहब, एडवोकेट एंड मेंबर पार्ट टाइम लॉ कमीशन ऑफ इंडिया, उनका भी बहुत बहुत आभार। We had in this panel Rajesh Kumar ji, IPS Chief Executive Officer, I4C, Ministry of Home Affairs, Government of India, उनका भी धन्यवाद। Zohaib Hussain साहब, Special Public Prosecutor, Enforcement Directorate, और अमित प्रसाद जी, Special Public Prosecutor and Advocate, Delhi High Court, आप सभी का बहुत बहुत धन्यवाद। Thank you very much for joining us। और इस सेशन को जो अपने आप में ये भी बहुत इंपॉर्टेंट था, हमारे 3 लॉज में से ये लास्ट टेक्निकल सेशन, उसमें आप सब विराजे और समय का पांडे साहब ध्यान रखा आपने, इसके लिए और ख़ास तौर पर धन्यवाद आपका। बहुत बहुत धन्यवाद हमारा सर। हाँ तो इनकी अपनी मजबूरी थी पर फ़ायदा हम सबका हुआ है क्योंकि थैंक यू सो मच, सो काइंड ऑफ यू सर। सो क्योंकि वैलिडिक्टरी सेशन जस्ट अब हम शुरू करने वाले हैं और इसके तुरंत बाद, सो प्लीज़ जस्ट वी विल टेक 5 minutes टू रीअरेंज द स्टेज. सो थैंक यू वेरी मच फॉर ऑल द panelists. Thank you, sir. देवी सज्जनों, हमारे आज के इस वैलेडिक्टरी सेशन में हमारे साथ स्टेज पर हमारे इस सेशन में मुख्य अतिथि के रूप में आगमन हो चुका है ऑनरेबल मिस्टर जस्टिस PS नरसिम्हा, जज सुप्रीम कोर्ट ऑफ इंडिया। उनका बहुत बहुत स्वागत, बहुत बहुत अभिनंदन है आप सबके करतल ध्वनि के साथ, आपकी तालियों के साथ इस सेशन में। मैं डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, गवर्नमेंट ऑफ इंडिया की ओर से आयोजित इस कॉन्फ्रेंस में ऑनरेबल जज सुप्रीम कोर्ट ऑफ इंडिया ऑनरेबल मिस्टर जस्टिस PS नरसिम्हा के साथ साथ इस सेशन में मंच पर जिनकी गरिमामयी उपस्थिति है, उन सभी विभूतियों का, उन सभी डिग्निटरीज़ को भी मैं वेलकम करता हूं। ऑनरेबल जज सुप्रीम कोर्ट ऑफ इंडिया ऑनरेबल मिस्टर जस्टिस संजय करोल साहब, उनका भी बहुत बहुत स्वागत आपकी करतल ध्वनि के साथ, आपकी तालियों के साथ। जज दिल्ली हाई कोर्ट ऑनरेबल मिसेस जस्टिस रेखा पल्ली जी, उनकी उपस्थिति को भी हम नमन करते हैं, स्वागत करते हैं। और स्पेशल कमिश्नर ऑफ पुलिस ट्रेनिंग दिल्ली पुलिस छाया जी का भी इस अवसर पर हम स्वागत अभिनंदन करते हैं, उनकी उपस्थिति भी है इस कार्यक्रम में। इसके अलावा लर्नड एडिशनल सॉलिसिटर जनरल दिल्ली हाई कोर्ट चेतन शर्मा जी, उनका भी बहुत बहुत स्वागत है आज के इस कार्यक्रम में। और स्टेज पर डिपार्टमेंट ऑफ लीगल अफेयर्स के सेक्रेटरी मिस डॉक्टर राजीव मानी जी और एडिशनल सेक्रेटरी डॉक्टर अंजू राणा जी, वे भी उपस्थित हैं। उनका और आप सभी का बहुत बहुत स्वागत, बहुत बहुत अभिनंदन है। At the outset of this valedictory session, I will request Dr. Rajiv Mani ji, Secretary, sir, to felicitate and welcome all the dignitaries on the stage. And first of all, मैं Dr. Rajiv Mani ji से request करूँगा कि Honorable Mr. Justice PS नरसिम्हा sir, Judge Supreme Court of India, जिनकी गरिमामयी उपस्थिति आज के इस valedictory session में है, जो बहुत important conference आज डिपार्टमेंट ऑफ लीगल अफेयर्स ने ऑर्गेनाइज किया है, नए 3 क्रिमिनल जो लॉज हैं उसको लेकर, उसमें वैलिडिक्टरी सेशन में आपका आगमन हुआ है। विद ए प्लांट एंड एक मेमेंटो भेंट करके उनका बहुत बहुत स्वागत, बहुत बहुत अभिनंदन है आज के इस मौके पर उनका। आदरणीय ऑनरेबल मिस्टर जस्टिस PS नरसिम्हा, थैंक यू वेरी मच फॉर कमिंग सर। एक मेमेंटो भी है, वो भी भेंट करने के लिए मैं रिक्वेस्ट करूँगा। डॉक्टर राजीव मणि जी से मैं फिर से रिक्वेस्ट करूंगा ऑनरेबल मिस्टर जस्टिस संजय करोल जी, जज सुप्रीम कोर्ट ऑफ इंडिया, उनकी भी गरिमामयी उपस्थिति है आज इस कार्यक्रम में। उनका भी हम इस अवसर पर आप सबकी तरफ से डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, गवर्नमेंट ऑफ इंडिया की तरफ से बहुत बहुत स्वागत करते हैं। उनका भी बहुत बहुत अभिनंदन है आज के इस आयोजन में उनकी गरिमामयी उपस्थिति के लिए। ऑनरेबल मिसेस जस्टिस रेखा पल्ली जी, ऑनरेबल जज दिल्ली हाई कोर्ट, उनकी गरिमामयी उपस्थिति है आज के इस कार्यक्रम में। मंच पर उनका स्वागत करने के लिए भी मैं डॉक्टर राजीव मणि जी से रिक्वेस्ट करूंगा कि उन्हें भी एक प्लांट और एक मेमेंटो भेंट करके उनका भी स्वागत करें। और स्वागत में आपकी करतल ध्वनि, आपकी तालियों की गूंज इस स्वागत को और भी गरिमामयी बनाएगी। एक मेमेंटो भेंट करने के लिए भी निवेदन करूंगा डॉक्टर राजीव मणि जी से। छाया शर्मा जी, स्पेशल कमिश्नर ऑफ पुलिस ट्रेनिंग दिल्ली पुलिस, वे भी हम सबके साथ यहाँ स्टेज पर इस सेशन में डायस पर मौजूद हैं मंच पर। मैं उनका स्वागत करने के लिए भी डॉक्टर अंजू राणा जी, एडिशनल सेक्रेटरी, उनसे रिक्वेस्ट करूँगा कि वो यहाँ छाया जी को प्लांट भेंट करके और साथ ही मोमेंटो भेंट करके आपकी तालियों के साथ उनका स्वागत अभिनंदन करें। एंड ऑल्सो इन दिस सेशन वी हैव ऑन डायस लर्नड एडिशनल सॉलिसिटर जनरल दिल्ली हाई कोर्ट चेतन शर्मा जी, उनका भी स्वागत अभिनंदन इस मौके पर करने के लिए मैं निवेदन करूंगा। उन्हें भी एक प्लांट भेंट करके और साथ ही एक मोमेंटो भेंट करके डॉक्टर राजीव मणि सर, सेक्रेटरी डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस, वे उन्हें एक प्लांट और मोमेंटो भेंट करके उनका भी स्वागत अभिनंदन करेंगे आज के इस मौके पर उनकी उपस्थिति के लिए। इन सभी का हम बहुत बहुत स्वागत, बहुत बहुत अभिनंदन वंदन करते हैं। देवियों सज्जनों, आप सभी का भी, और सभी आप में से अधिकांश लोग सुबह से इस कॉन्फ्रेंस का हिस्सा बने, उसको विटनेस किया, पार्टिसिपेट किया, आप सबका एक बार फिर से बहुत बहुत स्वागत अभिनंदन है। एक मोमेंटो भी भेंट करने के लिए निवेदन है डॉक्टर राजीव मणि जी से। आभार डॉक्टर राजीव मणि जी का, और स्वागत एक बार फिर सभी हमारे अतिथियों का। Ladies and gentlemen, before we invite the dignitaries on dais to share their views, I will invite Dr. Rajiv Mani sir, Secretary, Department of Legal Affairs, Government of India, to present before you a summary of proceedings of all the 3 technical sessions held today. Dr. Rajiv Mani sir.
respected chief guest for the valedictory function, Honorable Mr. Justice P.S. Narasimha, Judge Supreme Court of India. Honorable Guest of Honor, Mr. Justice Sanjay Karol, Judge, Supreme Court of India. Honorable Guest of Honor, Honorable Mrs. Justice Rekha Palli, Judge, Delhi High Court. Learned Additional Solicitor General of India, Shri Chetan Sharma Ji, Delhi High Court. Ms. Chaya Sharma, Special Commissioner of Police, Delhi Police. All the esteemed guests in the audience, a warm welcome to all of you. We have now reached the valedictory session of today's one-day conference on the 3 criminal laws. And with this, this is the culminating event of today's conference. And I think I'll take this opportunity to sum up the highlights of today's discussion on the various agendas which the 3 technical sessions had undertaken. The first inaugural session, of course, was regarding the inauguration of the conference by the Honorable CJI in the presence of Honorable Law Minister, Shri Arjun Ram Meghwal Ji, and other dignitaries, namely the Learned Attorney General for India, the Learned Solicitor General of India, and the other heads of various law enforcement agencies were there, besides Secretary Justice, who's my senior colleague in the Ministry of Law and Justice. Honorable CJI gave a very detailed address on this theme of the conference and concluded by affirming India's significant overhaul of its criminal justice system, emphasizing the victim-centric laws, citizen-centric approach, and leveraging technology for efficiency and transparency, highlighting the importance of adopting of technological advancement to meet the objectives of the new laws. The first technical session was organized on the Bharatiya Nyaya Sanhita, BNS 2023. The panelists, the chair was our former Law Secretary and presently Judge, Delhi High Court, Justice Anup Kumar Mendiratta ji. And he emphasized that the transition from the Dand to Nyaya Prakriya in the legislation focuses on the importance of justice and the reform which has been undertaken to free the citizens of the country from the colonial mindset, which was based on the theory of retribution and did not recognize the importance of the rendering of justice to the citizens concerned, who are the very important stakeholders of this legislation. The reorganization of the offenses, particularly with detailed chapter on offenses against women and children, was also highlighted. We had the Learned Additional Solicitor General, Ms. Aishwarya Bhati, who actually laid a detailed emphasis on the provisions pertaining to women and children and the changes which have been brought about in this new law. The introduction of community service as a form of punishment and balance between over-criminalization and decriminalization were also discussed, indicating a shift towards more balanced and reformative approach. Despite enhancement in punishments, deterrence lies in the certainty of being caught, while the law aims to decolonize the addressing issues like sedition and ensuring dignity and security for women. The second technical session was on the Bharatiya Nagarik Suraksha Sanhita, BNSS, which in fact makes a significant shift towards a more victim-centric and accountable criminal justice system. The point was highlighted by the chair of the session, Honorable Justice Ashwini Kumar Mishra, Judge, Allahabad High Court, and co-chaired by Honorable Mr. Justice K.T. Shankaran, former Judge, Kerala High Court, and presently member, Law Commission of India, besides the other panelists. The introduction of accountability measures for prosecutors, victim-centric provisions, and emphasis on digitization reflect a concerted effort to enhance transparency, efficiency, and fairness in administration of justice. Speakers such as Shri Vikramjit Banerjee, Learned Additional Solicitor General of India, Shri Vinod Kumar, District Judge, Shri D.C. Jain, IPS Officer and Special Director, CBI, Shri Praveen Kumar, Additional Director, IB, Shri E. Chandrasekharan, Advocate, Madras High Court. They gave very valuable insights into the various provisions and underscored that the potential impact of BNSS on various aspects of criminal justice, including its impact on reduction of pendency, empowerment of victims, and adoption of technology. Additionally, additional considerations were made with regard to the influence of BNSS on the Digital Personal Data Protection Act, emphasizing the importance of a robust data protection measure. Overall, they were of the firm belief that BNSS is poised to usher in a transformative era in India's criminal justice system, promoting accountability, transparency, and protection of rights for all the stakeholders. The third technical session was on the Bharatiya Sakshya Adhiniyam, BSA 2023. And we had, the chair was Honorable Justice C.D. Singh, Judge, Delhi High Court, besides prosecutors such as Shri Zohaib Hassan and Shri Amit Prasad. The panel emphasized the aspects of modernizing the law of evidence by recognizing electronic and digital records as documents and evidence, and expanding the territorial applicability, introducing the concept of trial in absentia, changing provisions related to rape, punishment, accomplice evidence, communications between ministries and the president, electronic signatures, and corroborated evidence for conviction. The discussions covered the rationale, practical implications, potential hurdles, and notable features of these changes, as well as the need for aligning the CPC, addressing artificial intelligence and the data protection issues, and determining the law's applicability in the pending cases. The technical sessions overall gave a deep insight and the thoughts which were shared by the esteemed panelists, and the question answer session, which was a very valuable addition to this technical sessions, which was raised by many members of the audience, actually showcased the significant strides and the impact which these three new laws is going to have on transforming the criminal justice system in India. The 2024, when these laws come into effect from 1st of July, we will witness a concerted effort not only to modernize, reform, and enhance the various facets of our infrastructure relating to these justice dispensation exercises, but also the laws would put in place a strong emphasis on fairness, efficiency, and accountability. As we are focusing on India's progressive path in the administration of the criminal justice system, it is essential to acknowledge the collective efforts of all the stakeholders involved in this transformative journey. Policymakers, legal professionals, law enforcement officials, civil society organizations, and most importantly, the citizens of the country. It is through our collaborative and collective commitment that we have been able to advance towards a more just, equitable, and progressive administration of the criminal justice system in the country. On behalf of the Department of Legal Affairs, Ministry of Law and Justice, I would like to thank all the audience and all the panelists who have contributed in this important discourse, especially on raising very pertinent issues which are going to have some implications on the implementation of these laws. And I think the deliberations would throw new light and iron out many of the confusions which are there as with regard to that easy implementation of these laws. In the end, I thank everyone and all the audiences, and now I leave the floor open for proceeding of the valedictory session. Thank you. Dhanyavad. Jai Hind.
बहुत आभार डॉक्टर आचार्य माने जी का. Now I will request the learned additional Solicitor General Delhi High Court, Shri Chetan Sharma ji, to come forward for his address, please. Shri Chetan Sharma ji.
सभी को नमस्कार. Honorable Justice Narasimha, Judge, Supreme Court of India, Honorable Justice Sanjay Karol, Judge, Supreme Court of India, Honorable Justice Rekha Palli, Honorable Judge, Delhi High Court, Madam Chaya Sharma, Special Commissioner of Police, deputizing in absentia of the Commissioner who had a sudden engagement, Shri Rajiv Maniji, Secretary, Ministry of Law, Madam Anjurati Rana, Additional Secretary. On the dais, off the dais, Honorable Justice Chandradhari Singh Ji, my esteemed colleague, Additional Solicitor General of Bihar, Singh Sahab, other dignitaries, Adhish Agarwal ji, President Supreme Court Bar Association, dignitaries whom I know but can't take much of time because then they'll say कि साहब आपने काम अपना ठीक नहीं किया. And especially present in strength, all central government standing councils. I mean, one has to give a round of applause for them. Senior panel councils, the manner in which you have participated is really praiseworthy. So today is, in more ways than one, a watershed moment. Because this is for the first time that we are discussing these three new laws. The bulwark and the rigor of their sections has been detailed in the technical sessions, but the takeaways are important in a valedictory address. The Honorable Minister in the morning, he said, after the learned Solicitor General of India had painstakingly drawn the highlights of the new laws, तो उन्होंने एक चीज़ कही कि आपने धाराएं बताई हैं, मैं धारा की बात करता हूं. तो मैं जिस पृष्ठभूमि से आपको संबोधित कर रहा हूं, मैं धाराएं भी नहीं छोड़ सकता और धारा को तो बिल्कुल ही नहीं छोड़ सकता. धाराएं आपने अभी अभी टेक्निकल सेशंस में यू हैव बीन थ्रू दैट. धारा की बात करते हैं. सुप्रीम कोर्ट के पीछे लिखा है यतो धर्मस्ततो जयः, यतो जयस्ततो धर्मः, धर्म वीर्यो जयो राजा, धर्मो राज विजयः स्मृतः. ये मूल है हमारे सुप्रीम कोर्ट की जो आधारशिला है, ये मूल है. और ये कहाँ से आ रही है? ये उस मीमांसा से आ रही है जहां गीता का लास्ट श्लोक जो है, तत्र पार्थो धनुर्धरः, यत्रो श्री कृष्ण का जहां धर्म है वहीं विजय है. तो धर्म इस देश का एक सजीव आत्मा का स्पंदन है. दिस नेशन सर्वाइव्स, थ्राइव्स, मूव्स ऑन बिकॉज ऑफ द स्तंभ ऑफ धर्म. इसलिए राम को भी कहा गया है रामो विग्रहवान धर्मः, एवरीथिंग इज रिलेटेड विद धर्म. तो न्याय का जो हमारा ये सारी पृष्ठभूमि है, न्याय प्रक्रिया जो जितनी भी हमारी है, अगर ये धर्म से विहीन है तो ये हमारी संगति नहीं है. ये हम it's alien to us, and that is what the speakers in the morning said. We are to now let go of the मानसिकता जो परतंत्रता की मानसिकता है. We need to get rid of that. क्योंकि आपका जो धर्म है, श्रुतियां हैं, मीमांसा है, मनु है, जितने भी आपका बेस है, ये सारा धर्म के ऊपर बेस्ड है. इसीलिए एज द सोलिसिटर सेड, फ्रॉम ए रेजीम ऑफ इन्फ्लिक्टिंग पनिशमेंट, covering down the subjects so that the British rule is embossed on their minds and in their hearts and in their souls, so that the natives do not revolt in any manner. You have a regime of punishment. Now this, ये जो 3 कानून आए हैं, from punishment now it becomes the regime of justice. इसीलिए ये victim friendly and accused की natural justice. There are some provisions corresponding to 200 section 200 CRPC. पहले तो ये था कि साहब the complainant is ousted, it will be completely state. But now the major change is that the victim will be heard and the accused will also be heard to say he can also plead. सो देखिए प्रिंसिपल्स ऑफ नेचुरल जस्टिस जो हमारे धर्म के साथ समन्वय लेती हैं वो किस तरह से इसमें प्रस्तुत हो रही हैं, अवस्थित हैं रादर, प्रस्तुत नहीं अवस्थित, अब तो अवस्थित हो गई हैं, जुलाई से तो अवस्थान है ये. So this is the foundation of the theme of this conference. I must compliment the Ministry of Legal Affairs, Rajiv Mani ji, and his entire team, Anju ma'am, और जितने भी officials हैं. It's not easy to host such a large-scale mega function of a variety in which the intellect is really picked up to debate the finer points. Five points need to be highlighted. If I get into that, then I'll eat away all the time of my other co-panelists, which I certainly intend not to do. Removal of archaic and insensitive terms. You would have gone through that. तो अब ये lunatic, जो asylum था, ये सब निकल चुका है. We are more sensitive now. एक बहुत sensitivity के साथ कानून को इसमें लाया गया है. Metropolitan magistrates, उसको आपने हटा दिया है. Clarity in certain procedures हैं, which now in the chapter of bail, under chapter 35, a new section 479 has been added, which in the beginning only clarifies the scope of certain words. And for the first time, bail, bond, and bail bond have been enumerated. So mercy petitions be ab jo hain, they follow a guideline in the statute, which is as per section 473. The third part is progressive safeguards and changes. Isme section 311A CRPC, and which is now 349 of the new Sanhita, ki fingerprints, voice samples will be primary evidence admissible. Section 176 corresponding to 157 CRPC, by adding a new subsection, the police, when they receive information about the commission of a crime punishable for more than 7 years, it is mandatory for a forensic team to visit the scene and collect samples as well as cause videography of the process. Now this is a tectonic shift, because as the Honorable Chief Justice of India mentioned in the morning session, he laid emphasis on section 531 and 532, which is a total transformation of digitalization of the entire process. So when jurisdictions have been done away with, it is an e-jurisdiction. That's an all-encompassing e-jurisdiction, which is faster, which is not hedged by any subjectivity of either of the police officer or other people who seek to wield their influence over the first crime that has been committed. The victim, which was defined for the first time in the CRPC in 2009, safeguards were lacking. A proviso has been added to section 232 of the BNSS, corresponding to section 209, where during the committal proceedings an application filed by the victim shall also be forwarded to the Sessions Court. Similarly, copies of documents such as police reports supposed to be supplied under 207 shall also be supplied to the victim or his advocates. So victim-centric है ये. जिसके साथ ज़्यादती हुई है, उसको तो हमने अभी तक बिल्कुल एक तरफ लगा रखा था, उसको तो उसकी सुनवाई नहीं थी. But now it's a huge shift. और इसी बात की balance की बात हुआ है. So the victim has a role now statutorily, and the accused also will get natural justice to say कि साहब, I am as innocent as Chetan Sharma. ये चीज़ आपको मिल चुकी है by the new enactment. Now, साहब मुझे बता देना when I have to stop, because अब गाड़ी गर्म हो चुकी है. नहीं बताएंगे तो then self-imposed. So there is a new clause 193, which corresponds to 173(2), where the police is mandated to inform the victim about investigations program within 90 days, which can be done electronically. Just see the kind of the change that is there. कि who is the जिसके साथ ज्यादती हुई है, the victim, how he is at every stage being brought in so that he doesn't feel left out, so it doesn't become so and so versus state. और वो बेचारा देखता रहता है दीवारों को कि मेरा क्या होगा, मुझे तो कोई सुन नहीं रहा. But now things have changed. This is the major change, and which has been highlighted in the morning and in the technical sessions also. One more thing. Section 191 of the BNSS, corresponding to Section 171 of the CRPC, after completion of investigation, before submission of the police report, the police are not mandated to arrest an accused simply to secure his presence before a judicial magistrate. Yeah, this is another huge change. This change is in line, actually, now it has been incorporated. The Honorable Supreme Court in Satyendra Kumar Antil versus CBI 2022 10 SCC page 51 में इसके लिए सुप्रीम कोर्ट ने ये कही थी, जो कि अब आपके सेक्शन 190 सब सेक्शन 1 में इनकॉर्पोरेट हुआ है. So those of you who wanted me to speak only on philosophy are disappointed. I am speaking on the nuts and bolts of the matter here. So this there are many first-time offenders के लिए humane change has been brought in. जो vulnerable sections of the society है, that will correspond now. That will be now 195(1) BNSS, corresponding to section 175(1) CRPC regarding the police to summon people. As per this proviso, now people belonging to vulnerable categories will not be mandated to attend, quote unquote, any place other than the place where they reside. अब ये भी खत्म हो गया है. So this is the overarching jurisdiction. Now the fourth point, which needs to be highlighted, is section 532. Which has been added. As per the said section, all trials, inquiries, proceedings, recording of evidence, examination of parties, issuance, service, execution of summons, warrants and several other processes can now be done electronically. इसमें साहब आपके हैं section 64(2), section 73, so on and so forth. These are sweeping changes. Then expediting the processes and making time bound, which was the theme of the Honorable Chief Justice of India in the morning. This is also now encapsulated in section 336 of the Sanhita. तो साहब ये सारी चीज़ें हैं, और आपको अगर ये सारी इनमें मैं ले जाऊं तो ये सारा का सारा यहीं समाप्त हो जाएगा समय. So अति सर्वत्र वर्जयेत, they say everything should be in balance. तो यहीं आप लोगों से बहुत बहुत धन्यवाद, आप आए. Because you are the harbingers of the change. The Chief Justice in the morning said, it's very good to make a law, but it is for us, the true stakeholders, who will take this forward. So we are as much, rather it is our bounden duty to take it forward. Thank you so much, and sorry for exceeding the time, and sorry for partly boring you. Jai Hind.
बहुत बहुत आभार चेतन शर्मा जी का, ऑनरेबल लर्नेड एडिशनल सॉलिसिटर जनरल दिल्ली हाई कोर्ट. मैं निवेदन करूंगा दिल्ली की स्पेशल पुलिस कमिश्नर ट्रेनिंग छाया शर्मा जी से कि वे इस मौके पर अपने उद्गार, अपने अनुभव जो है हम सबके सामने रखें. छाया जी.
Respected Honorable Justice Narasimha, Judge Supreme Court of India, respected Justice Sanjay Karol, Judge Supreme Court of India, respected Justice Madam Rekha Palli, Judge High Court of India, Shri Chetan Sharma ji, Learned Additional Solicitor General, Delhi High Court, Rajiv Mani sir, and Anju Rathi ma'am. All the dignitaries that are present in the hall, and my dear colleagues from Delhi Police, and everybody else, I'm very honored to be part of this august gathering, representing my CP today, as he was forced to be in a different session. It is my honor to address this valedictory session. For the simple reason that I joined training as special CP training only 3 months back, so I mean, actually in January. And the first task that I was given was to teach Delhi Police the new laws. So I attended that Home Secretary's meeting on 25th January in the morning, and then we came to know that this thing is going to come. And CP sir had already carved out this thing, and he said, you will be holding the baton, and you will be leading the Delhi police through the change that the new laws will be bringing, and I would like that through training academy and through refresher courses, we'll make sure that we teach. So first was a resistance to change, which was within me. I had to relearn 25 years of learning a law and then unlearning and then the new learning. So pehle mujhe ye dar laga ki how do I overcome my fears? And then when I came that, then came the thing that how the smallest unit in my police station, the head constable, the ASI who's investigating, shall be able to overcome this fear, the resistance to change, and effectively be part of the transition from the old laws to the new laws. There is a lot of change in the BNSS as far as the police is concerned. So there is a lot of process transformation that learning that has to be part of the learning. And nobody at, sometimes at the last 10 years of your service wants to relearn and then go all over again. But then this is the fate, and we'll have to accept this. The best part that motivated me to be part of this was when Sir addressed all of us and said कि देखो ये दंड से न्याय की ओर जाने का रास्ता है. So a lot of time in the morning से अभी तक repeat हो चुका होगा. बट पुलिस की नज़रिए से देखें तो ये बहुत ज़रूरी है कि हम एक जो लॉज को इम्प्लीमेंट करते हैं, द रूल ऑफ लॉ को, हम दंड से न्याय की ओर ले जा रहे हैं. और न्याय सिर्फ विक्टिम के लिए नहीं, उनकी फैमिलीज़ के लिए, जो अक्यूज्ड हैं उनके फैमिली के लिए. लाइक अभी सर ने बताया कि सो मेनी orders, whether of the Supreme Court or the High Court or the other orders, which were part of just orders and we were following them, but not part of the statute, have been incorporated. And because of that incorporation, now it has become a mandatory thing. So these are very nice things that have come in. And because of this, that once one starts to read the new laws and starts imbibing that what change has come, and slowly starts interpreting it, how it is citizen-friendly, how it is female-friendly, how it is victim-friendly, how it is bringing the justice and to the doorstep of the person. So when you start looking at it from those perspectives, learning becomes easy. And the endeavor at the Delhi Police Training Institute for us has been that we have tried to make our learning that simple, and in that way we have tried to motivate people to learn the new laws. Sir, I would like to take this opportunity to let you know that we started our training programs from 5th of February. And up till now, we have completed 10,000 IOs, like investigating officers who are frontline officers. They have been trained 5-day courses. And each of the BNS, BNSS, and the Bharatiya Sakshya Adhiniyam have been taught to them. The change part, and what is really essential for them. So this will end the first phase of training for us. The second phase, of course, we will start with the potential IOs. Like an IO may be posted in the armed police or traffic who's not doing day-to-day investigation. So we will be addressing those people and their needs, and we are doing training for them. So this is not for the new recruits. This is for people who are already in service. And one by one, we are going to touch base with all of these people and make sure that they are in sync with the new laws. So having said that, I feel that the soul of the 3 new laws will be to protect all the rights given to the Indian citizens by the Constitution, and their purpose will not be, as I said, to punish, but to give justice. Now, these 3 laws within the Indian thought process, as my previous speaker has very beautifully brought out, will bring a huge change in the criminal justice system. The law expands the definition of documents in this. Like for us, as police officers, digital evidence, its collection, its saving the integrity of the digital evidence, how we will save it, what will be our hashtag values, what will be the primary evidence, what will be the secondary evidence, how will we produce it in court, how during charge sheet we have to stitch this digital evidence to show that the integrity of chain of command is not broken. So all these things we have to then teach to our staff, because first we have to learn and understand through the law that what has been given, and maybe as the laws get rolled out and as we start off with our new journey from 1st of July, we will understand more changes, and we may have to bring in more changes in the process and the learning. But as of now, whatever is given in the Sanhitas and the Adhiniyams, we have tried to incorporate that in our learning. There has been effort in the law to digitize the entire process, right from the FIR to the case diary to charge sheet and to the final judgment. Already we were having CCTNS, then we were having this ICGS system also. We were already integrating the FIR, we were giving a printed FIR. But now we will also have to integrate the whole thing differently, because now the entire law has changed. So there are, NCRB is working on patches and giving us the new things. So there will be a new CCTNS 2.0 which will come, ICGS 2.0 will come, which will then see how we will be able to save, or maybe on cloud, maybe on an independent primary server, this digital evidence, which maybe then when the courts during trial want to see it, will have to have access through a different process. So all this needs to be thought out still, and probably NCRB and people in MHA are already working on it. And as we are told, there is a lot of things which will come. Maybe some new apps will be introduced, where apps will be given to police officers to collect digital evidence from the field, record when a forensic expert has come to the spot to pick up evidence, even that has to be videographed. So for all those things, we need this digital gadgets. It has to be a clean digital gadget. I cannot start using my cell phone, which may have 10 other apps. So to maintain the integrity, we will have to give them standalone apps. So a lot of technical and lot of infrastructure investment is required. And I'm sure the timeline that has been given in most of the sections, where they say that there is a timeline of 5 years or 1 year or 2 years, or till the preparation of the state government to provide this infrastructure, they can still find a way out. But however, there are certain sections we went through, and we realized that the word they have used is shall, and they have not given any proviso for any kind of a leeway where we can say, oh, we can wait for 5 years and we can do it later. So everything has to be done fast, pronto, and I think all government machinery, especially the legal system, the legal divisions, the law ministry and the MHA are all trying to make it as smooth as possible for all of us. So sir, videography has been made very compulsory at the time of search and seizure, which will be not only part of the case, but will also help in not implicating innocent citizens. Without such recording by police, no charge sheet will be valid. So again, we are moving towards an era where digitization helps us to become more fair and independent. The visit of the forensic team is being made compulsory on the crime scene, especially those with a provision of 7 years. So already we had forensic assistants and experts in Delhi police. They're of course on contractual basis. They were not appearing for the evidences in court, but they were helping the police in lifting of evidence. So some infrastructure is already available with us. All we need to do now is to make sure that how they will be from forensic assistants, the terminology will now have to shift to forensic experts. So who are forensic experts? That has also been defined. What kind of forensic experts do we need? And the number now, because now with motor vehicle thefts having gone from 3 years to 7 years, and fatal accidents also having gone from 3 years to 7 years, what happens? Now all these cases will also add burden to the forensic assistant or the expert, who has to now mandatorily visit the spot. So we'll have to find ways and means of countering that. Either we increase the number of forensic experts available, and then ensure that this thing is delivered. So all those things we have already in the process of projecting. Delhi police has projected its demand for the number of forensic experts based on the 2023 crime figures, and what the new law envisages in terms of the number of years of punishment and the details thereof. the concept of zero FIR, we used to think that, okay, this is something different, we used to have it, did not have it, but somehow the statute has now incorporated it for the first time for the convenience of citizens. With this initiative, they have given a provision where the citizens will be able to lodge a complaint even outside the area of their police station jurisdiction. Now, there will be some provisos, there will be some ways and means and how we will make it effective on ground, but as of now, we know that the statute is providing for it. The provision of EFIR added for the first time. Every district and police station will designate an officer who will officially inform the family of the arrested person about his online arrest and in person. So we already had EFI registrations for thefts, MB thefts, and for, say, house thefts. However, now it is being part of the statute, we will have to make a number of changes in our methodology, but we already have a little bit of practice here, therefore it will make our life easier. The change will be easier for us in this area. The provision that there will be an officer who, in each district who will be informing. Presently, there used to be a board in front of the DCP's office. Everybody could go and see. But now, mandatorily, they have to have an officer of the rank of an ASI who shall inform the family members. So a lot of transparency has been brought into the system. It will be also mandatory for the police to give status of the complaint in 90 days, and thereafter, every 15 days to the complainant. So earlier it was not mandatory, but having brought it in the statute, it becomes mandatory, and the shall provision makes it, forces us to be compliant. The scope of summary trial has been increased in petty cases, which will definitely reduce the burden, especially in those crimes which are punishable, up to 3 years. And a time limit of 90 days is fixed for filing the supplementary charge sheet during trial, depending on a situation. And the courts can, of course, give us a little more leeway with permission for 90 more days. All of you must be aware about the timeframes that have been set for the various functions of the courts. Like, for example, uploading of the judgment, framing of the charge, supply of the police report, committal of cases, filing discharge application. So when you see the timelines, it's very heartening to know that now there is a compulsion on quick delivery system, time-bound delivery system. So now one can go to the higher court and say that this timeline was probably not followed. And then the delivery and the uploading of judgments, complaint cases, all these timelines will ensure better justice delivery. The government also has to decide on permissions, in cases of government servants or civil servants, when they would withhold permission in case of trial. If they don't give within 120 days, it will be treated as deemed permission. So again, the trial can start. Similarly, in the case of fugitives, like the proclaimed offenders, earlier what was happening was if the proclaimed offender was not present, the case would keep hanging. Now, he will be prosecuted even if he is not present. So all this you already know probably. The provision of death penalty has also been made in case of crimes with girls below 18 years of age, mob lynching. All three provisions of 7 years in jail, life imprisonment, capital punishment have been made. I think this dichotomy which existed about 16 years of or less or 18 years, I'm very happy that now the law has become very clear. Any girl child less than 18 years is a minor, and anybody above 18 is a major. So having that clarity will really help in our execution of the law. A historic decision which I think the lawmakers have taken was there was earlier no definition of terrorism. Like we had things like UAPA and other things, but they were part of a special law. But now we're talking of these special laws like MACOCA, like organized crime, like terrorism being specifically defined in the proper main statute. And now crimes like armed insurgency, subversive activities, separatism, challenging the unity and sovereignty and integrity of India have been clearly defined. Now this will definitely make the law more strong and give it more teeth. Finally, in this law, special care has been taken for women and children. For the first time, I see that there's a whole separate chapter which has been dedicated, and details have been looked into and very clearly defined. Separate scenarios have been defined in certain cases where women were deceived and false promises of marriages were given, and on what false promises are there. So those have also been clearly defined. So those, finer nuances in which the law has gone into, it has been ensured that criminals engaging in these kind of acts are punished, and police cannot misuse their powers anymore. So no, on the one hand, laws like sedition, etc. have been repealed. On the other hand, provision of punishment for heinous cases like the exploiting of women, cheating, mob lynching, and even snatching. Like every time we would be snatching, robbery hai, snatching hai, chori hai. So now this dysfunction has gone. Very clearly there is a section which defines snatching, and clearly we are able to make crackdown on crime and criminals more properly. The fact that the statute clearly mentions and differentiates between organized crime and petty organized crime, I'm particularly very happy, because there were times when we were finding it very difficult to handle it because they would not fit in the cases of Makoka, but we would know that it is an organized crime, maybe at a lower level. So with this, I would like to close my address, and thank you very much for the attention. I'm particularly thankful once again to the Law Ministry for inviting the Delhi Police. Very few times police is allowed to come and make their point of view. So thank you very much.
बहुत बहुत आभार छाया जी का, स्पेशल कमिश्नर ऑफ पुलिस ट्रेनिंग, दिल्ली पुलिस. Ladies and gentlemen, in this valedictory session, we also have on the dais the Judge, Delhi High Court, Honorable Mrs. Justice Rekha Palli जी. मैं उनसे निवेदन करूंगा कि वो इस मौके पर अपने एड्रेस के लिए और अपने संबोधन से हम सब का मार्गदर्शन करें. Mrs. Justice Rekha Palli जी.
Justice P.S. Narasimha, Justice Sanjay Karol, esteemed judges of the Supreme Court, my esteemed colleague in the Justice C.D. Singh, Mr. Chetan Sharma, the learned Additional Solicitor General of India, Ms. Chaya Sharma, Special Commissioner Police, Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Dr. Anju Rathi Rana, Additional Secretary, Department of Legal Affairs. The young students sitting there, I'll address you first, because I can see a lot of students with the ties there. Oh, they are I don't know. I thought they looked like students. Oh, they are all sub-inspectors. But they're students anyway, so they're learning now. Not law students, though. Yes. Ladies in the standing council, Mr. Adish Agarwal also I saw in the... Yes, ladies and gentlemen, a very good evening to all. I must begin by expressing my gratitude to the Department of Legal Affairs for giving me this opportunity to be a part of the first of the series of conferences which they propose to hold, I am told, and all across the country to create awareness amongst all stakeholders of the crucial reforms which these three acts will usher in. The criminal law of a nation reflects the values and beliefs of the citizens, thereby depicting the collective their consciousness. So what happens is, whatever is the law, so law of the nation is actually, what is it? It is the common, that's what we learned in sociology also. It is the common conscience of its community, embodying the collective moral compass of the nation. The launch of this branch of law necessarily has to keep evolving along with societal changes. Criminal law, therefore, cannot be and should not remain static. As Roscoe Pound, the American legal scholar, said, law must be stable, but it must not stand still. So there is a very deep meaning to it. It must be stable, but it must keep changing with the timings. For over a century, IPC, CRPC, and Indian Evidence Acts, which we have all been reading in this college, formed the bedrock of criminal law jurisprudence in our country. They were, however, entrenched with colonial legacy, both in the language, and the substance of the provisions contained therein. Over the years, as the world's largest democracy, we have moved from a society that functioned on the principle of retaliatory justice since an eye for an eye. That was the scope, That is what was addressed by the previous speaker also, by a society which was based on reformatory justice, which acknowledges that an accused is also capable of being reformed. A system where victims are not going to be mere bystanders, but will be recognized as active stakeholders in a trial. This transformation underscores a broader societal understanding of justice, emphasizing the importance of ensuring that victims are heard and supported throughout the legal process. While regular amendments in the Act were being carried out from time to time, a piecemeal approach was leading to confusion for everyone. Like we just heard Ms. Chaya Sharma said, because what was happening were amendments were coming, judgments were coming, but there was no clarity. That is why it was the need of the hour to have a complete overhaul. That's what I would say. It was actually really needed. The 3 new acts meticulously crystallized the developments brought over the years as a result of the joint efforts of the legislature, executive through its various parliamentary committees, judiciary, and also the academicians. The enactment of these acts, if I may say, is a loud message to the world that we will be governed only by those laws which meet the aspirations of our citizens and not by earlier law. These acts logically reorganize the provisions, resulting into a more user-friendly legal framework. For instance, in order to bring clarity, definitions under the acts have been arranged alphabetically, which was not there earlier. Earlier, if you would take out any of the acts, you will find one definition there, another. You didn't know whether it is subsection 2I or 2X. Now it is most of these acts logically, very alphabetically arrange them. So redundant provisions have been deleted. This change reflects a fundamental understanding that individuals are more likely to adhere to law in the language and form they can easily understand. So that is the purpose of these acts, that now it has been made simpler, more clarity has come in the punishment, and everything is more clearer. In this spirit, terms like jury, Her Majesty's government, Her Majesty's dominion, they have all been which all reflect the British legacy, have been deleted from each of these acts. There are many subtle and not so subtle changes which will gradually come to light once these acts come into force on 1st July 24. As we stand on the threshold of another information technology revolution, with artificial intelligence likely to become a part of our daily lives in the very near future, our laws could not have ignored the technological advancement. These acts, therefore, not only provide for digitization of the procedure wherever possible, but also introduce provisions for e-FIR and simultaneously also give legislative backing to the concept of zero FIR. They also provide for summons and warrants through electronic means, besides including provision for recording of confessions, TIPs, search, and seizure procedure. So my view is, I would say that integration of the rapidly growing technological advancements in these acts will definitely streamline the justice delivery system, enhance its efficiency, and ensure transparency, instilling greater public confidence in the criminal justice system. In a similar vein, the new acts realize the importance of gender equality, and therefore the definition of gender under these acts includes the transgender person. This is in tune with the Supreme Court's landmark decision in National Legal Services Authority judgment in 2014. In contrast, I was very surprised to know that in contrast, under the CRPC, something as basic as summons could only be served on an adult male member. The new act changes it to any adult member. So I will say the new acts also say kudos to the general equality. They realize that earlier it was like a lady would not, that was the CRPC provision. Notably, the act provides additional rights to all stakeholders of a criminal trial, the accused, victims, and the witnesses. Mr. Chetan Sharma had highlighted a lot about how victims will now be heard. So I will say that insofar as the accused is concerned, in all complaint cases, now the magistrate must provide the accused person with an opportunity of being heard at a pre-cognizant stage, that is prior to issuance of process. This, in my view, will be a game changer, because we had so much litigation on this that the process has started without even the accused being heard or at least being told what is there against him. There is another very new concept which has been added. A new punishment of community service has also been added. It will be an effective alternative to incarceration and will also help in tackling the problem of overcrowding in prisons. Community service was being done by high courts, through judgments it was coming, but now it has been made a part of the acts itself. In tune with the principle that victims are not passive bystanders but active stakeholders, the police will now be under an obligation to inform the victim or informant of the progress of the investigation, including by way of electronic communication. Further, the victims will also have the right to ask for all documents which were earlier being given only to the accused persons. Similarly, to protect the interests of witnesses, an obligation has been cast on each state to come up with a state witness protection scheme, which was also being done earlier only through judgments, through decisions. During the day-long technical sessions, you have already heard experts shed light on various crucial aspects of these new criminal acts, and Ms. Chaya Sharma has given us some practical tips on how they are training our police officers how to handle these cases which will come from July onward. I therefore conclude by congratulating the Department of Legal Affairs for holding this conference, which will, I am sure, go a long way in creating awareness and developing an unbiased understanding of the comprehensive changes that are being introduced by these three acts. There were a lot of biases. We were very, no doubt, we will also have to change our mindset. We were so all used to seeing Hindi movies, Dafa 302 or 498 or 420. You can't call your friend 420 now. You'll have to look. But that is why there were some biases that it will become very difficult. But that conferences like this will help us understand that this is changing for the betterment. Things are improving. Things are becoming more transparent. Efficiency is going to improve. So I will congratulate. I'm sure the successful culmination of this conference will send a clear message to one and all that the legislature and the executive are committed to fully implement the new and modern criminal justice system being introduced through these acts. Thank you and Jai Hind.
बहुत बहुत आभार ऑनरेबल मिसेस जस्टिस रेखा पाली जी, ऑनरेबल जज दिल्ली हाई कोर्ट, उनके एड्रेस के लिए। दिव्य सज्जनों, अब मैं निवेदन करूंगा माननीय न्यायमूर्ति सर्वोच्च न्यायालय ऑनरेबल मिस्टर जस्टिस संजय करोल जी से कि वे इस अवसर पर अपने संबोधन से हम सबका मार्गदर्शन करें।
On the dais, my esteemed colleague, Honorable Justice Narasimha, Ms. Rekha Palli, Ms. Chaya Sharma, Dr. Rajiv Mani, Mr. Chetan Sharma, Dr. Anju Rathirana. Of the dais, my colleague, Mr. C.D. Singh. Ladies and gentlemen, when Dr. Mani approached me for being part of this August gathering, I was informed that people from, rather all stakeholders in the justice delivery system from all India would be here. Hence, it is indeed a pleasure to be speaking at the present conference, which was happening at the pivotal junction in the realm of the Indian criminal jurisprudence, with the implementation of the 3 new codes being on the horizon. Dr. Mani, I would definitely like to pat you on the back with the enactment of these 3 codes. But really, that's not the line which I am going to toe. I'm going to bring forth the harsh realities at the ground level. Ms. Chaya mentioned that either Ms. Chaya or Mr. Chetan Sharma mentioned that the terminology or the nomenclature of the judicial officers stands changed. Yes, that's a very welcome change. The Metropolitan Magistrate is no longer there in the statute. I take it as endeavor of bridging the gap between the metro-centric approach which Delhi has or metropolitan cities have and the other rural urban India. And that is my stream of thought which I wish to proceed to present. It is imperative that we reflect on our journey thus far and chart the course for a more efficient and just criminal legal framework. We must recall the words of Justice Bhagwati way back in the year 1980. And those who have come from the India would definitely agree with me to say as to whether things have changed thus far or not. And I quote what Justice Bhagwati said. Today, unfortunately, in our country, the poor are priced out of the judicial system, and the result that they are losing faith in the capacity of our legal system to bring about changes in their life conditions and to deliver justice to them. The poor in their contact with the legal system have always been on the wrong side of the line. They have always come across law for the poor rather than law of the poor. That faith would these people have in our justice system of justice administration system is what the query was posed by His Lordship in the year 1980. Have we really progressed since then? Well, in some ways you can say that bringing in with these 3 new statutes, you have taken a big step, undoubtedly. But what does the National Judicial Data Grid tell us? That there are 3 lakh pending criminal cases in different courts of India. And therefore, today I stand here before you, not only as a judge of the Supreme Court of India, but also as a concerned citizen, deeply committed to addressing this pressing issue of pendency in different courts. The cornerstone of any effective justice delivery lies in its ability to deliver timely justice to all. Well, this is the mandate of the Constitution, as has been held in Husainara Khatun. The concept of speedy trial is read into Article 21 as an essential part of the fundamental right to life and liberty granted and preserved under our Constitution. The learned ASG Bihar is here. Khatun came from Bihar. I come from Bihar. And I'm not sure how much have changed at the ground reality. I'm sure in the hinterland, the position is no better, so to say. But nonetheless, there is hope, and the hope stems out from these 3 new legislations. The inadequacy of financial or administrative capabilities is not a ground to deny the right to speedy trial. Mr. Mani, this is something which you must take note of. Because at the ground level, do we really have the infrastructure to implement the new laws of which we have been speaking since morning? Some introspection definitely needs to be carried out. Adding further, let us delve into the heart of the matter by examining the data relating to pendency, detailed-wise. Delay is one of the most potent roadblocks in the realization of this right. That statement, I'm sure no one can dispute. In the Supreme Court, there are at least 17,000 criminal cases which are pending for more than 3 years. Across India, there are at least 2.5 times more number of cases than civil cases before the Sessions Court. And another alarming statistic, as pointed out by the Law Commission in its 239th report, is that in some states, disposal of criminal cases is lower than the institution of new cases, which results in the burden of the judiciary as an institution being increased year by year, and more so now with the digital platform which we have, an online platform which we have. An expedition into the NJDG data unearthed the following reasons, amongst others, for delay in criminal trials. 1, difficulty in securing presence of important witnesses. 2, one or more accused absconding and not appearing. 3, and this goes to my colleagues across the bar, at the bar, non-availability of counsels. 50 lakh cases are pending only because of non-availability of lawyers. And more than 1.5 crore cases are pending for delay reasons. It quotes delay reasons. What these reasons are, really, one doesn't really know. I'm sure, starting with this note of pessimistic note, I would say, the new statutes would bring in an era whereby at least the poor man, the man who cannot afford litigation, who is helpless, is rendered justice expeditiously. Certainly, it cannot be the case that these statutes are an old wine in a new bottle, but they represent the structural changes and reforms to be in sync with time, also accounting for future requirements of our society. The constructive legislative change has to be accompanied by conscious efforts on either side, that is amongst all the stakeholders, be it an investigator, the prosecutor, the lawyer, or the judge, to continue to tackle the other systematic problems which, while also seeking to translate the written word into a relative reality. The 3 codes, I must confess, they are tongue twisters, really. Bharatiya Nagarik Suraksha Sanhita, the object and purpose of the act is to address delay in delivery of justice, large pendency of cases in the courts, low level of uses of technology in legal system, delays in investigation system. The Act provides for the use of technology and forensic sciences in the investigation of crime and furnishing of lodging of information. I need not dilate any further. Much has been said both by Mr. Chetan Sharma and Ms. Chaya, as also my colleague Madam Palli. The Bharatiya Nyaya Sanhita, for the first time, community service has been added as a punishment for petty offences. And this is in furtherance of the reformative approach of punishment. Offences of sedition, which he mentioned, and attempt to commit suicide have been deleted, while organized crime has been accounted for. The Bharatiya Sakshya Adhiniyam is to keep pace with the advancement of the contemporary world. It addresses the admissibility of digital evidence. The scope of evidence has been broadened to encompass statements conveyed through electronic platforms. And therefore, we now see a whole change of use of technology under this new statute. Definitely, with the passage of time, we'll be able to adapt. We'll be able to first understand and then adapt to the procedures. Now, what is the way forward and the challenges to be tackled? As I have pointed out, statutory changes must be supplemented with adequate infrastructure and administrative capabilities. We must be cognizant of the fact that this is not the first remedial step being taken under these statutes must be supplemented with adequate infrastructure and administrative capabilities. I'm only reminded of one such endeavor by the ministry headed by Mr. Mani as a secretary. The fast track courts endeavor to deal with the criminal cases did not yield any results. It was not really, the government had to discontinue with this fast track courts endeavor. I am sure that you will ensure permanent solution and infrastructure which is permanent in nature. All stakeholders, second is all stakeholders must play their part. On the judicial side, across the bar and bench, private lawyers and prosecutors must work together for fostering a more efficient judicial process. While understanding the difficulties of lawyers in seeking repeated adjournments, balancing the interest of litigant is also necessary. Role of district judiciary in tackling pendency. I was told that a lot of district judges were to attend this conference. I'm not sure they are here or not. But repeatedly, we have been saying so in different capacities as Chief Justice, as judges in the Supreme Court, that the Supreme Court is overburdened with matters which ought to have been dealt with at their level, at the level of either CJM or the district judge, or for that matter, the constitutional courts, the high courts. So that is one, to be specific, is grant of bails and not preventing unnecessary delays therein. I would also highlight one major issue. Whenever any statute comes, is there any audit, legal audit carried out? The impact assessment which it is going to have on the existing infrastructure of the judiciary. Illustratively, I'll just, since 1980, we have seen number of statutes which have come. And there is no corresponding increase in the infrastructure at various levels. As Chief Justice, I had to look for judges who could be assigned the duties under the specific statutes, penal statutes. I do remember having faced with a problem where the present Prime Minister was attending a rally and there was a bomb blast. So to deal with this type of statute of national security, I had to look for an officer. I had to look for a person who could handle it. I had to look for a person where he could be placed. And I had to look for a person the witnesses to be there, the officer who could prosecute. Another issue which I would highlight is that every department, every state has got a litigation policy. If only that litigation policy is uniformly implemented with an earnest effort, the pendency would definitely be taken care of. We do find SLPs in the Supreme Court where even for a sum of ₹50, the appeals are preferred. We find where accused have been acquitted and appeals are being filed after 800 days to 2,000 days. Yes, 2,000 days. We have also find that some of the accused, there's a split trial. The accused have been convicted, but those who are absconding, well, that's the end of the matter for them. And there's none to prosecute them or pursue the matter any further. These are all issues which I am highlighting because with the use of technology, definitely the ministry, or for that matter, the state governments, or the prosecutors, or the people who are in charge, the stakeholders, can examine this and take it further. We have also seen cases where there are disputes between two private government organizations having an overtone of criminality. I am of the view that all these issues must be resolved at the earliest before bringing them to the court. The other imperative reforms I would highlight are these, that with the digital age, crimes are now becoming revolutionized. With data breaches, AI, and use of deep fakes becoming more common, hence implementation of the criminal justice system must be in tune with the technological advancements for tackling these issues head on. Punishment theory, reforming punishment and sentencing from a deterrent-based one to reformative is something to look at for the future. Madam Chaya mentioned about capital punishment. I look for times when the legislators would ponder over it and do away with it. That's my personal philosophy. Another lot of people are here. A lot of lawyers are here. I would say that you can do great service in taking up matters pro bono. And the legal services movement or the legal aid movement must be carried forward with greater vigor and at every level. The road to a more efficient and equitable criminal justice system is fraught with challenges, but it is a journey that we must undertake with unwavering resolve. By fostering collaboration among all stakeholders, including the judiciary, bar associations, and government agencies, along with leveraging the power of legislation, we can pave the way for a brighter and more just future for the generations to come. Thank you very much. Jai Hind.
We are grateful to the Honorable Mr. Justice Sanjay Karolji. Honorable Judge Supreme Court of India for sharing his valuable thoughts in this valedictory session. Ladies and gentlemen, now this is time to request Honorable Mr. Justice P.S. Narasimha, Honorable Judge Supreme Court of India, to enlighten us with his valedictory address, please.
My esteemed colleague, Justice Sanjay Karol, Justice Rekha Palli, Chetan Sharma, Additional Solicitor General, Rajiv Mani's Secretary, Mr. Chaya Sharma, Anju Rathi ji, Justice Chandradani Singh, President of the Bar, many additional Solicitors Generals are here, senior counsels, advocates, students, everybody who is present here. I should start by thanking you for giving me this opportunity of giving the valedictory speech on this topic of administration of criminal justice. We are at the conclusion of this very, very important conference. I say it's important because these three acts imminently, directly, and immediately are going to affect our lives. When I say our lives, I mean lives of the citizens of this country who would transgress the law, lives of those officers who are sitting up there who are enforcing the law, and those of many of you who will be representing one of them before the court, and also people like us who are going to judge these laws. That's the reason that this conference becomes very, very important for us. I had online heard the Chief Justice speak at the inaugural function. He has referred to certain provisions of the three statutes and highlighted the drastic changes, which are welcome changes. And at the same time, the Attorney General spoke about how society is never a static phenomenon and that it keeps moving and law has to keep pace with it. I will deal with it with this short issue of how much we have kept pace with it. Law Minister had an interesting episodes to share with all of you. He spoke about history. To what extent we remember history? To what extent this history, which left scars on all of us, the history which told us how we enjoyed our freedom and which also told us how we lost it. And then the lessons that we learned, did we really learn the lessons or not is also a question. Did all this experience get translated into our laws? These are the things which we need to reflect upon when we make changes to our laws. These three acts have been repeatedly referred to as an act of decoloniality, that we are now shifting from what was given to us to that of what we want it to be. The transition is a very important transition. But then this belief and feeling that much of it is filled with coloniality, and that this is a process of decoloniality is something which we need to look at once more. We are all this second generation after the independence. When British introduced laws, our grandfathers, so to say, and their father, I think 2 generations worked under the laws made by the British. Even during that time, if we read history carefully, an Indian never bowed down. Even at a time when we had no exposure of the foreign education, with whatever we learned, that essentiality was kept within us, and wherever there was an opportunity, we interpreted our laws. There was recruitment even at that time into judiciary. There was recruitment even as there were also lawyers practicing. Wherever there was possible, I think that process of decoloniality was there, but it could not be given effect to. You would see much of it in the making of the Constitution and constitutional debates. After the debates, and when the Constitution was formed, and we started making our laws, we inherited many of those laws like that of IPC, and though CRPC was subsequently done, but had the vestiges of earlier. Wherever it was possible, through the process of interpretation, courts have done this act of decoloniality. I don't want to, we are on a Saturday evening, you had a very long session commencing from the morning, would not take you to all that. But this Supreme Court and many of the high courts also have done that process of examining the laws, reflecting on the laws in the context of how we as people look at it and whether it is suitable for us or not. And then we have interpreted it. Large number of judgments of the Supreme Court are to that effect. But those are precedents of the court. We have, over a period of time, kept carrying out amendments to the statutes, reforming them, adding provisions, deleting provisions from time to time. And over a period of time, perhaps some statutes lost its originality and there is something completely new. But amendments such as these, remaking of the entirety of the law, becomes very, very important for us because it takes into account what all happened and then puts them in a correct perspective. Considering the time, I'll just highlight just 2 ideas that I have instead of reading through the note that I had prepared. The first thing is about the process of reform, which I have told you through the decolonization that we have done. These reforms as a consequence of change of law are triggered by changes in the society and its thinking and reformation values, realization of failure of existing laws, the changes brought about by interpretation of courts. Large-scale legislative reforms can take shape in many ways. The repeal of laws that have no longer necessary, the creation of new laws to regulate areas that were either outside the law or were not adequately regulated, and by consolidation of laws into one simple theme, and to codification of the laws is the fourth one. This has been happening for a very long time. This Nyaya Sanhita, which replaces the IPC, the Nagarik Samhita, which replaces the CRPC, and Sakshya Adhiniyam, which replaces the Evidence Act, has endeavored to reform a large body of criminal laws in the country by substituting old laws and new ones. A continuous engagement with existing laws is an absolute must to prevent stagnation of laws or outdated laws. This exercise is important as a nation must constantly evaluate whether the laws are relevant, whether they account for the correct state of affairs and whether they are reflective and in aligned with our fundamental rights and directive principles. Such reforms provide an opportunity to undertake a systemic review of law. It is imperative to reform is not scattered or fragmented. That is what has happened. What we had was all fragmented amendments that we have brought about over a period of time, and we have consolidated them and we have brought in a new perspective to it. Added to this exercise that we have undertaken, I have a little concern. Once we enforce these laws, notify and enforce these laws, it's going to come into effect for the entirety of the country. How it is going to work in the remotest of the districts, as my brother has reformed, that he is referred to as he's saying that we don't need to talk about cities, we have to think about how it's going to work in the districts and the lowest of the places. How are you going to coordinate? Is there any methodology by which some kind of a hand-holding would happen? The new laws are being interpreted, used and implemented from time to time. We will have enormous variations from place to place. We will have open-ended provisions. We need to know what exactly could be the meaning. There could, over a period of time, be opinions of court interpreting certain provisions. Should the only method be that an aspect which is unclear, which is open-ended, is taken to the court examines the matter, be it a sessions court or even lower than that, and then goes to the High Court in revision and an appeal, and then comes to the court, Supreme Court. This is what has been happening all through. We have seen that reforms that were brought about to criminal statutes happened very episodically. It happened not less than about 8 years, 9 years, 10 years, 15 years. Look at the gap in between one reform and another reform. That 15-year or 10-year period, how did we cope? Laws which we thought were unjust, incorrect, could not have changed. Matters would not have been decided in courts over a period of time. So therefore, one would have ignored the violation of the commission of the offense. So even though the law is not changed, we turned a blind eye. Where the laws could not be changed, even though you knew that they were not just, right and correct, you had to suffer them. People had to suffer. Till the amendment came about, till a court changed it, even though a legislature had not done it, many instances where the Supreme Court had changed it. Is this the only method, is the thought that is occurring in my mind. What needs to be done is that legislation amendment in our country is slow. It's an admitted fact. So we need to have an alternative. There is an alternative scenario which we have seen in matters relating to, like for competition, IBC, where you had a regulator on a field. A regulator had 3 types of powers, is empowered by the parliament or the legislature. It would have telescoped into it the executive power, the legislative power, and also many a times judicial powers. These regulators make rules and give clarifications. More than anything, they are constantly watching the field. They are examining how the system is working. They are examining how the laws are operating. They are examining how the individuals are faced with difficulty but are not having any solutions immediately. Legislative powers granted to them in the form of making regulations and rules enable them to give guidelines. everything need not be amended by way of a statute. So that's an easier way, which I would suggest. Law Secretary is here. He would take note of this idea that I am sharing with all of you, that the times to come, once we start implementing these three laws, when they come into force, there will be a situation where open-endedness, the comparative problem of the provisions, interpretations will keep arising. Are we to wait till yet another amendment takes place, or can we have an institution, a body in the nature of a commission or a regulator? Most important aspect is we must have what is called institutional memory. What an institutional memory does is, it first depends upon a continuing body. You must have a continuing body to keep watch of the operation of the three statutes, keep watch of the feedback that you get from those who are affected by these laws, keep watch of those who are operating these laws, get a feedback from the court and feedback from the lawyers. Every year, you can have a review of this. And through the review of the process by which these laws are getting implemented, the necessary, to the extent possible, the necessary addition or clarification in the form of rules and regulations will be of immense value and help to all of us. Over and above that, if it needs a fundamental change of bringing about an amendment to the statute, then I think that process can take place. That way, as I recall Chief Justice saying, you need to have the will to take it forward. It's not merely, believe me, it's not merely that it is coloniality which has affected it. It depends upon the culture of working. It depends upon the attitude that we have. Every court had its own culture. The way we operated these acts, the way we take adjournments, the way we make our preparations, all this is part of the working of the statute. So those are the aspects that we must now highlight upon. Merely amending a statute will not make all the difference. We are thankful to the Parliament for having passed this statute. We will examine it. But then the working is completely depending on those who are implementing it, and of those implementing it, lawyers have the highest stake role. So therefore, how do you look at these statutes and what additional features that we develop and add on to make these statutes successful depends so much on us. So I think with these, I thank these 2 points, I thank the Law Ministry for giving me this opportunity, and I thank one and all. Thank you very much.
So we are grateful to Honorable Mr. Justice P.S. Narasimha, Honorable Judge Supreme Court of India, for his valedictory address. और अब मैं निवेदन करूंगा डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस में एडिशनल सेक्रेटरी डॉक्टर अंजू राठी राणा से कि आप सभी का आभार व्यक्त करने के लिए पधारे, वोट ऑफ थैंक्स के लिए पधारे।
धन्यवाद। धन्यवाद एक ऐसी प्रार्थना है जिसे देखा या छुआ नहीं जा सकता, इसे केवल हृदय से महसूस किया जा सकता है। Respected dignitaries, esteemed guests, ladies and gentlemen, it is with great pleasure and immense gratitude that I stand before you today, representing Ministry of Law and Justice, Department of Legal Affairs, to extend a heartfelt vote of thanks on this momentous occasion. We have been honored today to witness a rich tapestry of insights and perspectives from some of the most esteemed legal minds in our field, making this event truly exceptional. I express my deepest gratitude to Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Shri Arjun Ram Meghwal, Honorable Minister of State, Independent Charge of Ministry of Law and Justice, Honorable Mr. Justice P.S. Narasimha, Judge Supreme Court, Honorable Mr. Justice Sanjay Karol, Judge Supreme Court, Shri R. Venkatramani, Learned Attorney General for India, Honorable Ms. Justice Rekha Palli, Judge Delhi High Court, Shri Tushar Mehta, Learned Solicitor General of India, Shri S.K.G. Rahate, Secretary Department of Justice, Ms. Chaya Sharma, Special Commissioner, Delhi Police, Shri Chetan Sharma, Learned Additional Solicitor General, Delhi High Court, and our distinguished chairs, co-chairs, panelists, and moderators. Your expertise and passion have sparked a meaningful dialogue and enriched our understanding of the evolving landscape of criminal law and various important aspects of Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. We are grateful for your valuable contributions and for gracing us with your presence today. I extend my sincere gratitude to all the attendees, including law officers, panel counsels and advocates, the officers of Delhi Police, CBI, ED, National Investigation Agency, and other enforcement agencies. Thank you for your active participation and thoughtful contributions to the discussions. Your engagement has added tremendous value to the conference and made it a memorable experience for everyone involved. I extend my warm regards to our Honorable Minister for Law and Justice, Shri Arjun Ram Meghwal ji, and Union Law Secretary, Dr. Rajiv Mani, who personally supervised each and every activity of this conference and conceptualized the idea to make this event a grand success. I extend my sincere thanks to members of all the organizing committee and their heads, Shri R.S. Verma, Additional Secretary, Shrimati Sunita Anand, Joint Secretary and Legal Advisor, Shri Dhruv Kumar Singh, Chief Controller of Accounts, Shri Sher Singh Dagar, Joint Secretary and Legal Advisor, Shri Ajay Kumar Arora, Joint Secretary and Legal Advisor, officers, staff, and volunteers from the Department of Legal Affairs who have left no stone unturned and burned their midnight oil in organizing this event. I also extend my gratitude to the additional legal advisors and deputy legal advisor of our department, in charge litigation, Central Agency Section Supreme Court and Delhi High Court, and the young professionals for their unwavering support in making this event a grand success. I also extend a special word of thanks to Easternberg Company, Indian Law Institute, Delhi, Dr. Ambedkar International Centre, NBCC, and Zest Hospitality for their invaluable contribution to this event. I also extend my heartfelt gratitude to our anchor, Shri Janendra Singh, for his commendable presentation skills. I also extend my sincere thanks to all the audience members, faculty and students from various law schools who have taken their time to join us today. Your presence here is a testament to your commitment to the ideals of our Constitution and your love for our beloved nation. Last but not the least, I also extend my thanks and gratitude to all those whose name I could not mention due to time constraints. My sincere apologies for that. I hope that the conference will provide a major impetus to future legal reforms in our country. Once again, I thank all for your contributions in making this conference a resounding success. Thank you all. Jai Hind, Jai Bharat.
थैंक यू डॉक्टर अंजू राठी राणा जी, आपका भी। और दिव्य सज्जन, इस कॉन्फ्रेंस वैलिडिक्टरी सेशन के अंत में, आखिर में आइए हम सब अपने अपने स्थान पर खड़े हों राष्ट्रगान के लिए, नेशनल एंथम के लिए। राष्ट्रगान प्लीज।
जन गण मन अधिनायक जय हे भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा, विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा, तव शुभ नामे जागे तव तव शुभ आशीष मांगे, गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
देवर सज्जनों, आप सब सुबह से जिस ऊर्जा के साथ इस इवेंट का हिस्सा रहे, एक बार अपने लिए भी ज़रूर तालियां बजाइएगा आप लोग, क्योंकि आप सब ने बहुत ही पेशेंस के साथ, बहुत कमिटमेंट, डेडिकेशन के साथ, एक इंक्विजिटिवनेस, जानने की इच्छा के साथ आप इससे जुड़े, आखिर तक जुड़े रहे। बहुत बहुत धन्यवाद। कॉन्फ्रेंस ऑन इंडियाज़ प्रोग्रेसिव पाथ इन द एडमिनिस्ट्रेशन ऑफ क्रिमिनल जस्टिस सिस्टम, अब यहीं आज का ये कॉन्फ्रेंस यहीं विराम लेता है, लेकिन इस तरह की एक्टिविटीज़ आगे भी होती रहेंगी। हम बहुत बहुत आभारी हैं आज के इस आयोजन में, वैलेडिक्टरी सेशन में पधारे सभी अतिथियों का, आप सभी का भी बहुत बहुत धन्यवाद, बहुत बहुत आभार डिपार्टमेंट ऑफ लीगल अफेयर्स, मिनिस्ट्री ऑफ लॉ एंड जस्टिस की तरफ से। और आप सभी के लिए हमारी बहुत सारी बेस्ट विशेज़ हैं, गुड विशेज़ हैं। आई विल रिक्वेस्ट ऑल ऑफ यू टू प्लीज़ ज्वाइन फॉर अ कप ऑफ टी, हाई टी, जहाँ लंच की व्यवस्था जिस रूप में थी, अलग अलग फॉयर में लेके या VIP लाउंज में, वैसे ही आप उन्हीं जगहों पर आपके लिए व्यवस्था की गई है। तो प्लीज़ हाई टी के लिए आप सभी ज्वाइन करें। आप सबका बहुत बहुत धन्यवाद, बहुत सारी शुभकामनाएं, मंगल कामनाएं आप सभी के लिए। देवी सूचना।